Kia mau kei te tuturu whakamaua, kia tīna, haumi e hui e, ai ki e. Just welcoming you here and starting with Karakia before I hand over to the chair. Karakia asks us to be present. We centred on the kaupapa and committed to the best possible outcome. I'll now hand it over to our chair to take us through the day.
Good morning, everybody. My name's Trevor Robinson. I'm the chair of this hearing panel. We have a large group present here. I'll ask each of the commissioners to introduce themselves one after the other, but my background is that I'm a lawyer, currently based in Hawke's Bay, but lived in Wellington for a number of years. Starting Commissioner Faulkner.
I'm Rawiri Faulkner, planning consultant based here in Wellington.
Heike Lutz, heritage consultant based in Auckland.
Hi, Robert Schofield, a planning consultant based in Wellington for a few decades now.
I'm Jane Black. I specialise in urban planning and design. I'm based in Wellington and have been here for many years.
Good morning, everybody. David McMahon, planning practitioner and independent commissioner, based in Wellington these days, previously in Christchurch.
Kia ora, Liz Burge, also planning consultant and independent hearings commissioner, and I'm based in the Wairarapa.
Kia ora, Lindsay Daish. I'm a planner as well, also based in Wellington. I've been working here for over 30 years.
Thank you, team. I should say that this is not, although this is the start of the formal part of the proceedings, we were welcomed formally onto Pipitea Marae by Mr. Hunter on behalf of Taranaki Whanui and his whānau. Thank you to them. That was yesterday afternoon, and following that the panel took a site visit because of its relevance. We rode the Johnsonville train up to Johnsonville. Mr. Taylor of the Community Association had asked us to take a site visit in the Johnsonville area, and we he's identified 3 routes, and we took one of those routes walking through the underpass under the motorway and up the hill on the other side and back. We'll undertake a visit of the other 2 site routes, probably a convenient afternoon when we happen to finish early, if there are any of those. I should say also that as a result of our pouring through the evidence of submitters and the rebuttal evidence of counsel, we've identified some further conflicts that we need to disclose. So I have updated the conflicts register with effect from today. It's now on the website. Well, it will be soon. I sent it to our hearing coordinator about half an hour ago. The changes from the previous version are highlighted, so you don't need to compare it line by line, but we'll replace it with a clean version in a few days. That was only for convenience. One of the issues that I need to note before we start is that as per the conflicts register, a number of the conflicts translate into specific issues in stream 1 where commissioners will not be taking part in the proceedings. I'm not going to ask them to step outside the door. They'll be going backwards and forwards, like sitting in the naughty chair. But I do note what those conflicts are so that everybody's aware of them. And I've asked the commissioners to be mindful and stay in their box and out of their conflict zone, although they so Commissioner Schofield has conflicts in relation to Transpower, corrections, and a couple of Offamiscal employees who are appearing, Mr. Dunn and the representative of the Tawa Community Board. Commissioner Black has conflict about the strategic objectives, won't be taking part in that part of stream 1. Mr. Daish has a conflict about airport noise, Centreport and Meridian. And Commissioner McMahon has a conflict over issues related to the university and the hospital. The flurry of minutes indicates that the first item of business that we're going to first is procedural in nature, related to the allocation of topics to the ISPP process and whether the hearing panel has a discretion to alter that allocation, either to shift matters into the ISPP or out of it. A number of parties have filed submissions. I've indicated we're going to hear those parties, but starting with Counsel for the Council. That's our first item of business. Once we've dealt with that, I'll ask any if anyone else has any procedural items that we need to address before starting into stream one proper with the presentation of the Council's Section 42A report. First of all, I should get a clear fix on who is present with an interest in the ISPP procedural issue. Obviously, Mr. Wellington for the Council, Mr. Ballinger for WCCT. Is it Dr. Keir?
Yes.
I see Mr. Henchley is on the line. Looking around. Hopefully you can hear me, Mr. Henchley. Are you are you proposing to talk to us on that? You're right. Anyone else? Ms. Wong.
Yeah.
Thank you.
Ms. Dewar for Wellington Airport, International Airport.
Ewan, was that Ewan?
Dewar, D-E-W-A-R, as in the whiskey. And I'm here with Miss Lester from the...
Right, for a while. Thank you. Mr. Whittington, would you care to, can I just emphasise the point I previously made with everyone having pre-circulated legal submissions? I expect Council and lay parties to be relatively brief. I want to focus on our questions of you rather than what you have to say to us.
In that light, I'm happy to simply turn over for questions. I don't know that there's anything I can say to elaborate on the position that I put in the submissions. Happy simply to be questioned. I can introduce the topic if you like for 3 or 4 minutes.
Well, why don't we have 3 or 4 minutes to get our collective heads around what we're talking about?
Well, perhaps I can start by just indicating here on my reading of the various submissions, there is agreement or disagreement. And first question is, do you have jurisdiction to determine the issue? And I don't think any party suggests that you don't. You have the power to determine. Sorry, I should have this right there. Just to, so the first question is, do you have jurisdiction to even determine this procedural question? I don't think there's any doubt that you do have that power. You then turn to the procedural question, and there appears to be some agreement between the various parties that, or at least between, on my reading of it, the airport, the council, and the Retirement Village Association and Ryman's, that if there is an issue, it's not one that can be solved by you reallocating provisions. And perhaps it's worth just alighting on this question of reallocation, because a theme of my written submissions, and one that I've thought about since, is I don't know that it's helpful to talk about this issue in terms of reallocation. I think it's an illusion created by the fact that we have 2 separate instruments, and there seems to be agreement between at least the airport and the council. and I think even the Wellington Charitable Trust, that there are two separate instruments before you, and this illusion of reallocation being an available option is created by the fact that they sit in one document. But in reality, and as I said in my submissions, you should treat them as distinct. So the question of whether you can reallocate is one that, as I say, is almost an illusory one. Nobody thinks that getting to the end of the process and finding that certain provisions have gone through the wrong process is a particularly good outcome. It raises the prospect of judicial review or people potentially seeking to appeal provisions which went through the IPI to the Environment Court, where the Environment Court could potentially determine whether it has jurisdiction on the basis that while it did go through the IPI process, in fact, it should be treated as having gone through a Schedule 1 process, and therefore the appeal rights that the Resource Management Act provides apply to that provision. And that is something that could perhaps be seen as a possibility, because while the procedures, the ISPP and the Schedule 1 processes are distinct, they overlap to a significant degree. And you'll be aware, of course, that the ISPP process in the Act is set out in Part 6 of Schedule 1 by reference to the provisions in Part 1 of Schedule 1 that apply. The only realistic differences are that you can allow cross-examination in relation to provisions within the ISPP, but you cannot Schedule 1, and of course the question at the end of appeal rights.
So what was the second point?
The appeal rights. They're the two practical differences in my submission between the two processes. Can allow cross-examination.
That we have the right to make recommendations out of scope on ISPP matters.
Well, on that, I don't disagree with part of Wellington Airport's submission that your powers have to sit within the phrase on the IPI. What I disagree with them on is what the IPI is, because as I read Wiles' submission, it is saying that if there is a provision which does not fit within Section 80E, it is not part of the IPI, regardless of whether it's been notified as such or not. And I don't agree with that. Until a court of competent jurisdiction comes along and says that a provision has been wrongly included in the IPI, the notified version of the IPI governs the situation.
Now, first question I had by way of clarification, and maybe you want to defer this to Mr. McCutcheon. I was going to ask one of you. First, I should also say I apologise for asking you initially to address the merits and then finding that wasn't a very helpful idea, since there were other potential issues that would need to be addressed. But the question I had relates to the spatial allocation of plan provisions. Understand the argument that every provision in the plan has a neat little marker that says it's either first schedule or ISPP. But what about the maps? What about the spatial allocation of the plan provisions to the areas on the ground? So I'm thinking, for instance, of Weil. I think Weil's concern is about the application of natural hazard provisions to the airport. The overlay, the natural hazard overlay, applies over the airport land. Where does it say that that's an ISPP provision, the map, or it's not, or does it say it at all? And if so, how do you allocate it?
Well, without bringing up the maps, and perhaps I do need to defer to Mr. McCutcheon, I would say that the way that the maps fight, for want of another word, is through the provisions. They set a framework, and the provisions which are stated in words which have allocated ISPP or allocated Schedule 1 fight based on what the maps say.
So, for instance, in the wild category, because the provisions related to the natural hazard overlay are ISPP provisions, or are classified as such, so does the map showing where that
Fights on the airport land, yes.
Does that include, it shows an area of rural land?
Yes. And I say that because the way that the natural hazard provisions were drafted is to apply to all zones. Now, to the extent that those provisions support the intensification policies of the IPI, EPSUD, those provisions that apply to all zones are able to, and have been determined by the council, to go through the IPSPP.
Where does the plan say that?
The plan says that on the provisions that relate to natural hazards.
Is there any annotation on the maps?
Well, going back one answer, I say they don't have to. The fact that it says that it applies to
well, going back a step, your answer is no, but they don't have to.
Yes.
Now,
and perhaps just to answer your question more fully, because this is perhaps starting to engage on the question of whether things actually have been correctly allocated, as opposed to the more theoretical question of what can you do about it if you happen to reach that view, is that I happened to think that the better way forward would have been to address that question now, because for example, Weil has suggested in its memorandum a trip to the Environment Court or the High Court to determine by way of declaration whether certain provisions have been correctly included in one or other process. And that's an available option for any party. But until we have at least an arguable or reasonable case to believe that something actually has been incorrectly classified, if I can put it that way, it's a theoretical question. The court doesn't determine theoretical questions. So the only question that the court could determine is whether it has in fact been classified. And that's why I say that it may have been more helpful, and why the council did in fact address the question up front in its submissions and by the provision of Mr. McCutcheon's supplementary statement as to why the allocations that have been included are correct.
Yes, I'm aware that there's at least one party that's going to that is going to argue the opposite, that we should leave everything to see how they fall and then sort it out at the end.
Well, I suppose if the council was sitting here and was of the view that a number have been wrongly allocated, its position would probably be along the lines that going to the Environment Court may be worthwhile. But as presently instructed, the council doesn't agree that it's got any allocations incorrect. It may be worth, and the council will certainly have discussions with parties to discuss that, to see if that position can be changed. But the minor exception of the two policies that Kainga Ora have raised, and on that I need to clarify, because I think a number of parties have misunderstood the council's position on that. with the minor exception of those two policies, which are in the Schedule 1 process, but which I think there's an arguable case they could have been put into the ISPP. Council doesn't accept that anything has been wrongly allocated. Now, with those two policies, what the council's saying is that there's an argument they could have been brought within either the mandatory or the discretionary categories of section 80E. But if what we're talking about is a discretionary category, well, then the decision's been made not to include them. The council had an option either way and it decided not to. And it certainly isn't conceding that it should have been put through the mandatory category. It's a fine line, I think, put in the submissions.
Just testing that where your avenue of challenge would be. Would an Environment Court declaration actually cut the mustard? The court could declare you've done it wrong, but that wouldn't change it.
No,
would it have to be judicial review? Would it have to quash the council's decision?
No, I don't know that that's right. What I would say is that the question the Environment Court would have to determine would be something along the lines of were the provisions that the council has put within the IPI, but which other parties say should be in the Schedule 1 process, were they capable of going through the IPI? The answer to that is yes, then that determines the matter in the council's favour. If the answer to that is no, they were not capable of going through the IPI because they do not fit within either category, mandatory or discretionary, then the council could seek to delete those provisions from the IPI and re-notify them as a Schedule 1 process. And that would sort the issue out. Alternatively, as you say, it could be judicial review. The court could quash those proposed provisions and the council has to re-notify them in some form.
You've raised a question that I was going to ask, or a point that I was going to ask you about. You've put a lot of emphasis on the fact that the council had a discretion as to which process it was in. The question I had about that was, is that in fact the purpose of that discretion? Like, we take the fact that Wellington's case is unique. There's no other, as far as I'm aware, there's no other Tier 1 council running their IPI in tandem, alongside, as part of, however you put it, a larger review. And if you take the norm, which I think we would presume the minister was anticipating, that people had a plan, or councils had a plan, and they needed to change it. The discretion then makes sense because, by definition, if you have qualifying matters, you need a discretion to decide whether there is a qualifying matter, point one, and secondly, the extent to which it applies and constrains the MDRS. So it's a discretion as to whether you have, for instance, a qualifying matter at all, rather than a discretion as to whether you deal with that qualifying matter in an IPI process or in a normal first schedule process. I'm not sure it goes to the specific question, but I'm interested in your response to that point. Sort of, what was that discretion intended to encompass?
So the first part of your question was, what's the purpose of the discretion? And was what the council has done consistent with the purpose of that discretion? And my answer to that is yes, it is consistent with the purpose of the discretion. The purpose of the discretion is to enable councils to include within the IPI provisions that support or flow from, are consequential on, ones that have a rational link, the way I put it in the submissions, with provisions that have to go through the IPI process, so that you don't end up with some disconnect between the MDRS and the policies that support the MDRS and the way in which the council chooses to implement the NPSUD and other provisions which need to be changed at the same time. And a really good example of that is the natural hazard provisions, because if we're going to have all of this increased intensification, we need to make sure that the natural hazard provisions are fit for purpose. That's the purpose of the discretion. The second part of your question was about the discretion over policy 4, over qualifying matters. And I see that as an entirely different question, because there is no discretion about whether qualifying matters go through the IPI or not. They have to. They're within the mandatory category. And the way that the reason that that is important is for parties such as Dr. Keir and Ms. Cutten and the Wellington Charitable Trust, because the council's position is that those provisions, those heritage provisions, had to go through, at least in Dr. Keir and Ms. Cutten's situation, had to go through the IPI. No option about it, because the heritage listing of their property reduces the scale or is used as a reason not to apply the MDRS. It's not about whether it's in a schedule. I agree, of course, that the discretionary category enables the council to put schedules through the IPI, but that's not why the heritage schedule is going through the IPI. Heritage schedule is going through the IPI because in that heritage schedule, that gives way to rules which reduce the scope of the MDRS or the implementation of the NPSUD. They have to go through that mandatory category.
I'm interested by that because my recollection of Section 80E is that qualifying matters are in the discretionary area, the 80E2.
No, they're within 180E1B, I think it is.
Pull that up and
So it's 1A2A. IPI is a change to a district plan that must give effect to, in the case of a Tier 1 authority, policies 3 and 4 of the NPSUD. So if you're giving effect to policy 4 by reducing the scale of the implementation of the MDRS or the NPSUD, then it has to go through mandatory category.
look at 80E2. It says related matters. Sorry, lost my book.
You're referring to the references back to 77I or O.
Yeah.
And so any policies which support that or are consequential on that, you could put through in this process. But if you are saying, the way I interpret it, if you are saying that the MDRS, which would otherwise apply to this residential property, are not to apply because whatever reason, but in this case because it's a heritage building, then it has to go through the IPI.
I'm looking at 80E2. Related provisions also include provisions that relate to any of the following without limitation. Qualifying matters identified in accordance with 77I or O.
Yep. So if you have a policy that relates to the provisions which have gone through the mandatory category, then that could go through. But I'm saying that the policies and rules which apply to Dr. Keir and Ms. Cutten's properties and the other ones are giving effect to policy 4, therefore they have to go through the IPI. If there were additional related policies, they could also go through under the discretionary category, but that's not what has happened here.
But think about that, but take another example. Obviously, the council made a decision that SNAs would be removed in the urban area, but there are submitters seeking to pull them back in, presumably with a package of, I haven't read those submissions in detail, but assuming, are they necessarily IPI matters? Because if they were back in, they would qualify the density requirements.
I don't actually understand what you mean by if they're back in.
Well, there are submissions seeking that the SNA provisions that were in the draft plan be reinserted, including maps, like objectives, policies, rules, maps, the whole package.
Well,
where would they fit?
My understanding of those SNA provisions in the draft plan was that while they resulted in an additional consent requirement, in the sense that if you wanted to clear vegetation, clear significant vegetation, you needed to get a consent to do so. They didn't actually change the application of the MDRS to the particular residential property. So they weren't giving effect to policy 4.
But
so,
if you have a SNA that covers 60% of your urban section, by definition that must restrict your ability to develop that section, 50% of that section as provided for in the MDRS.
But if you looked at such a property and the zoning rules that applied to it, it would have the full MDRS applying to it under the draft plan that was put out. Yes, you would need to, you wouldn't actually be able to build up to 3 stories over whatever percentage of your site you wanted to, unless you cleared some vegetation. So you'd have to get a consent to clear that vegetation. But the MDRS applied in full. There was no reliance on policy 4 in relation to such a property.
How are the heritage provisions written then? So they are not MDRS subject to a heritage overlay?
I don't think so, but
So clarifying, in a residential zone, a resource consent is required for any new building on the site of a listed heritage building. Accordingly, the permitted activity status to build 3 residential units does not apply.
But that's the same as the example you just gave me, that for SNA, it's the MDRS appears to apply, but the overlay has the effect that it doesn't.
no, I don't think that's right. It is a permitted activity to build 3 stories on the site.
But you can't. But you can't actually do that because you need to clear a building. Just like if you have a heritage building, you need to demolish the heritage building before you can do that. Well, I don't understand the difference. So can you explain that to me?
I may need Mr. McCutcheon to, but
Look, I'm happy for you
I see them as
for you to ask Mr. McCutcheon to, because I understand he's the one that is across all the detail of the plan.
Yes.
But as I say, I'm struggling to understand what is the difference between those 2 scenarios.
The way I see the difference is that what's stopping you is the vegetation. That's a matter of physical space, physical fact. The rules that apply in terms of whether you can build on the site are exactly the same as for a building, a site that does not have any significant natural vegetation on it. That's different for a heritage building because you need a resource consent to build anything at all.
Mr. Whittington's point, Should you have, for example, a residential site, and as the example before was 50% of it is covered in an SNA, it is a permitted activity to add another 2 units, bringing the total to 3 outside of that vegetated area, subject to meeting the MDRS standards. Whereas on the site, the entire site of a listed heritage building, it is never a permitted activity to build another residential unit.
But if the SNA covers 60% of the site, by definition, you can't build on 50% of the site without a resource consent. So it's ceased to be permitted.
It is a horses for courses, as it were, approach, depending on the extent of vegetation coverage on any given site. Not all sites have 60%, or as was in the draft plan, 60%. Some might have only had a small portion in a corner of that site covered in an SNA. So 80% of that site or such a figure would be enabled for development under the MDRS standards.
So I think that what you're saying is that if it's more than 50%, then I'm right. Then they are comparable. But if it's less, then it's not.
I'm not sure that I would agree with that.
Well, explain to me why not then.
Because it's still a permitted activity on the SNA site with more than 50%. It's just that you physically can't.
Well, but my point is, it's still a permitted activity on a heritage site. It's just you physically can't, because you can't demolish the existing building. So what's the difference?
Well, I don't know how many sites had 60% significant reduces, significant natural area over them. It may well be that this is a completely theoretical discussion, which to some extent highlights my point about needing to.
Well, with that, if that's that's probably a red herring. If we go,
It's more because that was part of the draft plan, which is not before us now anyway.
Okay, Mr. McCutcheon, through you, Mr. Whittington, Mr. McCutcheon, can you just clarify whether the hazard, particularly the flood hazard provisions, would adopt the same approach that you've outlined for Indigenous vegetation too, so that if a site was affected in part by a stream flow, river corridor, or some ponding on that, it would also have the same outcome as the Indigenous vegetation or SNA type approach?
That is correct.
Okay, and we're dealing with heritage, Indigenous vegetation, and these are all Section 6 type matters, aren't they? Why aren't they? Was any consideration given to them applying as full qualifying matters, so that the sites that they affected were qualified out of the MDRS rules?
The way in which the assessment was undertaken, and that I've outlined in my statement, is that we looked at the rules, and if the rules prevented the MDRS being undertaken because they applied to the entire site, as is the heritage example, then the entire suite of rules would go through. But for the purposes of application, at least in the interim, as I've said in my statement, whether or not a qualifying matter, a matter is a qualifying matter, is of transitional importance as we work our way through the IPI process, was determined on whether a development could be undertaken outside the extent of that area that the flood hazard applied to. So in terms of the resource consent planners, if a person was to come forward and say, I want to do an MDRS development on my site, and they could undertake the MDRS complying with all of those standards outside of the inundation area, that would be a permitted activity.
Thank you.
Mr. Whittington, as you, with your initial intro, I felt that you'd shifted ground from your written submissions. That, like, there's no reason to say you can't, but I just want to be clear about this. as I read your written submissions, you were saying that this was notified as a whole plan. Every whole plan, every proposed plan is changing the operative plan by definition, and so the fact that the IPI has to be a change was neither here nor there. And as you presented it to us, you seem to have developed that, and I think have adopted, I think it might be the Ryman RVA argument, that what we've got here are in fact two plan changes.
I don't know that my ground has shifted. That was something that I said in my written submissions, was that we have two changes in the same document. They're not written. They're written in an integrated way. So instead of having, part one of the document consisting of the IPI and part two of the document consisting of the Schedule 1 part, we have provisions which are labelled to one or the other process. So theoretically, you could take all of the ones that are labelled IPI, put them in one document and call that Plan Change 1, and all the other ones and put them in a second document and call them Plan Change 2. They just happen to be in one single document for ease of reference to the public.
And if we have two changes to that, does that mean that we need to apply a motor machinist's analysis for each plan change about whether submissions are on that plan change?
Yes. And the trigger or the reason for that is that clause 99(1) says that your job is to make recommendations on submissions on the IPI. So that
and similarly, normal rules would apply if it's a normal, if the balance of the plan is a second plan change, motor machinists directly apply.
Yes.
But what's your answer to Mr. Ballinger's argument, or well, I would say, I wouldn't phrase it a question, an argument. The question that he puts, well, what happens if a submission is seeking an entirely new provision? By definition, that hasn't been classified by the council. How do we treat that?
I don't agree with that, because even new provisions originate somewhere. So you might have a provision in the IPI and you don't like it, so you delete it. But you were concerned about the issue that it purported to manage, and you rewrite a brand new provision to manage that issue. In my submission, that is part of the IPI. That's where the idea originated from, and vice versa for the Schedule 1 process.
That works for submissions that follow the requirements of the forms rules and identify the provision to which they relate. But what about submissions that say, for instance, the plan is deficient because it doesn't have objectives, policies and rules linking directly to climate change objectives. And we seek that plan should have such provisions, as an example. If, like, on the base, one argument might be it already does, and what you're seeking to do is to amend what's there. But taking a hypothetical, if the submission isn't targeting an existing provision, but is saying in a vacuum, the plan should have the following provision in it.
Well, again, we might be hoist on the petard of theoretical situations, but I would question whether such a submission is in scope. It's on the plan or on the plan plan change, because no Section 32 analysis would have been done on it. If you go through the motor machinist's test, the bipartite test from Clearwater, one of the questions is it answered by the Section 32 report? I don't know, because it's a theoretical question, but I would question whether it is.
Other Section 32, other separate Section 32 evaluations for the IPI matters as compared to the others?
No, but I think because it's been written as an integrated plan, the Section 32s apply to Section 32 applies to both plans.
And in terms of the application of the, as you say, our task in clause 99, I think it is, of the part 6, where it says that we have power to grant submissions that don't respond to a submission, on the IPI. Is that a backdoor method to shift non-IPI provisions into the IPI fold, or potentially?
Well, let me answer that question by almost going directly to Weil's submission and explaining what I agree with and what I don't. Because I agree with Weil's reference to the Albany landowners case, which is about the question of what does it mean for it to be on plan change. And Weil has quoted in section 104 of that decision and highlighted in bold this sentence. The significance of this is that the IHP's jurisdiction to make recommendations is circumscribed by the ambit of the notified port. So applying it to this situation, your jurisdiction is circumscribed by the ambit of the notified IPI. And I agree with that. We have a bunch of provisions which are in the notified IPI, which some parties are saying shouldn't be. But I don't see this as affecting that. You have jurisdiction to consider and make recommendations on those provisions that are being called into question, because they are within the ambit of the notified IPI. You can't look at section 80E and say, well, I'm not sure they should have been, therefore I don't have the power to consider them. To me, that is illogical. Once we have a notified IPI, that sets the four corners of your jurisdiction.
In relation to the IPI.
In relation to the IPI. So I don't disagree. So I suppose when they say that the council's submissions conflate, trying to find where it is that it says that. Yeah, conflate these two quite different powers of recommendation available to the panel. I don't agree that that's what the council has done at all. I agree with Weil that the extent of your jurisdiction is governed by what's in the IPI. Where I disagree with them is that I say that includes the provisions that are called into question.
That's all I had for Mr. Wellington. Anyone else got any questions? Question, Martin?
Thanks, Mr. Whittington. I'm a little bit confused when you say there's agreement that the panel has jurisdiction to determine which process provision should go through, but then you say the council doesn't have the power to then reallocate the provisions between the two processes. Can you just elaborate on that?
Yeah, no, what I was saying right at the start is that you have the jurisdiction to determine this question about whether you have the power. So entities such as yourselves, independent hearings panels, tribunals, all have an inherent, I suppose, power to determine what your powers are, to answer legal questions about the scope of your power. So I was saying you have the power to decide whether you have this power. If you decide you have the power to allocate, then you can go ahead and do that. You might be subject to judicial review, you might be subject to challenge, but you have the power to determine that.
Yes.
My submission to you is that you don't have that power.
Yes. So the illusion of reallocation isn't really an illusion of jurisdiction.
Yes, exactly.
Okay.
So I think this idea of allocation makes it sound like it's a very simple process. There will be no harm caused to the process by simply picking up some provisions and putting them where other parties would like. But
Right.
I don't agree that you can do that. But you do have jurisdiction to determine whether you can do that.
Okay. It's a bit like Clayton's jurisdiction.
It is.
It's a drink you're having when you're not having a drink.
That's right.
Okay. For those that are old enough to remember that advert. The second issue is about prejudice, if any exists, and there's 3 timeframes I want you to consider up until this point, during the hearing and post decisions. Up until this point, in relation to any reallocation decisions, is anyone prejudiced in terms of their ability to lodge submissions?
No, not in my submission. Everyone has had full notice of the plan. They have been told by reference to the labels put on each provision which process the council intended them to go through.
Yes.
And they've had the opportunity to question that if they wish. Nobody's taken up that opportunity. They had the opportunity to make submissions, and their submissions will go through the process that the council has allocated to it.
Okay.
That's the first one.
During the process itself of the hearings, there's the issue of cross-examination existing for IPI and not for first schedule. There's the scope of IPI submissions being a bit more flexible than traditional ones. Are they the 2 key issues for the?
They're the 2 key issues for the second stage. So theoretically, we have provisions which are in the IPI, which some people say should be Schedule 1 process.
Yes.
I don't see any significant prejudice from them being included in the IPI process. People still have more than adequate time to prepare. But one of the issues raised was that there's a significant issue of natural justice. I don't agree with that at all. Both processes are entirely natural justice compliant. We'll get to it in what I anticipate is your 3rd stage, but appeal rights have nothing to do with natural justice.
Okay, well, let's go straight to that. And that's the key difference, isn't it, in the 3rd stage?
Yes.
The ability to appeal the decision of the council, whether it's an IPI or a first schedule process.
That's right, to the Environment Court.
Yes.
And in my submission, well,
yes, to the Environment
may
Court.
not be, I accept it's either a controversial view or one on which reasonable people may disagree. I happen to think that the right of appeal to the Environment Court is not as significant as is being made out. It's not a constitutional or democratic right that Parliament has somehow unfairly taken away from people. The process has been set. It is natural justice compliant. Parliament's decided not to allow Environment Court appeals.
Yes.
It's not, nothing's been removed. This is a brand new process.
But that's directly where the allocation bites, though, isn't it?
That's where it's perceived to bite. I don't see it as a problem at all, but
Yeah, we might hear differently
we
from.
will hear differently from other people, and I understand that. It's a backup, I suppose.
Yes.
But the reason that I think that it has more, that there is a perception of significance to it, is because of what I've mentioned in my memorandum as the behaviour that I think that it induces, the incentives that it induces. You know, people do not have unlimited resources. They often cut their cloth at the council hearing stage, knowing that they will probably end up in the Environment Court anyway, so better to save their resources for that process.
Yes.
That is obviously to the detriment of the council stage, and everyone's known from the start that there would not be appeals to the Environment Court for IPI matters. So I don't see that anyone is in any way prejudiced by that. Everyone can throw their resources into this process, and that will result in better decisions for
Okay.
them.
Well, let's hear what the others have to say on that. My final question was, and I think you acknowledged the chair's question that Wellington's in a bit of a unique situation that they're running a proposed plan review with the IPI process in tandem in one document.
Yes.
Other tier 1 authorities, I'm thinking of Selwyn, Porirua, have proposed plans and then the variations sort of got caught up. Are there any learnings from those other authorities that are relevant to this in terms of the allocation of books?
Well, I don't know.
Are you involved in the Porirua case from the other side of the table?
Yes. One thing I have done in preparation for this discussion this morning is to think about what would be my answers to some of these questions if we were just talking about an IPI. Some people were saying you've included these provisions in the IPI, they shouldn't be there. And my answer is the same. They can judicially review it, they can challenge it at the end of the process if they want. But and you could substantively decide to delete those provisions because you don't think that they're good provisions. But I don't think that if this was a single process going through, you were at the end of your deliberations and you decided, well, regardless of what we think of the rule, we don't think it should have gone through that process. I don't think you should sort of decline to issue a recommendation on those provisions, because what if you're wrong?
Okay. Doesn't really answer my question of whether there's any learnings.
No. And I think part of, well, my answer to that is that I don't know, because no one, to my knowledge, is considering in a preliminary way whether the scope of the IPI has been notified in those districts, cities, has provisions in it which shouldn't be there.
Okay. Have there been any declarations to your knowledge?
No, not to my knowledge. Auckland is holding some a pre-hearing conference to discuss some issues that have arisen because of the way that they notify their IPI, which doesn't include, has effectively a whited out Auckland light rail route down to the airport, which some parties say is unlawful. And there's also some issues with SHAs, which are going to be determined. They'll be assessed by the panel, I suppose, as legal questions. But they haven't been determined yet, so there's no real learnings from it. Maybe something for you to keep under consideration to see how you're.
Thank you.
Commissioners? Just go for it.
Yes, thank you, Mr. Wellington. Just one question around these two maybe policies, the NIZ ones. If we, it's the so what question, if we were to think or come to the view that they should have been mandatorily part of the IPI, I think so what we do about that?
Nothing.
What's your advice? Nothing we can do about it.
Nothing we can do about it. They will theoretically be subject to appeal to the Environment Court. The Environment Court will do, assuming of course you recommend that they are adopted and then the council adopts them. They're going through the Schedule 1 process, and I think unfortunately Kāinga Ora may have misunderstood what I was saying in my memorandum, because I wasn't saying that the council agrees that they should be reallocated and asks that you do so. It was saying that they are the two policies that the council agrees there's an arguable case that they may have been included in the wrong process. Thankfully, in one sense, it's they've been included in the more conservative process rather than the other way around. And if the council is wrong, then that's unfortunate, but there's nothing in my submission that you can do about that.
Mr. Wellington, in your summary that you gave us at the start of this session, you made the comment that nobody wants an outcome that's not a positive one. Nobody wants, otherwise it'll go to judicial review, etc. If parties have submitted, or we've seen evidence or legal that there are provisions within the plan that should or shouldn't be in the particular area that they are, and we're of the mind that there is a good amount of logic to support that, isn't the best outcome achieved by us having a lever to pull in order to make sure that the best possible outcome is achieved? And second to that question. I'm not a big fan of just going down a path that's not appropriate in the hope that a judicial review at some point in the future will sort it out. So the concern that I have is if there are matters that are raised that are that do have logic and we don't have the lever to pull, how do we achieve the best possible outcome?
To answer that question and perhaps to also re-answer the question from Commissioner McMahon, the reason I said at the start that you have jurisdiction to determine this question is that it is open to you to disagree with me and to find that as a matter of law, you can reallocate. In one sense, that would be nice and easy for everyone. And because it would be nice and easy for everyone, I have actually tried relatively hard to make the law work in that way, but I can't see a way that it does. Now, other parties disagree with me. All I can do is explain to you my reading of the legislation and informed by, as you'll see in my submissions, my view of public law and allegations. I can't make them all work in that way. So that's one answer to the question is I'm not hoping that there's a judicial review at the end of it. I'm hoping that there isn't a judicial review at the end of it. But that's the avenue that I see that parties have available to them to check. Now, Lyle has suggested a declaration in the Environment Court. I'm not, don't necessarily agree that that's appropriate, partly for the reason that I mentioned at the start, that at the moment all this is a theoretical question, but may well be that parties can talk about that's inappropriate.
Thank you.
Well, I think we better hear from the other parties. Is there? I'll ask Mr. Ballinger this question. So, since he's directly in my eye line, no better reason. Do you have a suggested order of batting? There are, I think, 5 parties present with an interest in the matter. Who's going first?
So I don't have a strong view. So there's, I think, Dr. Keir.
Any volunteers?
Wong,
I wonder if it'd be, given that potentially is coming in by teams, it might be preferable to hear him first, and then we can go from there. Potentially, you out there?
Just before you do, can I perhaps just ask one question? I haven't mentioned, and you haven't asked me about Section 39 of the RMA, which was raised by Counsel for Dr. Keir and Ms. Cutten.
Perhaps you had better tell us what's your answer.
Well, I don't agree that Section 39 provides the power for you to reallocate provisions. It provides a power for you to come up with a fair process. You've done that through the hearing, the minute on hearing procedures which you've issued. And in my submission, it doesn't authorise you to revisit the council's earlier decision to allocate provisions in the way it did.
Okay. Potentially. Heard Mr. Wellington, heard my exhortations amplified by the fact that it's now 5:10. So can you, do you have any brief opening comments before we ask you a few questions?
Yes, Mr. Chair, thank you. I thought it might just be worth quickly setting the scene in terms of why the retirement sector is interested in this question. And it's perhaps a bit different from the situation of WILE, where they're seeking for their provisions to be addressed through the first schedule process. In the notified plan, retirement villages, and I'm thinking of the medium density residential zone in particular, have been allocated to the Schedule 1 process. However, a number of the other provisions which relate to retirement village activities, being policies and rules and particularly the MDRS provisions, which also apply to retirement villages, are in the other process. So the complexity that arises as a result of that is that retirement villages are essentially in dual regimes when they come to consenting at the end of this process. And the industry says that is going to create uncertainty and problems and potentially delays in terms of it trying to accelerate housing in Wellington, which can't be what the legislation intends. And the proposition is, from the industry's point of view, that all of its relief should essentially fall within the ISPP rather than the first schedule. So I thought it was just worth setting the scene there, and I guess perhaps emphasising as well that retirement villages are essentially a form of multi-unit housing, and from that point of view they would naturally fit within the category of 4 or more residential units, which is provided for in the MDRS. However, in treating them separately, as the council has done, they essentially are unable to access those MDRS provisions now and potentially at the end of the ISPP process. So that's just a bit of a scene setter. In terms of some brief comments, I thought perhaps it's worth first of all noting that the RBA and Ryman don't agree that the issue in front of the panel here is a procedural question. And I think that Mr. Wellington suggested that all parties agree that. I don't think we do agree that is the case. As we've indicated in the submissions, we submit that the question in front of the panel around allocation is not consistent with the panel's functions or powers. And I say that essentially because the question that you're determining, whether you have the power to allocate and then should you exercise that power, essentially creates a decision on the scope of people's submissions or party submissions. And I say that the panel does not have the power to make decisions on scope. They only have the power to make recommendations, and that's calling on section 99 of the first schedule, which you've heard a lot about. The other section that's worth noting in this context is section 96 of the first schedule, which talks about when the panel can make recommendations, and it can only make recommendations after hearing submissions. So I say to the extent that you can make recommendations on scope, you can do that in accordance with section 99, but you cannot do that until you've heard from the parties. And that supports the parties' view that this issue should essentially be left to the later substantive hearings. Because what I'm saying is that allocating and scope have essentially been conflated, but the real question in front of you is a matter of legal scope, whether parties have made submissions that are on the plan change or on the ISP, and then whether in terms of the broader scope that section 99 provides for, that there's something there that the panel needs to engage in. And I've made a number of submissions on the scope points, which I won't touch on, but it's worth, I suppose, pointing out the perverse outcomes that can occur if the panel essentially determines that it doesn't have scope to allocate, or it does, and it makes a decision as to what provisions go where. In my view, that in my submission, that essentially will predetermine your recommendatory functions at the section 99 stage, because you'll essentially have made a decision on scope, and then that you won't be able to properly exercise your recommendatory powers in terms of the mandatory provisions in section 80E, and looking at those more discretionary powers in terms of how much wider the plan change could potentially be, related matters and the like. And then I just point to the submissions of Ms Anderson on behalf of Ms Cutten and Mr Keir, paragraphs 8 through to 10, just talking to some of the other practical problems that will arise if you make a decision on that now. And picking up on that point about new provisions, which is also a complex and problematic one, the industry has made a number of submissions seeking new provisions. And for example, they relate to policies seeking greater recognition of the housing needs of an ageing population. And we'll submit that those fall within and on the IPI process. I think that if those essentially cannot be included on the IPI, again, I think that results in a perverse outcome, because you have
some provisions being processed through a first schedule process, others through the ISP process, and retirement villages essentially caught somewhere in the middle when trying to, get consents in the future. But that was all I wanted to say by way of brief overview, and I'm happy to answer any questions.
Mr. Henchy, I picked up your initial point about, I understand the logic, you can't make a decision until you've heard the submissions. But as Mr. Whittington's observed, there are some things in the hearing where we need to know which bucket a submission is in. So if, for instance, you apply to the panel to cross-examine the 42A author in relation to their recommendations on, for instance, the example you gave me, the need for new provisions to address an ageing population, how do we know whether we have jurisdiction to consider your procedural application to cross-examine if we don't know which bucket this provision you're seeking to insert is in?
Yeah, and so I have really grappled with that practical issue as well, and tried to think of how essentially you get around that. I don't think it detracts from the submissions I've already made in terms of the scope you have here. So I just want to make that point initially. In practice, I think there's going to have to be a case-by-case assessment of these sorts of requests. In terms of a party seeking cross-examination, I think it's really incumbent upon them to make the case that they are within the IPI, or at least there's a reasonable prospect of that in their application process. And then the panel can grapple with that. To the extent that, for example, the panel approves the cross-examination requests, and that because they consider that there's a reasonable case there that the submissions are on the IPI, and cross-examination occurs, but as a consequence of hearing those submissions, that cross-examination, other witnesses and so forth, the panel ultimately recommends that provision is actually on the first schedule process. I think that would have to be a case of the panel essentially disregarding the evidence that they received during cross-examination. And I think procedurally that would be the only way to essentially, remedy that earlier incorrect allocation, I suppose, to the ISP process.
The other practical issue we have is that we're working to different timelines. That if we had the same timeline for the IPI and the non-IPI provisions, I could understand how your submission could work. We would sit in a huddle at the very end and decide this was properly part of the IPI. This is subject to our disagreeing with Mr. Whittington, of course, and this isn't. But of course, because the IPI is on a much tighter timetable and we cannot physically hear everything on the entire plan within that tighter time frame, we're going to have quite enough of a challenge hearing what we believe to be IPI matters within that time frame. How does your solution work, or how does that manage that practical conundrum that the panel has to address?
And that, again, that is another vexing issue in terms of how to get.
Can I just say it's certainly vexing us?
Well, it's certainly vexing me too, Mr. Chair, and no doubt other parties as well. And I spent a considerable part of yesterday thinking about how that particular issue applies in relation to hearings 6 and onward, which you'd raised in your earlier minute. Again, I don't think that the practical issue changes the legal position in terms of what powers you have available to you. And I just, you mentioned the word a couple of times, your decision. It just to go back, it is a recommendatory function that you have in terms of scope rather than a decision. So just to keep that in mind, I suppose. In terms of those later hearings, I think the panel probably has a couple of choices, neither of which I would say are ideal, but they are perhaps practical in the circumstances. One of those would be to look at the relevant hearings that fall essentially after the ISP process is proposed to be completed, and try and bring forward hearings or adjust the order so that any which are particularly where there are particular challenges around, the allocation of provisions, ISP or first schedule, could be heard earlier in the process, and you may therefore catch up to some extent. And if that's not possible, but the only other solution I've come up with so far is that you could release your recommendations in stages, the bulk obviously being within the first stage and within the statutory timeframes for issuing an ISP. And I would suggest that probably most of the relevant provisions will be in that part of your recommendation. And to the extent that that recommendation needs to be adjusted by adding essentially aspects to the ISP through the later stages, that could be done on an as needed basis. And only to the extent that the panel does agree that there are other provisions out there which are better fitted in the ISP process. And it might be, sorry.
But by definition, in the latter case, if we actually did that, we would be in breach of the provisions fixing the time limits for we would be contributing to the council breaching their time limit for making decisions on IPI matters.
And yes, and that's why it's certainly not ideal, and it wouldn't be suggesting it if I thought it was. If there was a better way, and I think perhaps with Wellington, as you pointed out, and as Mr. Whittington has mentioned, it is quite a unique case in that it's been forced into this situation where it's essentially running two plan changes together, one a full plan change process and one this ISP process. Other councils clearly aren't faced with that same issue to the same extent. So I think there's probably a case for seeking some flexibility in this particular scenario. I think that's probably made stronger by the fact that the legislation doesn't particularly adequately deal with this issue of overlapping planning processes. And as I say, Wellington really is an exception.
Does that mean that if the panel recommends to council that it seeks more time for the IPI, it'll have the retirement village parties' support?
Well, if it's in line with the initial thought, Mr. Chair, that the first recommendation could occur within the statutory timeframes, and that would deliver the bulk of the provisions needed to, consent to retirement villages, I think that would be yes. The answer to that would be yes from the industry. Yes, we can support an extension of those other aspects of the plan. To some extent, I mean, from the industry's point of view, the bulk, if not all, of the provisions it seeks will be in that first stage.
In terms of your suggested first solution, that was, of course, the thinking underpinning my asking if any party thought there were provisions currently scheduled in streams 6 to 10 that they were going to argue should have been in the IPI, that they tell us about it so we consider the order, assuming we decide we have jurisdiction to do that. And to, there wouldn't be any need to do it if we agreed with Mr. Whittington. You haven't. I've got two memos. One from Weil. I'll talk to council about, and one other. That wasn't the retirement village parties, was it? You haven't actually identified any provisions.
No, sir. And again, we grappled with this question yesterday as to whether we would file a memorandum. I think it's one of those balanced views from the industry, and we're seeking to be reasonably pragmatic to assist the panel really, and not making the case that there are matters in hearings 6 and onward that could be part of the IPI. But in essence, the provisions that the industry is seeking are all related to the basic activity of retirement villages, which they say is part of the ISP process. So I think we could have made that argument, but we just simply didn't because we felt it would be undesirable from your point of view, and that many of those provisions are actually sort of at the fringes, I suppose, of what's needed for development of retirement villages, and we can sort of just live with the uncertainty that having two processes creates. But I suppose, Sue, you do make a good point that the memoranda that you've received on that point, particularly on those later hearings, may well help you guide you in terms of whether there is any time issue, because you may well be able to shift some of the hearings forward in terms of the provisions that have been raised in the memoranda, or determine that perhaps they are of such a unique or sort of confined nature that it means you don't need to worry so much about the time frame issue that you mentioned.
I have one final question before I ask my colleagues if they have any questions. I'm picking up on paragraph 20 of your written submissions. The panel can't be precluded from including a provision on the IPI because the council notified a similar provision as part of the non-IPI provisions. I can understand there's one thing to add an entirely new provision in the IPI, but is there an argument that it's a bridge too far to say that you can add a new provision in the IPI component of the plan and delete it from the non-IPI provision of the plan?
Well, in practice, it won't be. It'll still be there, I suppose. It's still a provision in the plan. Yeah, and I think where we were coming from there is that obviously there's provisions in the plan which where the council has decided to allocate them to one path or the other, but the provisions ultimately that the panel recommends will not, in most cases, be exactly the same as those. So that essentially you won't be reallocating the provisions. You will simply be making a recommendation on a set of essentially new provisions. So we felt that might have given the panel some comfort in terms of not, I guess, going against the council's earlier decision. As I say, I don't think you'd be deleting any provisions from the plan. You simply would be making a recommendation, as you're required to do under Section 99.
And I just record that we don't have a problem making recommendations that don't accord with decisions the council's already made, if the evidence supports that, just for the record.
Good to hear.
Thank you. Any questions?
I've just got one. You're saying, Mr. Hinchley, about the issue for your clients is that it creates dual regimes and certainty for accelerating housing for the aged. I'm just trying to get my head around how that would occur if you're trying to provide for some policy support through the IPI process, but your actual teeth are in the Schedule 1 process. Does it matter? I can't quite see what the uncertainty is that's being generated.
Yeah, I think there's two perhaps points. There's a practical response to the question, and then there's a legal response. The practical response, I think, is that when you make your recommendation, the council makes its decision on the ISP, there will be operative provisions to deal with housing in the plan. And in terms of your decision on the first schedule process, there'll be essentially operative if they're not challenged, but otherwise still proposed plan provisions. So for retirement villages, you could have a situation where they've got a regime of operative provisions that they need to comply with, and then a bunch of essentially still proposed plan provisions, and then they'll still be required to engage with the operative, the currently operative plan. And that, I think, creates kind of practical complexities, because you'll be in a consenting context, you just won't have a certain and clear regime. And I submit that would go against what the intention of this legislation is to do, is to enable housing by removing barriers and, having, clear pathways to get through, consenting processes. The legal issue is partly that the industry will say that its provisions, better achieve the purpose and intent of the ISP process, the enabling housing legislation, and the NPSUD, is potentially, there may be a debate about how much those provisions can be relied on if essentially we're only, in the first schedule process. And I would again submit, when you're dealing with an activity class, which is essentially a form of housing, a form of multi-unit development, and a decision in this process would essentially say that you can't argue that you're part of the accelerating housing solution that the government's seeking to achieve here, then that would create perversities, and I think would create natural justice issues in terms of this industry's ability to argue for its position on housing versus any other industry that's also arguing about housing matters.
Thank you.
Any more commissioners? Thank you, Mr. Hinchy, for reporting in virtually.
Thank you, sir. Thank you for accommodating me.
I think we're ready for the next one up, Mr. What was it?
You want to go or?
I don't mind going next. You
Right.
You're welcome.
I'm happy. I'm probably fairly brief.
Ask Mr. Wellington to vacate for the moment and give you some space. Mr. Ballinger.
Thanks, sir. My client's position on the jurisdiction question is, I think, largely aligned with Mr. Hinchy's client. The focus that my client has is on wanting to seek for provisions to be moved from the IPI process to the Heartland Schedule 1 process, but in principle we're aligned on what Mr. Hinchy says about that largely being a matter of the scope of submissions. One difficulty, I suppose, in assessing the scope of submissions in the usual way here is that, as I pointed out in my written submissions, as far as I'm aware, most submitters haven't made it clear which of the two plan change instruments they are submitting on. And so when the panel is, if you are looking at this question through the lens of scope, you'll need to sort of take into account that submitters haven't been sort of invited to be clear on which of the two plan change processes or instruments they were making submissions on. So that's sort of one point I wanted to make by way of opening. The other, I suppose, point is, oh, sorry.
Just for people behind you.
Yeah, is that better?
No.
It goes green.
How's that? Yeah. The green light.
The missing link, pressing the button.
Sorry about
switching it on.
The other point, so I think this jurisdiction topic arose from a question from the panel about inviting parties or submitters to address the panel on whether provisions had been correctly allocated. But through sort of working through that question, it's become clear that there are other allocation type issues that the panel needs to have a clear grasp on to proceed. And the one that I've raised, as has Mr. Hinchy, is what is to become of any new provisions that submitters have put forward. And in my submission, when you look at how those are going to be dealt with, it becomes clear that there is ability to assess whether those are part of or on the IPI or on the regular plan change. And equally, there is ability to consider whether consider submissions on moving a provision from one plan change instrument to the other. So yeah, in my submission, there needs to be a sort of a clear direction. So to go to proceed with hearings on how new provisions are to be addressed and whether there is any ability to move provisions between the two instruments.
So you don't agree with Mr. Hinchy that we should just let it play out and see what happens?
No, sir. I think some direction is necessary to make this hearing sort of fair and easy for people to engage with on how the panel will be dealing with questions like cross-examination, the timing issue that was raised just before, and other sorts of things that might flow from the allocation of provisions in the notified plan and any new provisions that might be added.
Ballinger, in terms of the characterisation of the process as two plan changes, is that your characterisation as the best way to make sense of what's rolled out?
Yes. Yes.
Right. And now, in terms of, if you take that, we have two plan changes side by side, and so you're actually talking about we're shifting provisions from one plan change to the other. Now, in a machinery movers principle, how's that going to work? Because by definition, a provision that's currently notified as being in the IPI equally is not in the non-IPI and not addressed by the non-IPI. Is a submission seeking to shift actually a submission on in quotes in a machinery movers sense the non-IPI plan change?
Yes, so in my submission, a submission that is calling for a provision to be moved from one to the other is a submission on both instruments, and the usual scope analysis from machinery motors is probably a starting point for the panel to assess whether there's scope to do that.
Yes, it's machinery motors. Is it movers or motors? I've forgotten.
I did.
Corrected.
Machinists. Thank you. When looking at the test and approach in that case, in my submission, it's not really going to be helpful just to look at the guidance from that case. There's an additional factor here to consider, which will not have been a factor on any other plan change processes that have occurred, and that is that here we have two plan changes notified at the same time. In the public notice, they are referred to as the proposed district plan, and the public notice calls for submissions on the proposed district plan. The notice then does go on to indicate there are two processes being used, but that from an engagement perspective, and therefore from the perspective of what you could expect submissions to deal with or raise, it's important to bear in mind that submitters will not have necessarily been alive to the point that they need to perhaps make it clear which plan change instrument they are submitting on, and to make it clear maybe that they are calling for something to be added to one plan change instrument and removed from the other. So when you're looking at analysing scope, if it is to be addressed through that lens, that additional factor that this is two plan changes rolled into one and notified together is important.
I suppose the particular factor that Justice Koch identified of whether or not a provision that's sought to be added is covered by the Section 32 analysis isn't a problem because there is only one Section 32 analysis.
Yes.
Thank you, Mr. Ballinger. Any questions from the panel?
Thank you, Mr. Ballinger. The only question I have is if most of the submissions, as you've identified in your memorandum, most submitters haven't identified whether they're part of the IPI or not. What's the practical implication of that, given that if that's the case, I'm assuming they're not seeking for it to be changed from one to the other either.
Yes, but I suppose submitters weren't given sort of a clear warning at the time of notification that as to how the panel might deal with these sorts of questions of allocation, and they weren't advised to, if you're putting up a new provision, you should indicate which instrument you think it should be added into, etc. So I suppose the fact that this is the first time, as I understand it, that two plan change instruments with different procedures are going through at the same time has been used, needs to be part of your assessment of scope and fairness to submitters.
I think for the Commissioner's benefit, I can think of at least one submitter that did make it precise. That's Transpower.
Yeah.
They were specific and trying, I think they wanted to move things into the IPI rather than the reverse direction, but they were specific.
Yes.
Any other questions for Mr. Bellinger? Well, thank you very much for your time, Mr. Bellinger.
Thank you.
Appreciate that. I think we might stop and have a cuppa and a drink of Obviously, we need to know that. Otherwise, I'll invite you to make any brief introductory remarks before we ask you some questions.
Sure. Well, I mean, it's quite obvious from all of the legal submissions that have been filed and the submissions that you've heard this morning that this is a complete schmozzle. And rumour has it that one of our Environment Court judges referred to a brain bleed in the context of this legislation. So, and it has, you know,
I think we draw lots as to have a sweep as to which one that might have been.
But it is, you know, like as we've heard this morning, you know, people and I have spent a great deal of time thinking of solutions and thinking of the problems and trying to be constructive and not wanting to make the process more difficult than it already is. We understand, I've been through a number of district plan reviews in my career and I know what they're like on both sides of the counter. But it is a really, really difficult situation. And while I agree with the council that there isn't, I think I agree with the council because there's been quite a bit of changing of position as well. But my position hasn't changed in terms of what is in my legal submissions. I think that it's the council decision to put the provisions in either of these plan changes, and that was a decision, and you can't revisit that. So it's not a procedural matter. It's a bit like if the summary of submissions is wrong, you don't get to try and make that right as much as that would be a good idea along the road. But unfortunately, that is something where you have to go back to go. So that's that kind of decision. But what you can do, and what I've tried to put in our submissions, is you know, some solutions as to how do we go to the next steps and how do we make this a better process. And I suppose if I respond to all of the legal submissions thus far, is that it seems there is enough inconsistency between all the legal views that this matter that it would be helpful for the council, for you to ask the council to seek some guidance from the Environment Court. Now, Mr. Wellington said we haven't got anything to take to them yet, it's all hypothetical. I'm sure that's quite true. We have lots of examples and we have some fundamental questions to ask of the Environment Court. What does a district-wide matter mean in the context of the section? My view of it is quite different from the council's view of it. I think everything goes back to section 80E. What is on the IPI? It's not on the IPI, it doesn't go into it. And that is governed by those two subsections, subsection 1, the mandatory matters, and subsection 2, which is those what we're calling related provisions. And you know, this is, and so there are a number of questions that could be asked that would give the panel the best possible chance of making most of the right decisions. Because there are some glaring, in my view, errors, i.e., for instance, we've given them the most obvious, which is the whole of the hazards, natural hazards chapter has gone into the IPI. When other matters like heritage and other things, the council has divvied it up in those chapters as between the IPI and the ordinary Part 1 Schedule 1 process. So why not do that for natural hazards? So the IPI portion of the natural hazards chapter would only deal with those areas and zones that are subject to the section 80E provisions, and leave those other areas, industrial, land, open space, all of those other areas that I've set out in my submissions to be dealt with through the Schedule 1 process. Is it efficient? Probably not. It's untidy, yes. But the fact is that the IPI is a subset of the district plan review, and it is there for a particular purpose, and there is a particular process that you must follow, and there are particular restrictions in what you can and can't do, and obviously there are particular restrictions on what submitters' rights are, i.e. in terms of appeal. It is messy because as we go through this process, we'll see that there are overriding objectives that are in Schedule 1, but the related policies are in the IPI. So what happens if there's a resource consent when the IPI decision's been made on the policies, and then you've got these outstanding objectives that override? It's just really, really ugly from a planning practical perspective. And so my gut feel is, and particularly bearing in mind the decision, that the Otago decision that I put in our submissions, where the court, this was with regard to the freshwater provisions, said, well, you can't have the whole thing as a freshwater plan. So you're going to have to go back. But what the court did there, strangely, in my view and other practitioners' views, is that they asked the council to re-notify the freshwater provisions, because they were the special ones, I suppose. That's the only reason I can come up with as to why the court did it that way. And so the freshwater provisions were re-notified, so everyone knew what were those special provisions that would take away some rights and had a particular emphasis in a particular statutory regime. And in my mind, the same approach is here. But I think the court could give some good direction about that. So, and we can ask the court for guidance. When the City Council did, I think, one of its second plan review, and Commissioner Mann will remember, they were planning this new outrageously fantastical district plan that had never been seen before, and so they went to the court and asked for some direction about the approach that they were taking. And the court is practical, it's full of clever people, and they gave directions to the city as to how to deal with that issue. This is a bit more serious, because we're talking about the jurisdiction and taking away appeal rights, and also creating this hiatus. And you'll see, I filed yesterday, albeit late in the afternoon, provisions where Wellington Airport thinks that some of the provisions that have been identified in Schedule 1 should be moved through to the IPI. So as far as Wellington Airport is concerned, we have submissions going either which way. So some of the provisions, like, say, for instance, the hazards, we think that the hazards as they relate to those non-urban zones need to go into the Schedule 1 process. and there are provisions that relate to reverse sensitivity effects because of a qualifying matter in those urban zones, which are in Schedule 1, that need to be moved into the ISPP.
Well, let's just, I was going to say at the end, but with you and Wakakatahi, I didn't finger the noise provisions and that we've shifted those that were specifically identified as ISPP provisions forward into an earlier hearing, but not the balance, and that's what I think both you and I think when you finally caught up with Mr. Kyle, I think that was his list. They were all noise provisions.
Mostly.
And I think we're going to take this on a stepwise basis. We'll worry about where things are scheduled when we've decided whether we think we have jurisdiction to do anything about how they've been notified.
Yes.
The practical question I have for you is, if we were to accede to your suggestion and suggest to the council let's seek a declaration with the best will in the world, there's no chance that we would then make our statutory timeframe for IPI decisions. Are you suggesting we plough on while we wait for the court's direction, or do we just stop and throw up our hands and say this is all too hard, we need some help, please?
And again, another vexed question and indicates the layers of complexity as a result of what the council has been forced into by this legislation. But I think that I think that the court would entertain an urgent declaration in the circumstances. I would certainly hope so. And it could be that there are some topics that are not riddled with the problems that we've been talking about, which could be heard. I don't know, I haven't looked in that.
When you've identified them, you could tell us what they are.
Well, we've identified which ones Weil thinks their concerns, but I know that our planners have suggested that they've seen other likely suspects as well. But you know, what I can say is that Wellington Airport wants to assist the situation, not make it more difficult, and would be happy to sit down and help with identifying the questions that would go to the court, for instance, and providing the examples. And often by providing the examples to the court, as you know, the dicta that comes out of that assists in other ways. And in terms of timing, it might, for instance, make a comment about how the timing doesn't work very well, and that may assist the council in going to the government and seeking some kind of extension with a piece of paper from Mum and Dad in hand to say how serious the situation and how awkward this is making it for this process.
Well, I had one question about the substance of your submissions, moving past the suggested relief. At paragraph 3.8, you say the scope of the IPI is determined by section 80E. And then you quote Justice Fotter's decision, which, as Mr. Whittington observes, says the scope is circumscribed by the ambit of the notified, in that case, proposed Auckland Unitary Plan.
Yeah, the town.
I can understand if what you meant in 3.8 was the permissible scope of an IPI is determined by section 80E. But what's your answer to Mr. Whittington's response that it's that in this case it's determined by the subset of provisions that the council notified as their IPI?
Oh, I don't think that can be true.
Well, the key question is, well, why not?
Because otherwise that fetters your ability as a panel to make decisions or make your recommendations. And I seem to recall that there are a lot of examples in DLO Piper legal submissions as to why that is not a
For who? So,
the DLO Piper submissions.
Oh, yeah.
Can't remember the submitter's names, is Dr. Reid and Mr. Cutten, or the other way around. So there were some examples there as to why that is, but we don't agree with that submission.
Mr. Wellington's response, of course, is that we will make recommendations either way. It's not fettering our ability to make declarations. It's and one answer might be, well, we might think it's an IPI provision, but someone could still appeal and convince the Environment Court that it wasn't, and that therefore it should hear an appeal.
And I think that's exactly true. But what I'm suggesting is at least get some advice to cut that down so that you're in the best possible position to make the best possible recommendations. And then there's less likelihood of, legal wrangles later on and rules being severed because they weren't on the plan, or resource consent's been applied for, or legal effect issues. So it is just for me, simplest approach is to get some advice, because obviously there is a wide breadth of legal opinion here as to what is the right thing to do.
Okay, any other questions, Mr. McMahon?
Thanks, Ms. Stewart. As a lay member of the panel, these are all quite challenging topics, and I think I probably speak for the majority of the panel, so it's been quite difficult getting our head around some of these legal issues. I've got two sets of questions, one legal procedural and one substantive. The first one comes directly from your 7.3, which is your relief, and that is to remedy what you say is the incorrect use of the OSP by either seeking the declaration or re-notifying the provisions so that they form part of the Schedule 1 process. So I'm not talking about natural hazard provisions here. On the Environment Court declaration, I presume any party can take that matter to the court. It doesn't just need to be the council, it could be your client or Mr. Hinchy's client or Mr. Keir's client, or it's not beholden on the council to do that, is it?
No, but it is the council's review, and it was its decision.
Yes. And
it's the complexity that that has been created because of that. In my submission, it would be the council would be the most appropriate entity to seek that declaration, or to go to the High Court, whatever decides is the most.
In the absence of that, and you may not want to answer this, do you have any instructions from your client to do that?
No, I don't have any instructions.
Okay. The second part is what you refer to as removing the ultra-virus provisions from the IPI. That's the natural hazard ones, and re-notifying them through the first schedule process. What would that achieve over and above a decision by this panel to make that distinction now? Because presumably people who have lodged submissions to the natural hazard provisions, regardless of whether they are codified as IPI or first schedule. So what would re-notifying those provisions achieve?
I don't think it achieves a lot in practice, because this is a legal issue.
Yeah.
And that's the crux of it. It is, that there is a legal problem here in my submission. Yes. And I think, as we've said in the submissions, because everything has been notified, yes, that's a good thing. And the court might say, okay, well, everything's been notified, so let's just concentrate on the things as a result of these principles, looking at these bits and pieces that look wrong, and that will help you and it might say, look, as indeed the Otago decision, don't re-notify the whole plan, just re-notify the freshwater provisions. So the court might say, don't do that, just do this.
Yes.
And
could the divvying up of the provisions between IPI and first schedule occur through the other legal remedies that you've identified without the need for re-notification?
I think that if you're looking at the Otago situation, I think it's less problematic legally to go from, if it's been identified as IPI and then it's going to be Schedule 1, because the default is Schedule 1. It's the IPI ones that are special. So for instance, your definitions, there's no notation on there. So by default, they must be they must be Schedule 1.
Yes.
And that's problematic because some of them relate to stuff that are in the IPI.
What about for plans? We heard Mr. Whittington earlier in response to the chair's question about plans not having a notification. Is it clear?
Look, I accepted his explanation that generally, a planning map is a provision that stems from something that's inside the main document, and that rings true to me. So, but it's the things that we're not thinking about today that might pop up. It worries me. So don't disagree with that. So yeah, does that answer your question?
Well, I guess what I was trying to ascertain is whether there was a declaration or some judicial review, would that might out of necessity result in a re-notification, or could there be a direction given as to which tent the provisions fall into?
So it's less problematic going from IPI to first schedule. It's probably more problematic going the other way, because that's the special procedure that's got special rules associated with it. Yes. Truncated decision making and no appeal rights, but also the possibility of cross-examination to sort of try and make up for that lack of appeal rights, so that evidence gets examined. So this, let's do it all later, is tricky, because if you get into hearings that are beyond when you've made your decision on the IPI portion of it, then someone's given up their right of appeal and they haven't even had the opportunity to even ask for cross-examination.
Okay. One final, and it's more a substantive question, and it may be that it's more appropriate for Mr. Kyle, but I'll put it to you anyway. And you've drawn a distinction between the way natural hazards are being dealt with in the plan through the IPI process and heritage, and you said that heritage had been divvied up between the two, depending on the spatial area that's affected. And I wonder whether hazards is different, because of all of the chapters in the plan, it's not dealing with effects per se, it's dealing with risk. And hazard is about the degree of risk that the hazard poses and the degree of risk that the activity in those various hazard areas have. So the intersection of the type of hazard and the type of activity gives the degree of risk. And I wonder if that's not different from the effects associated with heritage, and perhaps doesn't lend itself so much to divvying it up between urban and non-urban. It's risk regardless of whether it's urban or non-urban.
Look, I don't disagree with that analysis. I think that risk, those risks have effects. So ultimately it is about effects. Yes. If you look at it broadly. But I think that you can divide up that chapter quite easily into the spatial areas as between the IPI matters and the non-IPI matters. So why wouldn't you? And I think that's what Section 80E instructs you to do.
Yes. We, I mean, hazard is a district-wide rule, isn't it?
Yes.
Are you suggesting that the panel might come up with decisions that are differentiated on the basis of whether it's an urban or non-urban environment based?
Look, it might, and I accept that might be unlikely.
Yes.
But if you're dealing with zones where you have different, like there's no one living there, for instance, you might have a different decision about risk and the effects of it. Okay. So, yeah, but I accept that there's a risk in dividing them up for submitters, and leaving it until that second round, if you like, knowing that you guys may have already consolidated your views about natural hazards through the IPI in principle.
Okay, oh, that's interesting. Thank you for that.
Any more commissioners?
Just one. So if this matter was taken to an urgent, presumably, declaration for the Environment Court, there is a chance the Environment Court may fully agree with the council.
There is a chance.
Wouldn't have gotten any further in terms of these issues that you've raised.
Well, there's a possibility of that. Can't say that there isn't.
Yeah, and I'm just looking at your legal submission where you say, while the panel may not have any ability or power to reallocate, it can raise the difficulties with the council and work with them to reallocate them, which again, to me, indicates that even if you get an urgent declaration, that still looks like a fairly lengthy time frame to sort those out.
There's no doubt that that will take time, but what I'm saying is that this issue is sufficiently important to at least see whether that is a possibility, because it is going to cause a great deal of problem for this process, and there are risks itself in not dealing with it now.
Ask you the same question I asked Mr. Hinchy. Would your client support an extension of time to sort this out?
I don't have instructions, but I can pretty much categorically say it would.
Okay, thank you very much for your input. Dr. Keir. One of the downsides of being towards the end of the batting order is that we've tossed a whole lot of ideas around. So I just want to emphasise that I really don't want you to relitigate or repeat what everyone else said. But do you have anything, from what you've heard, do you have anything that you think that you can add to this discussion? You can see that the panel's grappling with these issues. I think everybody agrees that they're incredibly complicated, incredibly difficult.
Yeah, I endorse that. Firstly, I'd say thanks for the opportunity to present today, and just make an acknowledgement to friends and family in Hawke's Bay. I know you're from Hawke's Bay, Trevor, so thoughts are with those people. You're at the start of a long journey. You're already grappling with some pretty hard challenges, so lots of mahi ahead. To be clear, just for everyone, including those behind me, I'm not a lawyer, so I'm a lay presenter, but I do have extensive experience in policy development and policy analysis. Unfortunately, my partner couldn't be here today, but she is listening in online. I really endorse Commissioner Faulkner's point that he made about getting this sorted earlier. Why wouldn't we try and do that rather than wait for a judicial review to solve it at the end? So I am very much aligned with that and the other, my fellow submitters today in resolving that. We know this is very much a jurisdictional issue you're wrestling with here. However, we're trying to raise the issue of the interpretation, particularly of ATE, and we clearly hold a contrary interpretation. Now, why is that important to the jurisdictional issue? It gives you the size of the problem and how widespread this could be. So in terms of the ISPP, it's important to remember that this was directive and narrow, and it was designed to get councils to implement the NDRS quite rapidly. So that narrowness is what led to the decision to remove appeal rights, along with that testing those standards within the select committee process. The discretion granted in ATE 1B3, we think the council has interpreted very broadly. The law doesn't, while well-meaning grouping things together and dealing with them together as topics, the law isn't set up to allow for that. it is very clear on what can be included and what can't. While that may create some problems, that doesn't mean this distinction should be ignored or things unlawfully included in the IPI. So we don't think that's a huge point. So on heritage itself, we think that's a substantive merits issue, and we don't believe those drafting those laws had the intent that our appeal rights would be removed. So back to the situation you find yourselves in as a panel. One, I sympathise with that. I won't go into the legal details there. We essentially present the challenge to you as commissioners under Section 39 to have a procedure that's fair and appropriate in the circumstances. And to be clear, the circumstances we find ourselves in are one where people have different opinions or different positions on whether those provisions should be included in the IPI or not. Now, including whether they're lawfully included. So should you come to the conclusion that some shouldn't be lawfully included, you have to think about what is a fair process, fair and appropriate process to manage that. So, Chair, you raised an important point early in the session today about the maps and whether those were included in the IPI or not. In some ways, the schedules, while more explicit, are a similar concept. Mr. Whittington presented that the provision, these are what give the provisions the bite, right? These are the things that must exist for the provisions to have the bite. So we're suggesting that those weren't intended to be in the IPI. It's the provisions and the restriction on the MDRS and BSUD policies that were expected to be included. So the Council has interpreted this broadly as a relational link, and we disagree with that interpretation. Mr. Whittington brought up that he thinks in 80E1A that due to policy 4 being included, so policy 4 from the NPSUD. So we again dispute that while it's not covered in our submission. The key word in policy 4 is accommodate, and that word accommodate we think applies to accommodating restrictions to the MDRS due to the presence of qualifying matters. It isn't included to go out and list a whole lot more houses or establish a whole lot more qualifying matters or expand existing qualifying matters. The design of the IPI as it's drafted was intended to come as a variation. It's the fact we're doing these together that is causing most of the issue, but it wasn't a carte blanche include anything related or relational in the IPI. So we think that's a mistaken interpretation. 2 more points and then I'll throw it to you for questions. So in terms of the reasonable opportunity to challenge issues with the IPI allocation, we were only notified on the 18th of July that our house was scheduled for listing. So all those decisions having already been made, we had no information, or we had no idea to know we were affected, and then we had no information on how to challenge those other than our expectation of raising them with this hearing panel. We also, Mr. Whittington and the Council's frustration with the appeal rights in the Environment Court, we don't think are relevant. We've put a 100-page submission in, an 80-page further submissions and multiple subsequent submissions. We are most certainly putting our best foot forward. I'll throw that to the panel for questions.
Thank you, Dr. Keir. I only had one question I wanted to tease out, and that was what I was discussing with Mr. Whittington. Section 80E is framed really oddly. You have the things that must be in an IPI, then it has, as you pointed out, a general provision about related provisions, and then section 80E2 says, and related also means, and there's a great long list that includes all the that includes qualifying matters. Now, that appears on an initial view to have been added in because in the select committee process there was a lot of argument, well, that the IPI provided for was too narrow and it needed to include related provisions. But the definition of what's related is incredibly long, or potentially related. And so the interpretation issue to me is, well, is this just saying add all these other things as well?
Yeah, so I guess my view there is that must be included is very directive. You know, that's what the IPI is about. And you're right, this discretion got added later because of the feedback from submitters, including councils, on the implications of having that just implementing the MDRS. So what they were trying to avoid was the fact that you'd immediately have to do a first schedule code change after the IPI was implemented, bearing in mind they didn't anticipate them being done together, to remedy this conflict that would exist between existing plans and the IPI. So it's like, well, that doesn't make sense. We'll be pragmatic. And yes, you can include related provisions that were clearly conflict. Now, the key words there, while there is a long list of related provisions, it is quite broad. The key words there are the test for which they are included. They must either support the implementation of the MDRS or be consequential on the MDRS. So those two words we've tried to expand on in our submission. In terms of the interpretation, we believe the council has misinterpreted consequential on, which means because of the MDRS, there is a resulting conflict, rather than of consequence on the MDRS being a policy or a legal consequence on restricting MDRS. It's the conflict they're trying to resolve. So while related provisions that meet that test can be included and that list is long, it isn't a broad discretion to say bring in anything that's at all relational to the MDRS.
I suppose the question I had is, while I understand that's your argument, the way 80E2 is framed seems to be independent of that test on consequential on. It says, I've got it in front of me, but it's something like, and related also means, thanks, what the question says, in subsection B2, related also includes.
Yes, but 1B3 defines when related is applied.
Yeah.
So 2 applies.
So, yes, so you're saying, well, you insert that list into 1B.
Yes.
1B3.
Yes. 1B2 seeks to clarify what related can be in relation to that clause.
Thank you. Any questions on this half of the table? On that half of the table?
Just, sorry. Hi. You thought you got over it. No, just you're not debating that section 80E2, whatever it is, E, that historic heritage is a qualifying matter.
No.
You're not debating that at all. Can you just clarify for me what you are debating, how that relates to your concerns?
So it is, B3, 1B3, which is those words support and consequential on. So that's the test you must apply to the related provision. So for example, delisting the heritage protection of the Wellington City Library or the Michael Fowler Centre or the Civic Centre, you could argue is supportive of the MDRS because it will then apply to that zone. However, expanding the protection by listing our home or others isn't in support of the MDRS, and it's not a consequence of the MDRS. Right? It's entirely unrelated. Yes, if they are listed, the provisions, the heritage provisions, would apply to our property. We're saying the listing of our property should go through the first schedule process.
Just on that, but isn't the schedule the reason why there are the rules that apply to a particular property? So they're linked rather than being supporting or consequential.
Sorry,
well, the fact that it's a listing,
yeah,
that's the basis for having the rules that apply to a particular property.
Well, no, the rules apply generically to heritage. That's a plan-wide matter. The identification and listing of heritage, I would see, is a separate issue. If our house had always been listed, or had been listed in the OPD, then it could be in the IPI.
It's the fact that it's listed that those rules apply to it.
But it's that was notified at exactly the same time. So it kind of, the consequential on meant it had to already exist. So you're saying it was listed because of the MDRS?
No, just that it's part, they're inextricably linked is what I'm saying, the listing. Because you listed the heritage rules and that's a qualifying matter.
Yeah.
Which you've agreed is a qualifying matter.
Yes, but I don't see the identification as linked as you do. I think the identification and listing of heritage is a substantive merits issue and should proceed through the first schedule process. I don't see it as a consequence, that listing, because the MDRS is being implemented.
Okay.
In that case, we'll hand over to Ms. Wong.
Sorry. So just further to the question was just asked, your issue is because your house is a new listing, so you have no issue with what was in the operative district plan and being already listed, should I say, but your issue is because it's a new listing, you now don't have the opportunity to argue that whether or not your house should be on that schedule. Is that correct?
Beyond this panel, right?
Yeah.
So it's the intent of the IPI, what it was put in place for, and then it's that test of does it support the MDRS or is it consequential on? So I agree the policies support the MDRS and are related, but I don't see that the mapping, the schedule, or the areas or the maps are consequential on the MDRS.
Thank you.
You're saying that you don't have the chance to actually argue your case if it's listed or not because it's in the IPI. If I understand that right?
Well, we lose our appeal rights on the decision. Yes.
Do you see that because you just said, the only place where you can argue it is before us. Do you see you have an opportunity to actually argue your case in stream 3?
Yes.
Where heritage is actually discussed.
And we will be dealing with that here. The main point in this session is the breadth of the use of that discretion and therefore how complicated it makes your jurisdictional decision. Because this won't just affect the thing that we're mostly concerned about.
I look forward to seeing you in stream 3.
Thank you very much.
Irrespective of the outcome of this discussion. Wow.
And can I introduce myself by giving you a little pamphlet about
I just repeat the point I made to Dr. Keir, and you suffer from even more of being absolutely the last, and we've been around the houses, so please, and while I know it's not your fault, we're way over time, so if you could focus on the extra things you can add to our discussion that we haven't already heard, we'd appreciate it.
Okay. Kia whakatamuri te haere whakamua. I walk backwards into the future with my eyes fixed on my past.
and we acknowledge Historic Places Wellington, the historic people of this place. We submitted, Historic Places Wellington submitted on the NPSUD during lockdown in 2020 itself, and before that in 2019. And we also submitted on the Enabling Housing Amendment Act. And we do not oppose intensification. We do support a compact city, and that's contrary to the Section 42 report, which twice says that we oppose the NPSUD. It's not correct. We've submitted on every round of the spatial plan and the district plan preparations, and apologies for taking your time, but it's taken me a lot of my time over the last 3 or more years. Commissioner McMahon is starting to differentiate IPI and regular Schedule 1 between whether it's an urban zone or a non-urban zone, and we would reject that fully. We agree with the SNA analogy, Mr. Chairman, that you made. The best way to think about the MDRS in an urban context is an underlying provision, something that exists if you are allowed to do the activity that you want to do. If you do want to do the activity, you can build 3 houses to 12 metres and the height boundary provisions. Heritage is something like an SNA that's a precursor to whether you're able to do that. We, Historic Places Wellington, will be seriously prejudiced by the IPI process. We will lose our appeal rights. The extent to which the plan change gives effect to the MDRS and to policies 3 and 4 is relatively straightforward if just a plan change is being done to implement that new policy and legislation. And I would encourage you to look at what Auckland's doing with their Plan Change 78, which incorporates the standards enabling 3-storey housing in relevant urban residential zones and implements qualifying matters to reduce the height and density of development where necessary to accommodate the features and values where full intensification is not appropriate. And what Auckland is doing is simply slotting in their existing heritage chapter and their existing heritage rules into Plan Change 78 doesn't change them in any way. And in that respect, I would support fully the previous speaker. When you're changing the size of a potential qualifying matter, and that is having the effect of losing appeal rights, I think citizens feel seriously about that. Wellington's the only city, the only Tier 1 city that's creating an entirely new plan. But that's an administrative convenience. And in fact, Historic Places Wellington wrote to the City Council in August 2020 when they embarked on this, and we said the NPS changes things.
As well, can I just ask you to focus on the jurisdictional issue? Can we change things that are in the IPI so they're not, or in reverse, and if so, why? Because I understand you've got a much broader case that you'd like to advance, but now's not the time.
Okay, I think that you have the clear jurisdiction. I think it made practical sense for the legislation to apply a limited discretion for what may be in the IPI. And I think you, as the panel, considering both of the 2 separate planning instruments, have the ability. The technical detail of whether you add a provision and then add if you like, add the exact same provision to one side and delete it from the other side, you know, I think that's you're entitled to consider the technical aspects of how you achieve that. But I think you do need to take account of the fact that these administrative problems for submitters have been created by the City Council's bundling decisions. They took two bites at the cherry to try and resolve the issue. They asked the Select Committee to specifically legislate that the Wellington Plan was all in the IPI, and the Select Committee rejected that. And in fact, the Select Committee adopted, Section 80G1B, which said that the IPI, a TA, must not use the IPI for any purpose other than the uses specified in Section 80E. So I think it was clear then that this issue of appeal rights and the burdensome consequences for submitters was very much in the fore. The Council's second bite of the cherry was to ask the Minister if he would let them bundle the entire plan into IPI, and he rejected that. I think councillors specifically rejected the idea of exercising their discretion. They decided that they would only use the IPI for the minimal that was required by the MDRS. And I think the broader policy goal is to allow citizens the rights of appeals. I think it's manifestly unjust to remove appeal rights without a sound foundation in law and policy. So I would endorse what other submitters have said about the seriousness of the situation with which you're confronted. Thank you.
Thank you. I didn't have any questions, Commissioner McMahon.
Mr. Chairman, I don't have a question, but I think it's important that I state for the record my position that's been outlined by Ms. Wong. I'm certainly not advocating for the divvying up of or the delineation of heritage based on urban and non-rural. I'm simply exploring with the Weil Council an issue as to the comparability of that situation with hazards. So as a member of the panel on Hearing Stream 3 heritage, I think it's important that I make that clarification. So that's just for the record, it's not a question.
Yep, and apologies if that was misunderstanding that. Thank you.
Side of the table. The other side of the table. Well, thank you, Ms. Wong. As I say, the downside of being last is we think we've asked all our questions, and but appreciate your taking the time to come and talk to us, and we'll look forward to seeing you later in this hearing and probably back with boots on in Stream 3.
And 2.
And 2.
Thank you.
Well, that's the end of the procedural argument. I want to talk about how the panel intends to proceed from here. We've got multiple suggestions as to what we should do. The one that resonated with me is that we need advice. For that reason, the eagle-eyed among you may have noted that Mr. James Winchester has been listening from online. Mr. Winchester is a barrister from Hawke's Bay and has returned from his labours shoveling mud and cutting trees that have fallen over. Mr. Winchester is the panel's independent legal advisor, and the way that the panel proposes to proceed, mainly because we're now going straight into the balance of Stream 1 and we won't have time and mental bandwidth to consider all of the positions that have been put to us. So the panel is going to ask Mr. Winchester to provide us with legal advice that will be available to all. The panel will then issue a procedural decision on those matters that we think that we can issue a procedural decision on that takes all of these matters into account. I think the good thing is that the issues that have been canvassed don't come sharply into focus in Stream 1, so it doesn't affect how we'll run Stream 1. They came much more sharply into focus in subsequent streams. So we have a little bit of time to think and come to an outcome, and we're going to use that time. But that's how we intend to proceed. As I say, the next thing you see will be Mr. Winchester's legal opinion, and it will be followed by a procedural minute from the panel saying where we've landed. Having occupied almost an hour more than we thought, Mr. Wellington, we should turn to the presentation of the Section 42A report.
Thank you very much. In the interests of time, but also because I don't know that there's an awful lot I can add to the issue that I was asked to discuss, which is the Johnsonville train line, I think I should just hand over to the witnesses themselves for you to question and for their presentations rather than taking up time.
Just check my notes as to whether I had any questions on that brief. Sure. Oh, yes. A legal question, Mr. Whittington. In the nicest possible way, what weight should we give MFE guidance publications issued after the NPSUD seeking to influence how it should be interpreted?
I think the weight that your question implies. It's something that you may take into account, but it's hardly going to be determinative of the position. The fact that it happens to align with the position taken by Mr. Wharton is really neither here nor there in one sense, but it's not irrelevant to your decision, but nor is it by any stretch determinative or decisive.
Next question. You say that you agree with Mr. Wharton on the interpretation of the NPSUD as a definition of rapid transit, that it's where it says it's a rapid transit service means any existing or planned frequent, quick, reliable and high capacity public transport service that operates on a permanent route largely separated from other traffic. How would you normally interpret a definition that had multiple descriptors separated by and?
Well, I think the point is that, let's say you had a rapid transit line that for whatever reason the first 5, 6, 7 stops on the line were high capacity, reliable, quick, and then for whatever reason the last couple of stops were not one or more of the descriptors. That doesn't make the entire line not a rapid transit service.
I don't think that's how Mr. Wharton was interpreting it. He was saying as long as it's frequent, reliable and high capacity, it doesn't need to be quick.
Well, you can ask him that question, but
I'm asking you about how it should be interpreted, because that's a legal question.
Yeah, well, I agree with him. I don't read and as in that sense requiring it to be all four along all parts of the route at all times to be a mass rapid transit service. If it's reliable and let's say, because one of the issues here is there's no standards to determine what quick is. Quick isn't defined as a particular speed of train or a time of duration between stops or anything like that. But one thing you could do is determine what standard you want to apply to that before you apply it. Now, if it meets all of the criterion and almost meets the fourth criterion, in my submission, it would still be a mass rapid transit service. I don't see it as being a must meet all four at all times. And that's a matter of interpretation. There are lots of examples in the statute books where the word or means and the word and means or.
But the starting point is that if it meant that, it would have said all.
Probably. But when you need to read the definition as a whole, and I certainly don't interpret it as I say, requiring all four at all times for the entire length of the line.
And so any questions from Mr. Wellington before we? Well, in that case, we'll hand over to Mr. McCutcheon.
Good morning, Commissioners.
Good morning, Mr. McCutcheon. How do you want to proceed? Like you've got a very substantial report that you and Mr. Wharton co-wrote, but in defined chunks. You have an overview report. Do you want to address this first on the overview report and then go to the second report, or give us a combined introduction, or how do you want to do it?
What I'd like to do is give a short introduction, setting some context for where we are today and how we got here, and then open myself to questions from the panel. So, good morning. My name is Adam McCutcheon. My role is that of Acting Manager of the District Planning Team at Wellington City Council. I hold the qualifications of a Master of Planning with Distinction and a Bachelor of Arts in Geography from the University of Otago. I'm an intermediate member of the New Zealand Planning Institute, and I confirm that I'm continuing to comply with the Code of Conduct for Expert Witnesses set out in the Environment Court's Practice Note 2023. I am the author of the Section 42 Overview Report, as well as the primary author of the Section 42A Report for Hearing Stream 1. I'm pleased to be with you here today as we start hearings on the Wellington City Proposed District Plan. This is the latest stage of an extensive program of review, research and engagement and policy development on the Council's Planning for Growth program, dating back to 2017. The program has included the development of growth scenarios in 2019 and a 30-year spatial plan and draft district plan in 2021. Cumulatively, over 5,000 submissions have been received on these documents. The Planning for Growth program was developed to respond to changes and challenges the city is facing and to leverage the opportunities presented by them. These included a growing population, infrastructure assets under increasing pressure, a rapidly changing climate, the city's vulnerability to seismic impact, and a natural environment and Indigenous biodiversity under pressure. Consultation and engagement has given rise to 5 city goals. These are compact, resilient, vibrant and prosperous, inclusive and connected, and greener. When the spatial plan was ratified, a 6th goal of partnership with mana whenua has been added. These goals have been central to each stage of the Planning for Growth program as it reflected and brought together community feedback how trade-offs, tensions, and options for navigating growth and change can be managed. The proposed district plan is a step change in the city's planning settings. The current operative district plan was made operative in 2000 and has seen over 83 plan changes since. The proposed district plan takes an integrated approach to managing land use in the city, working towards the city's vision of being an inclusive, sustainable and creative capital for people to live, work and play. It does this by attempting to strike a new balance between growth and change, enabling development, while also retaining those natural and cultural values which Te Whanganui-a-Atara is known for and are important to the community. It has been informed by extensive engagement with Council's mana whenua partners. National direction, as we have discussed at length today already, has been a key determinant in some of the proposals of the plan, particularly the National Policy Statement on Urban Development 2020. This hearing addresses the planning processes which this plan is following, matters of plan-wide importance, such as the high-level approach of intensification, walking catchments, and rapid transit. The strategic direction chapters, which provide a high-level framework upon which the rest of this plan is based. The introduction and general provisions, and those definitions which have relevance across the plan. I have recommended changes to the plan as notified in my submissions and supplementary evidence. My recommendations are focused on achieving increased consistency with national direction, regional direction, and Council's own policy direction, achieving better internal alignment across the plan, and acknowledging that the plan can do more to reflect the aspirations of mana whenua. I have not recommended wholesale changes to the strategic direction of this document, and consider that with some amendment, it will contribute better towards achieving the city's vision. There is much more to come in this process and many chapters to be considered over the next 18 months, and it starts with the framework we establish here in this hearing. I consider my 42A and supplementary evidence as read, and I map the panel's service.
Thank you, Mr. McCutcheon. I think we'll start with the overview report. I have about a small number of questions on the overview report, and then I'll invite my colleagues if they have any questions, and then we'll go into the principal report. First is really satisfy my curiosity, having lived in Karori for 32 years. We say in paragraph 27, talking about the suburb's significant infrastructure issues, prompting a strategic decision for no additional intensification over and above the MDRS. What are those significant infrastructure issues, please?
That being that the Three Waters capacity of Karori is already beyond capacity. And the response from Council was that in this spatial plan, a sequencing of investment in the Three Waters network be undertaken. Preliminary investigations are underway already, focused on the inner city and the corridor down through to Newtown as well as Johnsonville. Karori is in the 20-year plus category for when those investigations will be able to result in any infrastructure investment in that area.
And are there any others areas of the city that we should be aware of that are so far out there in terms of 20 years plus in terms of infrastructure, already over capacity for infrastructure and not planned to be fixed anytime soon?
Not to the same extent as Karori.
Next question, sort of paragraph 59 said it's been struck out. Has that process followed its course? Are those strikeouts now beyond objection?
I do not know the answer to that question straight away, but I can get back to you on that one.
If you could note that down, I suspect I should make a point more generally. We will ask you many questions on these reports. We do not expect you to have the answer at your fingertips for every single question. But we would appreciate you noting those questions where you haven't been able to answer and reverting. Our hope would be that you would be able to revert relatively quickly. In some cases, where the question is a matter of relevance to a particular submitter, it's going to be important that the submitter knows your answer. In other cases, the answer could wait until Council's reply. I suspect that most of issues will be in the latter category, but to give you an early heads up, the Commissioner's intention is that at the end of the hearing, we are going to go into conclave and we're going to emerge probably with a number of questions that we will ask you to reply on. The council is, of course, free to reply on anything it wishes, but we will ask you, among other things, to answer our specific questions. Next, I have a general question, paragraph 72, about change 1 to the Wellington Regional Policy Statement. Do you have any general comments about what weight we should give to that document at this point of its process in the first schedule?
We'll also seek Mr. Whittington's advice on this response, but as I've outlined in my Stream 142A document, a number of provisions of Plan Change 1 to the RPS are in contention and have submissions received in opposition to them. They may, of course, change throughout this process, so I have advised that it can be considered, but the level of weight will depend on whether those provisions have any submissions in opposition and have scope to change or not.
I should say that, as you're aware, 2 of the commissioners, including myself, are on the Pairaroa panel, and the advice the Pairaroa panel has received from the Section 42A author was somewhat more pungent in terms of the quality of the regional council's efforts and the weight that should be put on them. Then your somewhat guarded, but I'm not saying inappropriate response. That's what's triggering me. Commissioner?
Well, I'm just wondering how the legislation might assist in Mr. Whittington. We've got to give effect to a operative regional policy statement. What about a proposed? What does the legislation say about proposed regional policy statements?
I'll just check that directly against.
Have regard to the statutory test.
But that's right. It's have regard to. That brings in the usual principles about weighting. What it means to have regard to. Weight is ultimately a matter for you.
Yes.
There are principles about how much weight should be put on a proposed plan when it's early in the process, when it's subject to challenge, and all of the sorts of matters that Mr. McCutcheon's raised.
Yes. I wonder if Mr. McCutcheon could just let us know briefly what stage that change to the RPS is at. Have there been further submissions called for?
Yes, further submissions have been called for, and a summary of those further submissions is available online.
Okay.
I understand hearings will be occurring shortly. The timeframes of that process and this one, of course, overlap, as do many of the IPIs within this region.
Yes. Okay. So it could be some time before we get decisions, which would then have legal effect.
Unless they're appealed.
Unless they're appealed, yes.
Correct, and that's why for some of the recommendations in my 42A report, like with the definition of regionally significant infrastructure, whilst that is relevant across this plan, I recommend that we take a somewhat slower approach to adopting a new definition or responding to submissions on that basis.
Thank you.
Are you able to say if there are any provisions in that change that have been submitted on in terms of weight?
I cannot answer that question. I can get back to you on the answer, but
yeah. I think that's for the council reply.
It'd be quite significant.
My change 1's a very substantial document.
As I understand it, though, you have heard advice somewhat less diplomatic than my response about that document, which may mean there are a number of changes or submissions in opposition to it.
Next point, also a question of weight. Draft NPS for Indigenous biodiversity. This is like the proverbial mirage that seems to have been hovering on the horizon for at least 10 years. What statutory weight can we give a draft NPS?
The proposals, the provisions in the proposed district plan for significant natural areas had been developed looking at a high level to the direction that was provided within the draft MPS, but noting that we don't have an actual MPS out yet. You can consider it, but a great deal of weight. I would not recommend placing a great deal of weight on that draft document.
Others have argued in previous hearings to me that we should give precisely zero weight to that particular NPS, given the extent to which it's sat on the table and gone through various iterations. You wouldn't go that far?
Well, those other people are correct that there is no MPS in force yet, hence it can't be considered. I mean, contextually, throughout this process, we have had a number of discussions with people around whether there is any case to manage significant natural areas or not in this plan. I think that is clear that there is, but it is a matter for you to consider whether you accord any weight to a draft MPS. I would be rather cautious to do so.
McMahon, you had a question?
I just wondered, Mr. McCutcheon, whether you might want to revisit some of your wording then in paragraphs 110. You say it cannot be heavily relied on. I mean, would you go as far to say that it can't be relied on at all?
And be given only little weight because they're not sort of a double negative.
Yeah, I agree with Mr. McMahon's statement on that one there.
Yeah. What follows from that though, and I mean the rumour mill is rife. I've heard that the MPS is imminent, and that it could be notified in the next month or two. It's certainly within the period in which we're making decisions or recommendations. And I just wondered, well, I guess this question more for Mr. Whittington. What's the scenario then, Mr. Whittington, if the MPS comes out in the middle of the hearings before we've issued any of our recommended decisions? What's the obligation on the panel then to consider that?
Well, if it was to come out in the next couple of days, it may well be that there was something we could do about it. If it comes out after you've heard all the submissions on the relevant points, then in my submission, it's the sort of thing that you could have regard to, but not necessarily seek to implement with the council to then have an obligation to notify a variation.
But is that the legal test? I mean, don't we, if it comes out and we haven't made decisions, don't we have to consider how the provision of the plan give effect to that MPS?
Yes, but then there becomes significant natural justice issues for submitters who have submitted on one basis. Then the NPS comes out, and if you decide to effectively disregard what you've heard and do something different, then there's a natural justice issue that arises.
We would clearly, like in terms natural justice terms, we would clearly need to give anybody who's already been heard the opportunity to provide, to explain how the new NPS impacts the submissions and the evidence they've already made.
That's right. And so given that we're under, I suppose it depends on which provisions it may be, whether it's in the IPI or the Schedule 1 process. But if it's in the IPI and we're coming up on the statutory deadline and you have decisions that are mostly drafted, then I would suggest that it's better left for a variation. It may well be, as I say, if it comes out reasonably soon, that there is something else we can do about it. But it will have to depend on when it comes out and what's feasible at the time.
The advice that I've been given in a different forum, and that's the new Plymouth District Plan, where prior to decisions being released, the MPS on highly productive land was released. Mm-hmm. The advice was that we had to reconsider our draft unreleased decisions in light of that. But it also talked about giving effect should be fettered by the ability created by scope to give of submissions to give effect to that MPS. And I wonder if you had a view on that.
Well, that sounds logical and correct as far as it goes.
Yeah. Because you can only give effect to the MPS to the extent that there's scope to do so. Now that might be different for the IPI.
Yes.
But for the first schedule process, it's quite clear, isn't it?
Yes, I think that's right. But again, it depends on the timing. If you're proposing to release a decision the following day and then it comes out unexpectedly,
Yes.
I'd suggest you should just notify it. And other than
Keep your head down. Irrespective
I don't think it's a hypothetical question. I think it's highly likely to come out in that time frame.
Yes.
Well, June will be the cutoff, I imagine.
Yes.
Being an election year.
I mean, maybe this is again a question where we go back. I go back to the legislation, and in the council's reply, we provide some specific advice on that. But I certainly don't immediately balk at what you're saying has been advised in New Plymouth.
And where it gets traction and bite is in the topic that the chair indicated right at the beginning on the SNOs.
Yes.
And if you're looking for some law, you could read the High Court's decision on the Ruataniwha Dam, where exactly that position came out, where we had I was running the case for the respondent, and
yes.
A new NPS emerged while it was before the High Court. So Justice Collins addressed the extent to which the Board of Inquiry, having decided it would be referred back, discussed the extent to which the Board of Inquiry had to consider the new the new NPS.
Yeah.
And it also came up in the Horizons 1 plan. Justice Kosher issued a decision again about an NPS FM version that emerged. I think it was while it was in the Environment Court, and the Environment Court followed your advice and put its head down and just kept going.
Here's a question.
Commissioner Dash.
I think most of it was covered by Commissioner McMahon's question, because I'm also involved in the Selwyn District Plan hearings, and the MPS HPL is front and centre, and that has come in partway through the process. And in that case, it was about halfway through, and so a separate 42A report on the implications of the MPS HPL came out, and any parties in the process were able to give their views on the applicability of it. And so I see if the MPSIB comes out, then and it's partway through the process, we'll be obliged to consider it in our decision making.
Just want to clarify that with respect to the significant natural area provisions notified in the proposed district plan, they won't be heard until February next year. So ironically, time might be on our side with respect to the notified provisions.
For once.
Yes.
That was all I had on the overview report. Any Standing Commissioner Fuller?
Just a general thing. The background to you provide leading up to this is primarily focused on both. This is collectively this is a full district plan review. There have been, this is just confirmation really, there's been no shortcuts in reviewing any other provisions of the plan, just to focus on growth. There's a full and comprehensive review of all provisions in the plan.
That is correct. So the focus of the proposed district plan is not just to respond to growth. It is one of the big drivers. Mr. Lees will be speaking to us today later on about population growth, but it also responds to the climate change emergency that Council declared, the statistics around the natural environment being degraded, and the need to manage pressures on our infrastructure. For example, there are no outstanding natural landscapes or significant amenity landscapes in the operative district plan. The proposed district plan seeks to remedy that. There's only a very high level touch on natural hazards in the operative district plan, focused on flooding in Tawa in the fault line through Thorndon. The proposed district plan takes a city-wide view to managing those hazards. So this is very much a full proposed district plan.
And the draft plan that was notified, was that a full plan, including heritage schedules?
Great. I suppose I should ask you, since Dr. Keir is sitting there, did that include, it included all the heritage schedule, did that include, the draft plan included
Proposed new listings were included on the draft district plan.
There are no new ones that weren't in the draft.
Council has made submissions to include new heritage listings through.
But none were notified.
I don't believe so. That people that were not listed on the draft district plan. I will seek to confirm that with you, though.
I think that you should, given that Ms. Wong clearly thinks you're wrong. So we'll ask you to confirm whether there are any new heritage listings in the notified plan that weren't in the draft plan.
Correct.
This half of the table overview report. Commissioner Dash.
Leading on from the previous discussions about SNAs, your overview report has identified a number of significant issues that you anticipate through the plan, and one of those is significant natural areas and the numbers of submissions and so forth on those. But the actual body of the 42A report on this hearing stream itself has very little discussion about SNAs at all. Is that deliberate, or is it just not a strategic issue for the city?
So this overview section 42A report is intended to set the context for the entire process which we're working through. So not all of the matters outlined within it are addressed within stream 1. SNAs is an example of that.
Okay, so it's not a strategic issue then? As manifested
within the stream 1.
Strategic objectives.
The matter in contention is whether it should apply to residential areas or not. That came through submissions. That was not what was proposed in the plan at notification. That issue is not being dealt with in the strategic direction chapter now. It will arise and you will hear submissions on it, and you will make a determination about what you're going to do about it in light of perhaps a new MPS comes out during that time. You will make that call in February 2024.
Okay, thank you.
Any more on overview report?
I'm interested in that answer, Mr. McCutcheon. And we're getting into detail here, and we'll deal with that this afternoon, but your answer that you just gave is a little bit at odds with strategic objective NEO1, which doesn't distinguish between urban and rural Indigenous biodiversity. And so it might be arguable that that there are no provisions to implement NEO1 in the district plan as they relate to both urban and rural. What would your response be to that?
My response to that is on the 23rd of June last year, Council decided that it would not include significant natural areas, the mapping of such, on residentially zoned private land. There are SNAs on publicly owned land and on privately owned land that is zoned any other zone than residential.
Yes. Probably it's not wise for me to take that much further.
I think that's an issue for stream, is it 8?
8, February 24.
An issue for another day. I think we've got enough issues to deal with today. I think that's the overview report. Now moving on to the, I did have one overview question. I've written on the front page of my overview report, so I didn't notice it today. The witnesses for Kaingaora have highlighted a 2019 report, Planning for Growth District Plan Review Issues and Options Centres, and have observed that that's not publicly available. Council's submissions are seeking an order that we direct that it be made available. Can we start at the outset and say, is there any reason why it's not publicly available that we should know about?
So dating back to about 2018, a number of issues and options reports were developed by council staff. It was based on monitoring of resource consents, discussions with the resource consents planners and urban designers to really get across what are the issues or with the operative district plan provisions, and look at options for how they could change to address the at that time 5 strategic goals of the Planning for Growth program. None of those are available online. The centres one we are getting put online in preempting this conversation coming up, and given that Kaingoa raised it in their submissions. They're documents that are of their time, so they were written before the MPSUD, so clearly looking at them now, they look quite out of date and sort of not representative of the proposed district plan as it is notified, given the timing of when they were developed.
So the punchline is KO will get it.
Correct. They will be made available. Oh, the centres one will be put online.
Now, going to, we have 10 minutes. I think I don't think we want to talk about the allocation of topics ISPP versus part 1. I think we've done that to death today. And at the point when we've decided whether we have jurisdiction or not, we will confront that. I think what I want to do is deal with your report section by section. And so that ISPP was 4.1. Well, maybe I should ask, did anyone have any questions prior to section 4 of the silence seems to be the first one we come to is the growth approach of intensification. Any questions on section 4.2, team? I don't. Start with Mr. Dash. Go in this direction, Mr. Burge. Silence. Well, that's easy. Now we come to the classification of rapid transit services. We have Mr. Wharton is in the chair, and this in 4.3 and 4.4 are your baby, Mr. Wharton.
Firstly, Chair, should I briefly mention that that document that you just mentioned in the previous point is now online, and the supporting documents, and will be the link will be shared with Kaingoa.
Yes, that'd be a good idea. Tell them it's there. Save us a lot of trouble. Are there any preliminary, like Mr. McCutcheon's given us a general intro on the section 40, is there anything, any preliminary comments you want to make before we start into questions on 4.3? Because as I say, what I have in mind is we'll do questions on 4.3, which likely to take some time, and then questions on 4.4, which is similarly likely to take some time.
Yes, Chair and panel, I do have just a brief introduction to summarise the topic of both 4.3 and 4.4. So I'll run through that.
You have the floor. And looking at the clock behind you, you have exactly 10 minutes before we stop for lunch.
I'll aim to do it in 7.5.
It's a walkable distance.
It is. So, good afternoon, panel and commissioners. So my name is Andrew Wharton. I'm a principal advisor planning at the district planning team here at Council, with 17 years experience in planning and resource management and district and regional councils at Ministry for the Environment. I do want to clarify I didn't work on the MPSUD specifically, and had a short stint overseas in land use planning and engineering consultancy. I've worked on district plans, regional water and coastal planning, resource management reform, planning standards, and urban and transport planning. I've worked at the council for almost 3 years on their spatial plan, district plan review, and also contributed to Let's Get Wellington Moving on their transit-oriented development, what they call their transformational program, and also just general planning advice. So in the Section 42A report, those two sections referenced, I've reported on the submissions relating to rapid transit, mainly the Johnsonville line, and walkable catchments under the MPSUD, and also the supplementary evidence related to evidence tabled by submitters experts. The main submission topics were on defining the rapid transit stops and services, Let's Get Wellington Moving, whether the Johnsonville line is a rapid transit service under the MPSUD, then walkable catchments around rapid transit stops, including possibly the Johnsonville line, walkable catchments around the centres, so city, metropolitan, town and local, and potential walkable catchments around Wellington Hospital and Victoria University, Wellington. I've included some general discussion on the walkable catchment methodology from more of a planning perspective, but I'll rely on Ms. Hammond's evidence on the methodology from a technical perspective. So yes, just some general comments and highlighting some important considerations. So as you'll be well aware, the questions on the Johnsonville line did generate the most submission points out of these two topics, both for and against. In theory, categorizing rapid transit lines should just be a question of fact. You know, does that meet this definition or not? But because it's tied to the directions to enable 6-storey buildings within these suburbs, both council and submitters have considered the balancing values and planning outcomes as a result of this direction. I acknowledge and respect that the council, when they notifying the proposed district plan, decided that the Johnsonville line would not be classified as rapid transit in the plan. I assess submissions opposing this decision with an open mind because the question is around how to interpret the MPSUD national direction, which council policy must give effect to. So I had to consider more broadly because of that obligation to consider that direction. So in the Section 42A report, you'll see I've considered the rapid transit definitions, guidance from other sources, alignment with MPSUD objectives, and the individual descriptors within the definition, as well as regional and strategic integration. And I may just take the opportunity, since the chair raised it, just to clarify my comment in paragraph 174, where I say, in my opinion, if one of these descriptors happens to not apply to a portion of the service, this is not necessarily a fatal flaw that rolls out the whole service, and I explain why. So in that comment in 174, I'm not saying that a service does not need to meet one of those descriptors. I'm saying that if a portion of the service happens to not maybe fully meet one of them, and the example that is evident in my evidence could be Rara. If someone's wanting to travel from Rara Station or Johnsonville Station to Wellington Station, they may be able to get there faster by car or perhaps by a bus from Johnsonville. And this is common not just for Johnsonville line, but for other lines as well. For example, if you're wanting to travel from perhaps Pukura Bay or the Kapiti Coast to Porirua, just looking at times, that might be faster to take a car at certain times. So I guess all I was trying to say in this is, given the general descriptive nature of this definition without measurements, that it would be a mistake to be absolutist about it, given how it's generally applied to other lines as well, including in Auckland. That's as far as it went. I wasn't trying to make any legal claims about one descriptor should not be applied or not. I also just want to raise a point that the submitter experts, Mr. Wignall and Mr. Helm, have made about the One Network framework. I'm grateful for them to point out that that advice was updated in November last year, which removed the assumption that all metro rail corridors and other public transport dedicated corridors are rapid transit regardless of vehicle volume. Instead, it's added in a new standard saying that the indicative vehicle volume of 4 more services per hour bidirectional. So I've updated my commentary in the supplementary evidence, and I note that there are commenters, experts here who will present, both Mr. Georgeson evidence saying that he believes that the Johnsonville line does meet that new criteria, and Mr. Hellman, Mr. Wignall, who say it does not meet that criteria. I did point out though that the ONF, in my view, is not determinative for the rapid transit criteria as it relates to the district plan. It's a tool that Waka Kotahi and councils use to establish transport function, performance measures, operating gaps, and potential interventions. So it's useful guidance, but it's not determinative. So my conclusion in this report was that the Johnsonville line should be classified as a rapid transit service under NPSUD, but whether it is or is not as clear as it could be for say the Hutt and Cutten lines, though you will hear many submitters saying that it definitely is, many submitters saying it definitely is not. And you'll hear evidence lining up on both sides. So because of this uncertainty, I've included 2 alternative recommendations in the 42A report if you decide that it is or is not rapid transit. So if you decide it is not, I've included a recommendation to support the notified plan's zoning pattern with a relatively minor change from 11 to 14 metres building height in the wedge and Kandala, which I don't think is consistent with our overall approach towards zoning land centres. Got time. Quickly moving on to walkable catchments. A point of key dispute is whether walkable catchments can be less than 10 minutes given the Ministry for the Environment guidance on the matter. Interesting given the conversation so far. The Ministry of Environment guidance does give just recommendations and has various references to not just, they do say 800 metres should be a minimum, but then they also talk about 400 to 800 metres should be suitable for most tier 1 urban environments. And then they refer to the Ministry's toolkit for urban design, which uses 5 to 10 minutes. So I think that is consistent with their advice as far as that goes. Also, just wanted to mention that we do have other rapid transit catchments, and for the Tawa line, Council recommended that there be 5-minute catchments around Linden, Redwood and Takaku road stations. I've recommended that they be expanded back to 10 minutes as a standard walkable catchment. And one of the key reasons for that was that, as well as MFE guidance and neighbourhood conditions and other shops, was that I didn't find any submission points actually supporting the 5 minutes, and even going to the submissions from the various community groups and Ratepayers Association business, none of them really mentioned issues around density related to the distance of walkable catchments. Instead, there were a number of submissions asking for it to be larger. So that was a key factor in that determination. The last point is Kilburnie Metropolitan Centre and walkable catchment around that, where I've also given a split, not a split, but a double recommendation, because some submitters asked for a 10-minute walkable catchment around that metropolitan centre. The Section 42A report details the issues as to why it wasn't initially in the proposed plan, and how, on one hand, the NPSUD says, and actually the intensified streamlined planning process says that you should be doing it within this process. On the other hand, that upzoning around Kilburnie has not been consulted with those affected up to this point. So there may be an issue of people being upset that they've just discovered that now them and their neighbours can build 6 stories high. So it's a bit of an issue, but I leave that with you. And into questions. So the rest of my evidence, I'll just leave as read in the Section 42A report and the supplementary evidence. So I'm at the panel service for any questions you may have.
Well,
after lunch, perhaps.
Given that it's 12:28, we will break for lunch. There's just one issue for the council team to think of. We have cross-examination of Mr. Warden. I've asked Mr. Bellinger, and he would prefer that to follow after we finish questions on section 4.4. It occurs to me that because Ms. Hammond's evidence is directly interlinked with your sections of the 42A report, it might be sensible to have her evidence following cross-examination and before we go on with the balance, whereas the other council witnesses are much more generally focused on intensifications and feed into strategic objectives as well. And so we would leave them until after we'd finished on the Section 42A report. Leave that thought with you. I don't think I'm not strongly of that view, and it just seems that while we have the issues of walkable catchments firmly in our mind, it might be useful to explore Ms. Hammond's evidence with her. But as I, on that note, we'll break. We were scheduled for an hour. Would it be a huge impediment if we shortened that to 3/4 of an hour, given we're running behind time? Any problems from the rear? Okay, we'll be back at 1:15. We'll resume the hearing. Thank you. Mr. Wharton, thank you for your introduction. First question I had for you was about the generic reference at paragraph 139 about the advice of council staff. With the greatest respect, I think we're interested in your opinion, not a statement of what the council staff's collective opinion is.
So I say council staff by meaning council planning staff in advice to council in the past. Was that?
Do you agree with it?
Oh, absolutely. Yes.
Bearing in mind the questions we were discussing about the timing of the NPSIB, how fast are Make Wellington moving travelling? When will concrete plans emerge? Do we have any idea? Is it within our timescale? Is it this year? This decade?
Within the decade, but not really within the time frame of this hearing. One of the key deliverables will be a detailed business case, which is being started now, which will include some early decisions on route through the Mount Victoria Tunnel, how to get from Island Bay through to Newtown, so perhaps some variations on that route, but most importantly, where the station should be. From there, assuming that those get confirmed by council and that there's money put towards the project, that would be the time to be engaging with the community about zoning around those stations. And the council is actually doing, trying to work in parallel with the transport planning, but in terms of the detailed zoning, that does really have to wait until we know what those station locations are.
So not in any irrelevant timescale.
That's been my advice recently. Yes, that any changes, and there will likely need to be changes, but whether small or large to the district plan, should best be done through a variation or plan change.
So moving on to the Wellington Regional Land Transport Plan, you've noted that it identifies Johnsonville as a rapid transit service. Is there anything in the RLTP suggesting that the writers of that document considered the statutory, the NPSUD criteria before reaching that conclusion?
I would say yes, because the definition that they use in the RLTP is almost identical to what is in the NPSUD. They've applied a very similar definition and description.
Is there, like you yourself have said, I think I'm paraphrasing your evidence, but you would accept that this is certainly a contestable, is there any indication that the writers of the RLTP, as opposed to actually got to grips with the issues that you've confronted?
I think the key difference between the regional land transport plan and the district plan here is that the regional land transport plan is principally focused with strategic public land transport and making sure that it's integrated, making sure you're prioritizing the right areas, being aware of how it relates to growth in the region, but principally, and it is identified actually in the RLTP, that decisions about land use need to be dealt with under the RMA through the district plans. So the document does not purport to dictate that district plans must identify the same rapid transit lines as the RLTP.
Given that answer, I'm looking at your logic of paragraph 150. As you say, that identifying what transport is planned is right within the wheelhouse of these documents, the RLTP, because the whole post, as you say, the whole purpose of is about strategic transport planning. Is, given your previous answer, that caused me pause looking at paragraph 150 and say, does that link follow? Because it's got a role identifying what's planned, does that mean it also has a role in identifying what's rapid transit and what's not for the purposes of the DP? So I understand that other experts may have, will probably present a different point of view, but that link is a one-way link. So the regional land transport plan isn't looking to the NPSUD necessarily in deciding where its rapid transit line should go, but the NPSUD does do that. So there is a link back to the NPSUD in the definition of what planned services and stops means. So in doing that, because we're using the NPSUD for this district plan, I see that there's a direct tie in the definition to the RLTP for planned services and stops, and I'm thinking, okay, if this is intended for planned services which are inherently less certain, then we should be giving a fair amount of weight to identification of existing rapid transit services as well in that direction. In terms of your figure 3, I think it's in Mr. Ballinger's submissions. He points out that the commentary under this map says that, this is the notes I wrote down, that these could be rapid transit when frequency increases in 2025, which is obviously a reference to Kapiti and the Hutt line, because as you said, there's no intention to increase the frequency at this point at Johnson. Do you think that qualification is important?
In relation to figure 3, I would say no, because it is for that particular document, the regional growth framework, they have identified the Johnsonville line as rapid transit network. But yes, pointing out that frequency improvements are scheduled is relevant.
No, I think his point, it says they could be rapid transit. It doesn't say they are. Yes, I haven't gone back. I was going off Ballinger's submissions.
You see, I'm sorry, Chair, where's the could be?
Well, I'll now have to have a look and see. Mr. Ballinger, can you save me the effort of finding which document were you referring to?
So that's in the Wellington Regional Growth Framework, which I don't know if you'll have before you, but
I think the message was there was a commentary under that map where it appears in the Regional Growth Framework.
Okay, I'll look. Could be.
Well, rather than do it, like I wonder if you could just note that as an issue that we'd like you to explore in your reply and explain, check the document, and if it says that, explain what you make of it, what importance you give to it, what relevance it has to the point you're making.
I have found it here. Yes, it does say that map 6 identifies frequent bus services, the passenger rail network, and the parts of the rail network that could be considered rapid transit when high frequency services are introduced around 2025, generally increasing service frequency to 10 to 15 minutes. The frequency issue more broadly is something I raise in my supplementary evidence. And that generally it's good when public transport services are improved to 10 minutes ideally, or 15 minutes, especially at peak times. But recognising that for a lot of our existing rapid transit stops, for example, on the Tawa line, they have services of once every 20 minutes in peak times because of express trains that happen to go straight past. And on that metric, the Johnsonville line performs fairly well at a 1 every 15 minutes. The key difference here is that, as you pointed out, Chair, that this line is not looking to increase the frequency of its services, whereas the other lines are. I think that's the main commentary on that.
So your response is that's a valid comment.
I think it's relevant given that, as I say in my evidence, all of these things are guidance from other sources, I think I've called it, and that none of them can officially, unfortunately, none of them can officially confer the classification of the line. But I think it's relevant to look at regional documents and how the Johnsonville line is viewed as part of a regional land transport network, particularly about the network of train lines and how they're regarded and will be managed into the future.
The point you make at paragraph 159, talking about basically internal transport within the confines of the Jayville line. What evidence is there of people using the train service to access services between Johnsonville and the CBD? So from people going from Rara down to Mitre 10 at Crofton Downs.
That data is quite difficult. I have wondered about that myself. I'm not saying it's not out there because there may be some from Metlink that I'm unaware of, but I know that generally survey questions such as where do you travel to work, where do you go for university, tends to bias trips into Wellington Central. Also, the fact that most trips are into Wellington Central on this line does kind of tend to bias the data because that's where people tend to focus. Unfortunately, and I would like to know, but I'm curious about the destinations in between the lines and in the other direction. Interestingly, the line has peak services heading counterflow, which is a little unusual for rail lines. So maybe Metlink see some demand there, but I'm not aware of what the data is.
Well, I should say that although of course what we see on our site visit is not evidence. We couldn't help but observe, given that we were on the 302 train to Johnsonville, going from relatively sparse to packed with school kids who rode, most of which rode the train up to Johnsonville from Raroa and then rode it back again, obviously heading in the other direction, didn't want to stand on the platform. So it's a scenic route, scenic option. That there is an issue, and well, we have a submission from, or comment, you produced commentary from Greater Wellington saying that in their opinion Johnsonville is rapid transit, and that's also a Greater Wellington submission. In the very large bundle of material that Mr. Taylor from the Johnsonville Community Association produced is included an email from, I think it's a Greater Wellington Regional Transport Manager saying in 2021 that in his opinion Johnsonville's not rapid transit, but that Wellington City was pressuring the regional council to consider it so to assist its evaluation. Now, I'm not asking you to speak for Greater Wellington. That would have clearly been appropriate, but can you shed any light on whether Greater Wellington has shifted views, and if so, why?
Well, Chair, I don't think I can speak on behalf of Greater Wellington beyond what has gone through their senior manager and the letter that they provided. I know that that the official council position is that there is no, I mean, clearly, as shown by the differences that the council decision has had on the Johnsonville line, that there's no overwhelming policy call, just to see Johnsonville as rapid transit over the long term. So I'm not sure I can comment.
Fine. That going to your discussion about the level of demand for housing, talk about this at paragraph 165 and following. Is there an argument that these are highly desirable suburbs because they generally consist of substantial standalone dwellings on reasonably large sections, and therefore that saying that there would be equally high demand for 6-story apartment blocks up on those hills where you don't actually have a view, you're too far back, you don't have a view out over the harbour, would equally be high?
Chair, if I may, can I give a perspective just as someone who actually lives in Kandala? I don't actually live within the walkable catchments here, but so this is perhaps stepping outside a planning role, but there have been many, we were just talking about this at lunch, many medium density developments which have been slotted in recent times, which tend to be about 3 stories.
Tend to be 4?
About 3 stories, of townhouse, terrace house type development, many of which are slotted in with just a small yard, no views, and they seem to be very well designed and obviously fit into the neighbourhood quite well. And so just in regards to people wanting a different typology, and perhaps this is where I jump back into a planning mode, is that I think the NPSUD is relatively clear in saying that its objective is to provide a variety of tenure, a variety of housing typologies, not just for the people who may have established homes and families there, but for people who may want to live in a really nice neighbourhood with good services and an easy commute into Wellington. So that's both my resident and planning advice on that point.
Equally, the NPSUD is about meeting demand. And can you point me to, I understand the point you make about townhouses, because I think that's one of the features of Mr. Osborne's evidence, saying that to the extent there is a deficit at the moment, it's for townhouses, particularly down on the flat here. Not the flat here, because we're not on the flat, but the flat below us on the Taro flat. Can you point us to any demand for, as you say, what we're talking about, a 6-story development, which is not a townhouse? What about, as a issue, is there a demand for that? Can we jump from the current house prices to a demand for 6-story apartments? That's really where I'm at.
Oh, Chair, I will probably defer some of the technical expertise to the economic evidence about demand. Perhaps a more general comment is that it's difficult to judge the popularity of a bridge by how many people are swimming through the river. Which is to say, if there's not a lot of a certain typology there, because it's been constrained by planning rules in the past, it's difficult to know how many people would be willing to live in a medium to high density apartment, because it just has not been possible. In fact, even in more recent times, there's been a number of Environment Court cases where local residents have opposed medium density developments on more constraining plan provisions than in this plan.
Is this a variant of the, like, I suspect, I can guess what the locals will say, that this is sort of like build it and they will come?
It's difficult to judge what the popularity is unless it's even possible.
But sorry, just one take. But the point, your point is, but if you don't build it, you'll never know.
Well, I think if you don't enable it.
If you don't enable
it, then it's difficult. I accept to point out again, as I do in my report, that property prices and land prices are quite high, and in other parts of the city where we do have high land prices, that has tended to enable more apartments where it has been allowed. So in Mount Cook, now moving down into Berhampore, the land values are also high, but they're often the actual the individual dwellings have lower overall prices because they tend to be more apartments.
Question.
So just in relation to that, and tell me if I'm wrong, but in paragraph 160, when Mr. Osborne, reporting on Mr. Osborne's findings, it says that only 89% of the 4 to 6 story high density opportunities enabling these walkable locations by rapid transit would actually be realisable. So did you think, well, that's quite a lot, and where does that take you? If that's quite a lot, that isn't actually going to, and on that estimate, there isn't going to be a lot.
Yes, and I think this is where we differ perhaps from the chair's question about popularity or demand for a particular type to perhaps more constructability and what a developer would actually provide. And again, I'm not wanting to preempt the evidence that's going to come your way.
But as a planner,
sure.
given that information, what you're doing.
I guess as planners, we tend to be a bit like, we do note where demand is for houses and where commercial feasibility is, because we need to be enabling enough houses. at the same time, we do have a slightly longer horizon than the modelling that happens. So the modelling that's done on commercially realisable development is based on current land prices, current commercial costs. And we do know that those change over time. And if this is a plan that's going to last for, until the new plan comes in, but potentially for quite a while, especially the baseline provisions, then it's about setting us up for these 50 to 80,000 in the next 30 years, which is our kind of planning for growth horizon. So it is something definitely that we account for, but we acknowledge that it's based on current data, not your future environment that you're moving into.
Yeah, I suppose it's sort of a slightly bigger picture question in that sense, is that given that it's now got the 3x3 rule in there, that's a whole lot of change as well. And then when you've got this on top of that, was there a point at which you thought, well, let's just see how that goes and how that settles down before we need to go that, given that you say, 10-year time frame, you've got to see how it goes.
That's right. And it's probably worth kind of skipping to the end of my analysis, which points out like that if you don't agree that it is rapid transit, I'm not recommending that it stay at 6 stories. Instead, that the work that the council had done around centres and our priority areas for growth and our infrastructure and amenity and all that work indicated that 3 to 4 stories in different areas was appropriate. So that was our initial assessment. So I guess it's now that the NPSUD is in place with not just it's this thing about rapid transit, but also the overall objectives about how these areas should change. That's, I think, the core of this argument. So from a planning point of view, if that weren't there, we would probably go back to that 3 to 4 stories.
Yeah, I get you.
As far as that goes.
Yeah. Thank you.
Paragraph 170, talking about the interrelationship with Three Waters. You say the Three Waters infrastructure chapter ensures that development only occurs within available capacity. I may have read it wrongly, but I seem to recall Mr. McCutchen saying that Three Waters is not a qualifying matter, which prompted me to think, well, how strong can those infrastructure chapter provisions be if they're not qualifying matters? They won't preclude the mandatory development rights directed by the NPSUD as permitted activities.
Well, Chair, Adam may want to fill in, perhaps we do something wrong, but I think the main point is, while it's not a qualifying matter for mapping and for applying it, we do have district-wide rules requiring that development meet the standards for water and wastewater. So it's quite possible that, well, say for example, in Kandala, and that if this went through and there was a large number of developers really keen to get in and build lots of apartments in Kandala, that at some point it may hit capacity of the wastewater, and at which point then the district-wide rules would apply, and the developers would have to show that they meet those standards, perhaps something like a holding tank or restricting water flow, something similar to what actually is being required for some developments in Karori right now. So it's being addressed more as a district-wide connection matter rather than a qualifying matter restricting zoning.
So is that like asking Mr. Cutten, is this then more an issue of definition, not a qualifying matter, but still nevertheless effective when infrastructure capacity limits are reached?
So capacity of the Three Waters network is not being used as a reason to not do policy 3 in the MDRS. There's a development response that's required by the plan to manage the pressures that is being experienced by the network. So to be a permitted activity to do an MDRS, you also have to be able to hook into the drinking water from the town supply. You also need to be able to have a water tank to manage stormwater impacts, so you're not achieving a direct flow from your roof straight into the stormwater network, you need to play a part in slowing that down and reducing the overall pressure on the network. And for wastewater, when that is an issue, depending on the capacity of the network as it is now, if it is to be reached, then you may need to have like a holding tank or some sort of alternative solution to manage that pressure on the network and release it at a time where there's not peak usage. So it isn't a qualifying matter per se, where the plan is not enabling policy 3 or MDRS, but a matter that's considered within the resource consenting process to enable multi-unit or the MDRS to occur.
Like the thing I don't understand is, of course, if MDRS is a permitted activity, is there a resource consent? So is your answer that there are standards on those resource consent rules under those permitted activity rules that ensure compliance with 3 waters?
Correct. So in any case, the MDRS is always a permitted activity within the residential zone, subject to 1, qualifying matters, and 2, meeting the other standards of the plan, like your driveway widths and your 3 waters standards. You would require a specific resource consent for those matters, but not for the MDRS.
Are those 3 water standards on subdivision or land use?
Both.
Both. And are they the same under both?
The subdivision one allows you to still do the MDRS as a permitted activity, because you don't have to subdivide to do the MDRS. But if you are to do a subdivision, then there's a trigger at that stage to ensure we don't end up with a problem later on when people are doing the MDRS.
Mr. Schofield.
Well,
Sorry.
Yeah, it's something that the Economist might be able to or Mr. Warburton. And it goes a slight step back. We were saying before that in some of the areas that you have noted a high land property price, but because there's apartments, there's a lower price than for the accommodation part of the things. Is that because that's the choice of the people to live in apartments, or is that because that's the only thing they can afford?
It's an interesting question, Commissioner, because it's something that Let's Get Wellington Moving is actually looking at, the demand for apartments. It's something that, based on the surveys that have been done within Wellington and elsewhere, that it is increasing over time, the demand for apartments. There's still a preference, if like all else excluded, there's still a general preference of people to live in a townhouse or standalone house. Generally, that preferences ranged from 10 to 20%ish of people would like to live in an apartment. But when you start looking at constrained preferences, which is okay, well, yeah, you're foregoing a yard and perhaps a smaller place, but you get the advantage of perhaps a more affordable place to live, being close to work, not having to have a car, having shops and events and services right by your doorstep. That then makes apartment living a lot more attractive. So I would say that they're very intertwined. I think price point and apartments for most people here in Wellington are connected, as I think for most things, but I'm sure our economist might say something else.
Does that, in your view, apply to the broad range of people living in Wellington, or does that only apply to a small age group of people, say professionals without kids or whatever it is? Because that then doesn't actually apply to provide for the broad range. It only applies for a small range of people that would like to live like that.
Yeah, I mean, there is, of course, a wide variety of people who choose to live in apartments. From just trying to recall data, but generally, you're right, there is, here in Wellington City, the higher preference tends for apartments is with your young professionals and your older empty nesters, perhaps. and less so that the families. But I know as a I'm not sure if it's an official council position, but certainly in terms of staff, when we're looking at how we are intensifying the city, we are looking at how we can make high density environments better for families and better for a wide range of people in terms of making things, accessible, having good parks nearby, good services nearby, making them safe. So from a council perspective, it's something that is very important to have those good environments for a wide range of people.
And that also includes larger apartments, because what we see mainly is 1 and 2 bedrooms where you won't fit kids in.
That's right.
One other question in your paragraph 168, and that flows into that slightly. You're talking about that high density around the transport, rapid transit stops will allow neighborhoods to develop, and that higher density will actually help to, how do you say that? This in turn helps meet the diverse and changing needs of future generations. Now, how can it do that? Do we know what the future generations' needs are?
So, yeah, I mean, just accounting for all the hypotheticals in that paragraph, and also going back to the chair's broad characterisation in an earlier question of this route being full of large established homes, that we know that as communities are changing, so that there are much smaller households now. There are far more single family households. A single parent with children is the most common family unit with kids, and there are also new cultures coming in who have multi-generational, well, actually even European cultures have multi-generational requirements as well. So it's recognizing that if high density living became popular in this area and high density were enabled, then having different types of housing options for different types of people is a good thing in terms of developing and changing over time.
Thanks very much.
Yeah, just one follow-up question. You mentioned the demand for apartments being in the 10 to 20% range just in the city, but would it be true that the demand is in the centre as opposed to more outlying suburbs like Burnie, Johnsonville, Karori? You may not know it might be more for Mr. Osborne, but certainly the majority of the recent apartments which have been developed have been on the Te Aro flat.
Yeah, again, just speaking from my knowledge and the surveys that I'm aware of, I think I don't want to prejudge anything, because I know in other centres such as Auckland and over in Australia and definitely in North America, there is a bit more of a tradition of having apartments in suburban areas, particularly where they are close to local centres and close to public transport. It's a fairly common trend that could potentially happen here in the future if things change. But definitely, as you point out, the trend currently is that the vast majority of apartments are being built in the inner city and CBD area, where developers can get the most profit from them and where people can enjoy living close to work, services, recreation, etc., education.
Yes, thank you. I'm going back even further a little bit. Sorry. The figure 1 that you have on paragraph 142, this is if we did agree with those submitters that it's not a rapid transit service, and you're saying this is what the zoning you would recommend would look like, intensification. Could you lead me through this map a little bit, please?
Certainly. So just to clarify, figure 1 is not the recommendation of what the zone of what the walking catchments would be, but this were rapid transit. This is showing the sites. So in the draft district plan, the council had resolved that this be rapid transit line, and that there'd be 10-minute walking catchments around each of the stations. So that's what's shown in figure 1. And then it's pointing out the difference from that to the proposed. So what is in dark blue there was 6 stories in the draft plan, but is now just medium density MDRS 11 stories. And the teal colour was also 6 stories, but in the proposed plan is down to 14 metres medium density. So in terms of the walkable catchments in section 4.4 are smaller for those other stations by about a third, because you're going from 10 minutes to 5 minutes, except for around Box Hill Station. And those maps are included in further down. So they are starting in, actually we've got London here as well, so let's get through them. That's Box Hill, okay. So it starts with Rara on page 78, paragraph 320. And then continues through as we go and as I look at each of them through to Crofton Downs on page 88, figure 35.
So the pale blue and the teal blue,
yeah,
subject to modifications later on in your. I'm thinking of around the Box Hill station area.
Yeah, so I included that graph just as an illustration of it's in the overall background, I believe. Yeah, just in the brief history of the classification, and I just showed that the effect of reversing the rapid transit classification from draft to proposed is shown in the map. Right. So I encourage the panel not to be give too much regard to that, except just to note that the changes in policy, that how this is flip-flopped a bit as this plan has progressed, if I can use the word flip-flop.
So just clarify my thinking. So if we were to agree that the line is not rapid transit service, you're saying this would apply?
No.
Not, it wouldn't apply.
Actually, generally, yes. Like if you said this was not rapid transit, I'm recommending that figure 1 with the 11 and 14 stay the same with one small change as shown in figure 15 on page 55. Where that little wedge which kind of goes in towards Kandala is converted from 11 metre maximum building height to 14 metre maximum building height.
And the top end, you show Raroa Station, so that's the end of that change. There's no other changes around the Johnsonville area as a result.
And that's because Johnsonville Metropolitan Centre has its own walkable catchment, which overlaps what the railway station would have as 10 minutes. Yeah. It's probably worthwhile pointing out to the panel that if the panel did decide after hearing submissions or the evidence here and by submitters that it was rapid transit and they wanted a 10-minute walkable catchment around the stations, which many people have asked for, I think figure 1 gives a good illustration of what that might look like. And if you convert the 11 metres and 14 metres to 21 metres.
I'm up to para 170. I'll just write down the last point you make. Yeah.
Just back to that figure 15, just because I'm not quite sure I'm understanding it. Which was it?
55.
So what you would suggest is that wedge, so it's got 11 metres, and then the blue circles with the 14.
So the blue circles with 14 are in the notified plan currently.
They are.
And I circled them to highlight that 14 meters is on either side of that wedge.
Yeah. But that wedge you're suggesting is 11.
So I'm proposing that the wedge outlined in blue, but excluding, obviously not the circles around the 14 meters, but the wedge part, that the maximum height go from 11 meters to 14 meters.
So where it's got 11, you're suggesting it should be 14. And that
Within that wedge, yes.
within that wedge, it says 11, but you're suggesting, okay.
Yes, yes. So I'm just taking this map from the existing proposed district plan, and I just outlined in blue the area, and then in.
How far does that 14 at the top extend in?
It extends up to a similar crescent that kind of curves around.
Oh, okay, it's just not in this plan.
But it's a whole kind of U-shaped block.
So that's by extending it, the catchment of.
That goes back to figure 1.
Yeah.
Yeah, if you look at figure 1, that gives a good example.
That's the whole thing.
Yeah.
The whole thing. That's the bit.
That goes to 14.
Yeah.
Yeah, I got it.
So, a question about paragraph 170. You talked about the changes that have been made to improve Joeville line. Of course, the serious changes about putting in facility for a double track at similar larger station to allow 6 carriages. Are they quote planned in the RLTP so as to qualify as relevant for our inquiry?
No, they're only the work that's planned are the ones that is described in 170, which is work to improve running and resilience. So that's putting in replacing wood bars with steel poles, renewing the traction power overhead line systems, renewing the sleepers within the 7 tunnels, and stabilising the slopes above and below the track, and installing on-station ticketing machines. So it's more about improving the resilience and reliability rather than the capacity. And just based on conversations with Metlink staff, that generally reflects that other lines like Kapiti and Hutt tend to suffer more from overcrowding, and so in terms of investment in capacity, it's worth more to invest in those lines first before Johnsonville. I mean, notwithstanding the kids on the line, there are times when the line does get busy, but relatively compared to other lines, it is, I would say, a quieter line than Johnson.
So the note I've just written myself is you're saying that the Hutt and Kapiti lines are being prioritised
for capacity and service frequency upgrades. Yes, I don't think it's fair to say that they've been prioritised full stop, because there is a fair amount of money being spent on the line right from 2015, when the trains got upgraded to new Matangi trains, and there's been consistent investment in improving the stability of that line, which they have to really.
Going on to paragraph 176, your capacity estimate. Question: the argument's been put, I think, for WCCT that that's a COVID figure, COVID affected figure. It's average, not peak figures, and therefore it's an artificially low base. What's your answer to that?
That when it comes to forecasting population, and I've learned this as well through Let's Get Wellington Moving, it is very difficult. In fact, we may even get evidence on that as well about the range in projections, especially when you start moving decades out. I mean, just the effect of COVID is an example of how short-term trends can change dramatically. So what I tried to do, because I did write that Appendix C assessment, was look at what the current capacity is and what the rates were for that month, and then how things could change if there were more people living in the area, and if more people were riding the train because they were living closer to the train station as opposed to more generally around the area. And I think if you tweak those numbers and the assumptions differently, you just come up with different numbers. But the general I would say general agreement even from the other evidence is that currently the train functions well in terms of providing for the capacity. If we do get a large number of people there, it's just more a question of when the investment in increasing capacity would need to happen. And given that funding decisions and regional land transport plans can be reviewed every 3 years, it makes sense that once it's evidence that perhaps if people do start moving to live near that line in high density environments and the amount of people riding the train does increase, that would need to go on the radar, that actually this line does need to increase capacity. And that's why I note about there's an easier way and there's a quite difficult way. And the easier way is to expand the platforms to cater for the six carriages, because if you increase the frequency from 15 minutes to 10 minutes, well, mathematically doable. In reality, in the real world situation where you get rainfall, you get delays, that can cause tension, and this is what Metlink have told us as well. Whether it's the relevance you put on it, I guess it is up to the panel. I generally like to look at how things currently are, and the reason why investment's being put into other lines for capacity is because they need it. And and because we're not sure on how population changes over time and where it goes, oftentimes it's better to wait until you see the trends happening before you start investing in it. I might be warbling a bit too much here. I'm getting a look. No? Okay.
I had a question about the footnote quoting former Minister Twyford. I thought this was really puzzling as a description of the NPS, saying in the NPS we've broadened it out to include high frequency bus transport. A high frequency bus service on a main arterial would fit the definition. And I'm thinking, no, it wouldn't. It's not on its own track unless it's a bus lane. So what am I missing? Did the minister not know what was in his own NPS?
I don't want, Chair, I don't want to endorse what a particular minister says. The reason, I mean, I included that quote.
I'm puzzled, and you're telling me I'm right to be puzzled.
I included, a couple of quotes just as to fill out, that the ministers did keep this definition intentionally broad to allow councils to decide how to interpret it for their cities. And this is an example of a minister positing on how that could happen. I don't think even Minister Twyford would expect you to take that as a deciding point for any rapid transit decision points.
Thank you.
I just ask a question. Yeah. Isn't it a little bit chicken and egg in terms of rapid transit? We're looking currently at the current system and section out, but isn't it a bit chicken and egg in terms of what build more intensive development? Would the line accommodate more rapid transit services? I suppose that's the question I'm leading to. Is there capacity, if it was deemed to be one of these lines, that future development could still be absorbed by that line?
Yeah, Commissioner, I think that is a fair point, and it's why in my evidence I do include that capacity assessment, and also how other public transport lines, given that there's 5 other bus lines that service that area, how they could potentially respond to growth. And I think that that's valid. My comments were more in response to the concern raised by a few submitters that, well, capacity is not planned for in the RLTP, and so therefore you can't consider it. And it's like, well, that's fine, but then they're also saying, and we're going to get increased growth. So you've either got to do both or neither. Either look into the future and think about, okay, can this line increase its capacity theoretically, and theoretically could we get growth there? Or I can say, okay, well, what's planned now under the RLTP and what's happening now? I think that's what my comments are in the context of.
Can I, back on frequency capacity questions. I think rapid transit is for peak and for off peak. You know, so it's to access work, you know, during peak times, but it's also should be to access services along the line. I think Chair mentioned too, but it's only once every 30 minutes. Would you expect that to be frequent off peak if it was when it's rapid transit? Would you see that increasing? Because we want people to sort of go between and access, or even to go into town. You know, people work for flexible hours now. Some people work home half a day, go in half a day. That would need addressing.
Certainly, from like public transport planners prefer that, and that's the reason I think why they're looking to increase frequency. Although I know that they've had a lot of difficulties with the number of in recent times with the number of drivers, etc. Potentially with the Johnsonville line, the reason, you know, like why isn't it 15 minutes or 20 minutes off peak? And it's, I don't want to speak for Metlink, but my guess would be that they just look at the number of people using the line off peak at the moment. Perhaps it's not.
It's a bit chicken and egg too, isn't it?
It is quite chicken and egg.
Yeah.
Which makes it difficult when looking at, you know, is it rapid transit? And I think that's why often looking at exact numbers and, you know, saying, oh, well, this is off peak, you know, only once every half an hour, and that's not good enough, is quite a difficult angle when deciding if this is rapid transit or not, because then there's other lines that also, I mean, until 2018, the Kapiti and Hutt lines were also every half hour during off peak, and it's only, you know, recently that they got updated to once every 20 minutes. But yet those were still expected to be a form of rapid transit.
Yeah. Isn't that the point though? I mean, would it be wrong for this panel to not expect Metlink to be nimble and adapt timetables based on what's in front of them at the time?
Well, a recommendation perhaps back to the panel is that's probably a relevant question to ask Greater Wellington when they present is what is Metlink's plan for perhaps off-peak services on the Johnsonville line? It's not something I have the data for or knowledge about.
Yeah, I think that's why I was asking, because it seemed to me to be quite a few changes desired. Go from 15 to 10, needs another platform, needs another passing day, 30 minutes isn't frequent enough. There's a lot of changes, but no actual commitment yet to actually do any of those things. And so it's sort of a bit of a theoretical almost assessment of whether it's RT or not.
And the other problem with SAR asking Greater Wellington, their intentions is that we're not going to be favoured by their presence. So that'll be a technical hitch.
So those things, there's a lot of outstanding questions really around there. All the desirable, the things that you talk about, yes, that'd be good to have.
Yeah, just a general comment for the panel. I admit it's not a simple decision, or at least from my opinion, it's not a simple decision. It's one of the reasons why I did also include other evidence which is contrary to my point of view, because I think it's worthwhile you do consider all the options here. And I mean, you've got one line in a definition with some very unspecified descriptors in them to help determine if this is rapid transit or not, which has significant effects on the zoning.
Yeah, but I was going to ask you about Appendix D because you included it wasn't something you commissioned, you know, to have it, but you included it. So I thought, well, what are your thoughts on that? Because it's got, I know you just included it for information. I thought, well, you must have seen some perhaps merits in there.
So the evidence provided there, and also similarly, some of the evidence provided both, I guess, from, I should say, not just against being rapid transit, but also, you know, for it being rapid transit, for example, the Kāinga Ora evidence. You know, they're presenting facts and figures, and I've clarified the ones where I think that they're a bit off in my supplementary evidence, but many times I accept, that this is an assessment. But at its core, it comes back to what is the panel judging this line on, and let's make sure that, and especially given I think we're the first to be looking at this, let's try and make sure that it's consistent with how we treat other rapid transit lines, and do it in a way that regionally that it results in a regionally consistent approach as well.
Thank you.
Going to quickness and reliability, I had a general question. I think it's Dr. Helm and Mr. Wicknell, rather than the other way around, have a lot of factual information about the Jayville line, like the speed across the ground. Can we assume that because you haven't provided rebuttal evidence on that, that you don't disagree with their factual description? You agree with disagree with their conclusions they've drawn on the facts, but you don't disagree with the underlying facts? Is that fair?
I think generally that would be true. I mean, your example you gave there, that I think I did have a comment on the speed, just mostly to say that the assessment is quick. So, and quick is generally compared to what? I mean,
dirty.
I don't want to bring the cable car into it, but an example of something that's really slow, but it's a really good shortcut. And in some ways, that's what some of the stations around the Johnsonville line is. That given the winding nature of the hills up there, it's actually quite a convenient shortcut, especially during peak times when it gets crowded or whatever. But it doesn't. I don't say that they're wrong in saying this is the average speed, for sure.
So my concern is that we're talking about, because we've got inherently imprecise descriptors that are all relative. How quick is quick? I think we know the Shinkansen trains in Japan are quick because they're 290 kilometers an hour, but what's not quick? And it all depends on your frame of reference. But my concern is that you're not pointing out to us arguments about the underlying facts. It's all the inferences you draw from those facts, the judgments you reach on the basis of those facts. There is one element that I wanted to ask you about in terms of reliability. From my time commuting, dare I say it, by car from out of Karori, I seem to recall lots of mornings listening to the radio in the car telling me that the Johnsonville train is now being serviced by a bus. How have you treated that as an issue of reliability? And can you say, well, that was my perception, but maybe perceptions, take with a grain of salt. But do we have any facts? How often is it replaced by a bus, and is that relevant to this inquiry?
That's a valid question, Chair. It's, in the theory is that being a dedicated line, when only having to stop for its own stations, means that it is a reliable service because it's not going to be affected by traffic and congestion and people crossing. But and I think that's probably true in comparison to other, in general, compared to other public transport options, buses, for example. But it is also true, and I have noticed that. So I did record in 184. Well, let me go back a bit. In paragraph 184, I mainly, in terms of reliability, the records I had were from Metlink about the number of services that weren't cancelled, were not at capacity, and that stop at every station. I don't know how many of those they switched for buses, because it may be that Metlink had a small incentive to make the numbers positive. I can't speak for any of that. And I note that also that was 2019-2020. In recent couple of years, there have been a number of instances that have reduced reliability, slips. There's been a fair amount of maintenance and upgrades. The sort of work that I referred to in terms of upgrading the sleepers, upgrading the lines, upgrading the slopes. And it's not just been the Johnsonville line, but also the Kapiti and Hutt lines as well. There's been a lot of cancellations, and of course, bus drivers, and now I hear anecdotally a few train drivers as well have reduced the frequency. How much weight you give to it? My advice would be not much, because I think those are short-term one-off events, and events which will actually result in long-term better resilience and more reliable services. So that's my take on that.
Cross-examining counsel would put to you the punchline that because you don't know how many times it's replaced by a bus, you can't really tell.
Well, back to my earlier response, I think that the reason why it's being replaced by buses, notwithstanding these one-off events that have been happening, have been because, well, oftentimes for line maintenance and upgrades, and yes, sometimes for slips, but though typically it's to make this more resilient and more reliable, and also notwithstanding like drivers issue and other issues.
A question is, in your description of quickness, you talk about comparison with alternative means of traffic, and saying, in your view, it's quick for the lower 1, 2, 3, 4, 5 stations, not quick for the other 3. We have any evidence, do you know, how to put it, what proportion of the users of the line are coming from the quick stations, and what proportion coming from the ones that are not quick?
I could.
I'm
sure I could find that data for you. But
well, can I entrust that question to you? Yeah. But probably more of a punchline, and this is more picking up the discussion I had with Mr. Wellington about, well, what does that definition really mean? How many boxes do you need to tick? If you looked at this line overall, you've said 5 of the stations are quick and 3 of them are not. Does that mean that the overall line is quick or is not quick in your view? If looking and focusing on that particular box.
Well, in my evidence, I've put it as quick, and just noting that what we're looking at here is from those stations to Wellington station, and to be fair, that is the majority of travel. But I mean, as you pointed out, there may well be people moving the other way. So yes, I was looking at it as an overall service, overall train service. And so if the decision is that, because certain stations are slower, or you choose a different metric, that therefore it's not quick and therefore not rapid transit, I'd just caution against that approach, because as was pointed out by Nick earlier, by Mr. Whittington, that there are...
We know who you mean.
Yeah. That there are other accepted rapid transit services which have services that are slower than car and buses. And I was interested to recently, or even just compare some of the Auckland lines and some of their travel, and how they are slower in many instances from some stations than buses are. So, it's difficult, but I think that's what I looked at the line overall and saying that, even though based on my own measurement, which to be fair, there could be better ones out there. There's a few that are slow getting into Wellington, that the whole service overall would be regarded as quick.
And the other question that that occurred to me is, now I'm asking you to suspend the fact that you formed a view and you've made recommendations to us. Is there a potential middle position based on that assessment that, as you put it, where the train is available as a shortcut, that's a really convenient shortcut, but it's more problematic further up? Is there a viable view that this is a rapid transit service between the CBD and Box Hill, but no further?
I think, Chair, that we're breaking new ground here. And
that's what we're for.
It could be possible. You could say, okay, well, our definition is, just thinking back to the definition of NPSUD, so rapid transit service. Hang on, let me look it up. Yeah, the stop is where you enter and exit a rapid transit service, potentially. Yeah. In terms of, sorry, I'll focus on your question, Chair.
So you say, well, would you say that's not a viable option?
I'm just looking back
in terms of the definition. You say it certainly meets the descriptors better than the whole line. And I'm saying, well, is there a reason why it's not a rapid transit service to that extent?
I mean, there is an interesting parallel with perhaps the Hutt line, which then that same service goes into Wairarapa, but with far fewer trains, and different trains, but it's the same corridor potentially. So perhaps that could be something. You could, the panel could look at the term service, got it here too, and say, well, yes, this is a service, could be as at any rapid transit stop to a common destination. The risk with that is you ignore transport the other way, that you ignore people who are like your Rara school children who, you know, leave school, hop on the train and go off to the mall to hang out. But perhaps looking at the dominant direction of travel for most commuters into Wellington City, you could say from a rapid transit standpoint, in terms of the rapid transit service, it would be just that. So I think, rounding back to a simple yes or no, that could be a middle ground interpretation of the definition.
Like the reason that that I'm not going to say it appealed to me, that occurred to me, was also if you combine a purposive approach and say you're linking, say why do we care that this is rapid transit or not? And the answer is because that's the trigger for higher density. Higher density responds to a quality rapid transit service. And those interactions, that, so where is there a case for higher density based on the Jayville line? There might be a better case for those lower stations in the area around them than further up. Is that a viable? Is that a reasonable case? I'm just floating kites here. I'm not saying I have any adherence. I've got no idea what my colleagues think. They're probably quietly muttering about why am I bothering you with these questions.
Well, Chair, it's an interpretation that was probably worthwhile the panel considering. It's, if you like, it's something that I can talk with my colleagues about, and rather than just me being.
Well, as I'm just floating kites, and you may want to. By the time you get to reply and you've thought of the 15 good reasons why that was a dumb idea, you can tell me what they are.
I don't know if this is the appropriate time, but I just wonder if we can step back a little bit. And I mean, what's your understanding of a planning period for this document, this plan?
district plans generally. That's
what's its lifespan?
Even though we've got a new NBA plan coming up, I like to think that
please don't depress us further.
a lot of these issues have to be addressed regardless.
Yeah, look, I could ask a more directive question to get to the
please.
point. Is it unreasonable to expect that we're dealing with a 10 to 20 year planning period?
I mean, in terms of the life period of the plan, or in terms of the implication?
Well, currently under the RMA, the MBA is just a bill, it's not statute at this stage.
Sure.
There's a requirement to review district plans every 10 years.
Yes.
That doesn't always happen, witnessed by Wellington City. Albeit that was a rolling review over plan changes. But generally, if councils review their plan every 10 years, by the time they get an operative plan, there's another 5 or 10 years gone by, and there's the life of an operative plan is somewhere between 10 and 20 years normally. Would you agree with that general proposition?
Yes, with the proviso that the things we're trying to manage are often much longer than that.
Yeah, look, it's not a trick question.
Okay, cool.
It's just trying to get a feel for the planning period that we're dealing with here.
Sure.
The intensification is enabling, isn't it? It's not mandatory. These minimum standards.
Yes.
Okay.
Absolutely.
Yeah. Okay. Is there anywhere in the policy, particularly policy 3C1, that says that we must make a spot decision on when something qualifies as rapid transit at a particular point in time?
I believe. Do we not? Can I ask Mr. Wellington that under the ISP, the intensified streamlined planning process, that we're required to give effect to NPSUD on this?
I don't think that's the question. I think the question is there a time period?
Is it time sensitive to a particular time frame? Do you have to make that call at a given set of time, like now, or can you consider the potential for this sort of infrastructure to become fully rapid transport over a portion of the planning period that you're dealing with and a portion of the planning period that you're enabling development over? What's the urgency in making that call now? Is there any guidance in the policy in the NPSD that says that a finding on whether something's rapid transit or not needs to be made at a point in time? I don't know the answer, so that's one I think we're just
looking towards what is the definition of rapid transit service. That's whether it is now or whether it meets the definition of being planned.
Yes.
Being identified in an RLTP.
In terms of potential.
Approved. Yes. Yeah. Yep. But prepared and approved. And so it's been planned and approved under the RLTP.
I don't know if that helps. The other thing, the other angle on that is we're focusing on these things because this is the mandatory element of the NPSUD.
Yes.
If we put aside whether it's rapid transport, we've got a complete discretion based on the ambit provided by the submissions. And you're suggesting, well, your fallback, your personal opinion, your professional opinion, not personal opinion, your professional opinion, is that if it weren't rapid transit and you weren't required to provide 6 stories, you wouldn't. You'd have something less, but maybe more than MDRS in some places. Is that have I understood that correctly?
Yeah, that's correct. So our general approach as planners and council is to focus on the city centre and suburban centres and key public transport corridors, and that was a general approach to growth that started way back on planning for growth, our city tomorrow, and it's been a consistent approach here. So recognising that, yes, these western suburbs have many descriptors that make them quite suitable for intensification, but at the same time, compared to our high growth areas like Johnsonville, the Let's Get Woody Moving corridor, are and also our infrastructure staging. We've staged that area for more of the 10 to 20 year period, recognising that development's happening slower there. And so I think if the NPSUD didn't exist, I would defer back to that as I discussed in my evidence.
Yes, so to recap, if there's no doubt that it's rapid transit, then there's no discretion to depart from policy 3C1 in terms of classifying it. Therefore, it's mandatory to run down that line. But and being mandatory, it's enabling the provision of development up to X number of stories. Not mandatory to do that.
That's correct, Commissioner, and just 2 points to add to that. One is there's still discretion around the walkable catchment.
Yeah,
whether it's, and that can make a big difference to the amount of intensification around. And also there's still policy 3D, which is about enabling within and adjacent to neighbourhood centre zones, local town centre zones, building height and densities commensurate with the level of commercial and community services.
Yes.
So that's what we would go back to more that direction.
Okay, and to go back to Mr. McCutcheon's clarification, to be classified as rapid transit, amongst other things, it needs to be planned and approved. Is that your answer, Mr. McCutcheon?
It needs to be planned in our LTP
yes
document, and it goes through that process, the document, and it's approved, not the planning to transition this service into a rapid transit service.
Okay.
That means any existing or planned frequent, quick, reliable, and high capacity rapid transits.
So given that the Regional Land Transport Committee noted that the Regional Land Transport Plan classified the Johnsonville Railway Line as rapid transit and recognised its role in the regional transport network, how does that align with the planned and approved test?
So the document which they made that decision was approved, not the. So it's been identified in that document, and the document went through the process, and that document was approved.
So is the Johnsonville line planned and approved in terms of rapid transit?
I don't think that's what the test is. Has it been planned in that document?
Isn't the focus on improvements to the line? That's how I read the definition. It's what you have at the moment and how it's planned to change. And the test of what is planned is what's in the RLTP.
Yes, so I thought I just quoted what was in the RLTP.
Yeah,
and it's classified as rapid transport and recognised.
But it's not planning any changes to it. That's the classification. I think that was Mr. Warden's point about what weight you could put on that statement.
Oh. Yeah, that's correct, Chair. It's an awkward point where if it's actual rapid transit, you only get those descriptors. If it's planned rapid transit, you can refer to the RLTP. So in some ways, you get more certainty if it's planned than if it's existing now. I think that's why I refer to the RLTP as something to give a fair amount of weight to, but it can't be definitive because it's not specified in the NPSUD.
Can I just have a follow-up question?
Yeah.
Now, you mentioned earlier on, I've done a little bit of work in that space myself a wee while ago. But the RLTP gets reviewed every 3 years. So is the review encompass sort of the strategic type of things where you want to go to in the future and amending and adjusting, or does it really look at the funding allocations and whether or not something goes from a short-term need to a medium-term need?
I expect, so yes, this most recent RLTP did have a fairly strong strategic redirection to look at carbon reductions and mode shift. There's some fairly big targets related to that. I think the new one in 3 years' time may also have some significant strategic changes because we're getting the new future development strategy coming through. So that's a requirement under the NPSUD as well. and that may specify where, in fact, it should specify where growth should be planned for and infrastructure planned for, and that needs to be integrated with transport. So it could well have a strategic direction and change again.
So it's going to actually specify where growth should occur in the Wellington region.
The future development strategy, yes.
Yeah, and the RLTP must rely on that.
No, but well, they're documents from different acts. So unfortunately, until RM reform comes in, and depending on what's in there, because obviously it's not law yet, they're documents you have regard to. I'm thinking more in terms of best practice, and in terms of, I know what the staff are looking at is that they are trying to make sure they get an integrated picture of land use and transport planning.
Yeah, I guess the reason for the questioning is that we are involved in an RMA plan process, which you're relying on certain things and other documents out of different legislation. The RLTP is, from my recollection of them, and it may have changed, there's a consultation process. It goes to council, gets the tick, and that's it, regardless of what anybody else says to the contrary. Whereas you have much more in-depth analysis here, but you are relying upon something which is subject to change.
Yeah, Commissioner, I tend to agree with that comment, and perhaps that's why in the MPSUD it's referenced more for planned services rather than existing, but it's a good point.
Last question I had before you get to your summary is the WCCT case in part poses the rhetorical question of the Jayville line is rapid transit, then why isn't the cable car? Now, your answer might be because no submissions have sought that the cable car is identified as such, but what's your answer? What's your professional opinion? What is the difference? Is there a difference between them in this regard?
Oh gosh, I don't want to get myself in trouble. No, that was a joke line. I'm quite happy to answer. Adam's like, no, don't do it. I think, Chair, that your last comment is probably the correct one. That we staff have not really been seriously directed to look at the cable car as whether or not it is rapid transit. Obviously, it has a lot of features in terms of it's quick compared to both driving and bus. You know, it has really high capacity because it's so short, up and down, and it's very reliable. The people have said, well, is it really public transport because, you know, it's not managed by Metlink? So I don't think anyone's really wanted to see if it falls under MPSUD, whether at a regional or at a city scale.
Like I can remember in the Genesis, in the local paper, there was a commentary, somebody had asked the council this question, and there was a great hilarity that it had taken the council quite a long time to come back and say no. But like I'm thinking, well, there are implications if we agree that Johnsonville is rapid transit. Where's that going to take us? Does that take us inexorably to, well, the cable car is too? Now, that may be, well, because we have no jurisdiction to make a finding to that, because no submitter has sought that, but that's just a temporary issue. Can you point me to a good reason why Jayville is and the cable car isn't?
The general hilarity I can understand, because for a layperson, if you hear the term rapid transit, you think fast, and then cable car clearly isn't fast. It's only when you start thinking about actually the reason why it's quite popular is because it is quick to get down, because it's just straight down into town from Kilburn. But I think the RLT,
having taken it myself in preference to walking up the hill, it has certain merits in that direction as well.
Yeah, I think generally the regional land transport plan is instructive in terms of looking at, again, how rapid transit around the region is being financed and managed and run as a integrated system. And the cable car is quirky and it's useful, but it's not seen and it's not being planned as part of a rapid transit network.
In terms of speed, the Johnsonville line, some places goes the same speed as the cable car.
I guess if it's slowing to the
It's
station.
very slow on some of those hills.
Going up the Naya Gorge.
And where it has to pass a train, perhaps.
So I've not noticed yesterday when we were even in the Mate.
And positively, the last question I had, the definition of rapid transit that you're proposing, given all of the problems with the NPS definition using ambiguous terms that have created all of this debate and issue, are we really helping anybody having a definition that repeats the same ambiguous terms and is a definition that effectively deems some things to meet the definition appropriate either? So in terms of the Section 32 analysis, clearly trying to put the question we're debating now on the to bed is helpful from one point of view, but does this meet the Section 32 tests? Is it really aiding the implementation of the plan?
It's something that obviously some submitters have asked for it because it's a term that's like the plan uses the term rapid transit and rapid transit stops, mostly, to be fair, in relation to policy in the, I think, definitely city centre zone, possibly high density res. Yeah, and so it's more about how development should be connected with rapid transit and how it should facilitate transit oriented development, that type of thing. So in that sense it's useful. But if the panel felt that actually it's just cementing things too much, I mean, notwithstanding that you can always change the definition if a new rapid transit line comes in, for example, if the Let's Get Woody moving one gets built. I think that's a call for the panel. It's not something I would be absolute, yes, this absolutely must be in here. Just merely responding to a submission that it could be useful in terms of people understanding how the plan treats rapid transit and rapid transit stops.
So that is all I had on transit. Does anyone have anything for section 4.3?
Just one question, just finish off the question I was having about if it wasn't service, Johnsonville, say in paragraph 197 about notwithstanding policies 3CI, so that's the metropolitan. You would have recommended enabling 6 stories within 10 minutes walk of the station. Right. So I'm just trying to remember that. Do you have a map that would show what that? If you overlapped, yeah, the MCR over that recommendation.
I don't actually have a map here showing the 10-minute walkable catchment around the Johnsonville station and also the 10-minute walkable catchment around the MCZ. But okay, it could be something that we could provide.
I think that's an issue for reply if you could.
Sure. Except to say that it does completely cover it. So the 10-minute walkable catchment around them, the metropolitan centre zone is bigger. Covers it completely. Yeah.
I'm just trying to think if there was any that 10-minute walking around the railway station, where would there be bits by the MCZ
that would be totally covered.
Now the team to the right of me, anything?
Yes, so Mr. Wharton, I just want to ask you a couple of questions about your summary that appears, well, your conclusion on 201 through to your summary at 204. So in your conclusion at 201, in your assessment, you've said that the Jayville line fits the MPS definition of rapid transit. The plan should enable 6-storey building heights within a walkable distance, and I acknowledge your point earlier saying that that's still what's walkable is still a live issue. And in your rebuttal evidence at paragraph 33, you've said that paragraph 21 remains unchanged when viewed as a whole. The Osborne line is a rapid transit service under the MPSUD in your opinion, and you've referenced Mr. Wignall and Mr. Helm's evidence on that. With that as the context, I just want to understand your 7 recommendations that follow under 204, and in particular whether there might be whether there's an implicit hierarchy associated with them. So there may not be, but I just want to clarify that. So recommendations B, C, D, E, and F and G, are they predicated on recommendation 1 being achieved or occurring first?
I'd say they're conditional, not hierarchical as such. So Rec 6 is obviously you.
Sorry, yeah, Rec 6, okay, which is item C, yes.
Yeah, so C, yeah, Rec 6. That's conditional on Rec 5. But if you decide to go against Rec 5, then you'd go to Rec 7, saying it's not.
Yep.
And then Rec 8 and Rec 9, I have noted that the Johnsonville line reference is subject to the recommendations above, i.e. Rec 5.
Yes.
Yeah, and then Rec 10 stays separate.
Yep, I understand that. I mean, if you like, Rec 5 and 6 are up by one and the same, they're linked. Rec 7 is the alternate. And Rec 8 and Rec 9 depend on what we decide on the Johnsonville line definition. But that's not my question. My question is, do Rec 5, 6, 7, 8, 9, right through to 9, at what point do they get implemented in relation to Rec 4? Because Rec 4 on the plan reading says that those plan provisions should not be changed until let's get Wellington moving, mass rapid transit routes and stops are identified in the RLTP. I'm just confused as to what that means and what the time frame might be.
Thanks, Commissioner. I can see that the confusion here in terms of how it's phrased. It should really be the plan provisions in relation to proposed walkable catchments around let's get Wellington moving stations, MRT stations.
So we need to get the wording right. So the plan provisions in relation to
let's LGWM mass rapid transit stations.
Okay, you might want to reproduce that recommendation.
Can I just ask on this?
Yes.
I mean, isn't that a null recommendation?
Yes.
Because we've got no scope to do
That's
it
right.
anyway. No one's submitted on it and provided it, so.
And just further to that, just while you're thinking about that, Mr. Wharton, what's the time frame? I mean, and that's why I used the word predicated before.
I think that was the question I asked. It says it's years away.
Yes. So, given that we're going to have to make a recommendation on this at sooner rather than later, at the end of this year, at what stage? I mean, it's highly unlikely that the Rec 4 will be actually given effect to at that stage. So what's the mechanism? Are you proposing a mechanism within the plan that defers the upzoning of those areas until such stage as that occurs?
So first question was that there are 2 submission points that have asked for the MPSUD provisions to apply to the mass rapid transit routes to the east and to the south.
Yes, so it's not a theoretical issue.
So there are.
Sorry, is it the routes or stations around the route?
They asked for the routes, the complete routes. And so in order to simplify what I clearly need to rewrite, perhaps we could delete the thing in advance of the proposed MRT routes and stops being identified in the RLTP, because that's more of just an explanation. Yep. The basic recommendation is to not do anything different than we've already got, because the reality is the plan already considers to a degree that there is going to be some form of public transport improvements down at least as far as the hospital. We expect that that's likely to be some sort of mass rapid transit, but of course we don't know for sure. And so the zoning pattern has been adjusted accordingly to reflect that. So all we need to have in this recommendation is just the plan, meaning the proposed plan provisions in relation to Wellington moving MRT routes, I guess we should say, should not be changed, and just leave it, if that's clearer, Commissioner.
I've missed one that, well, it's potentially clearer. Maybe I'm just showing my misunderstanding of what it is, but I just wondered whether there's any utility in deleting Rec 4 altogether. What purpose is it serving?
The main purpose was to respond to the Simon Ross and the Coalition for More Homes, who asked for upzoning to occur right along the routes to the east and south.
Okay, well, I guess I need to wait and see what the revised wording is, but on the face of it, I just saw that recommendation as potentially frustrating the implementation of the subsequent ones. And I acknowledge that probably wasn't the intention, but it could have been a possible outcome, unintended.
That's probably very fair, Commissioner. The section 4.3 was about rapid transit generally, and there were a couple points relating to moving rapid transit, and so that's what this recommendation is trying to address. But okay. I accept I would need to rewrite it a bit more clearly.
Thank
you. So I think we're moving on to 4.3.4, walkable catchments.
Can I just raise an issue, which is the availability of Mr. Osborne, who's been at the back of the room. He is here today, so we need to name him today. That's the only thing I'm raising.
Okay,
it may well be that rather than go to Ms. Hammond, depending on how many questions you have for him, maybe it's best that he slots in.
That's fine, whatever. I think.
Unless you think you do it with Ms. Hammond and still with cross-examination, you'll still have.
Well, Mr. Ballinger has promised me 10 minutes. I'll be counting.
Well, he said to me at lunchtime he may not need to do it at all, depending on your questions. So I don't know.
We'll see. So yes, we will. We will not impose on Mr. Osborne. Come what may, we will hear him today, even if we have to stop where we're up to, and go from there. So we're up to 4.4, and Commissioner Schofield will take the lead.
No specific questions around parts leading up to the maps, basically, and then I did get a little bit confused by some of the maps. So, if other commissioners got questions for the maps?
Up to when?
The maps that start on 83, page 83.
83.
My first question.
83.
So if you have questions first, right?
So we're going to what paragraph 285?
Yeah. Any questions? I didn't particularly.
Well, I had a question on the 268, para 268. And I wanted to understand your sense of, well, MFE have given us a springboard. We've talked about the weight. I talked about the weight that you've given to MFE's contribution, Mr. Wellington. it seemed, I interpret what the MFA is saying. It seems to be talking about how far people will want to walk as opposed to how far they can walk. Is that your sense of what is this inquiry? Which one of it is? Is this a behavioural question? How far people will want to walk to a centre or a rapid transit zone, or how far the average person could walk? Which is it? Or is it something different entirely?
There's been some interesting evidence on this as well, but I can give my take, and others can add to it. That it is partly where people are walking or willing to walk, and the guidance gives some examples from some studies on that. But it's also how far people could walk if densities and different housing types are available to them in that area. So they talk about if there are centres that have lots of services in the local area, if the area is relatively a pleasant place to walk through, people tend to walk longer and want to walk longer. And whether the area is suitable for intensification around this rapid transit. So I think it's not just, it is how far people typically walk, but of course, not every rapid transit station is, we're looking at rapid transit here, is the same, and there are different characteristics which may mean that it's more appropriate to use different walkable catchments.
And my last question before the maps was, if it's substantially a behavioural question, how much people will be prepared to walk, will want to walk, is, for instance, the steepness of the contour a relevant issue, not just because it's going to slow people down, but because they're not going to want to walk every day up a steep hill at the end of a day, even if they could walk it in 10 minutes. And similarly, the Hay Street residents pose the question about safety. Is safety, if a walking track is unsafe because there's no footpath and because it's a one-way private road, even if you could walk it in 10 minutes or whatever your time frame is that a relevant consideration?
I'll give a short answer, then I'll pass on to you two as well, because I think you've got useful things to add to this. It is something we considered as staff. In the NPSUD and also in the guidance, it talks more about walkable, and even when it talks about accessible, it is in the context of accessible to active and public transport, to a range of commercial activities and community services, not so much is it accessible for people with disabilities or people who, have to take a pram or something like that. So in terms of our general policy approach, we've looked at it in terms of is this a walking, obviously not bush bashing down a hill, but is it an accepted and managed walking path? Which may be on, if it's a small side road, it may be on the road, but it may be up some stairs, it may be up a ramp, and that's the approach we've taken. I'll let you guys speak to it as well.
Sure. Yep. Kia ora. I haven't formally introduced myself yet. My name is Orla Hammond. I'm currently the team lead for the City Insights GIS team. Just a brief history of my experience. I have a Master of Science in GIS from the Technical University of Dublin, and there I wrote my dissertation on the use of least cost pathway analysis in aiding search and rescue operations in mountainous terrain. And I only mention that because here in Wellington, hilly terrain is quite relevant. Prior to working for Counsel, I was a GIS analyst in Ireland, primarily in the environmental sector and in the financial sector. I've been with Wellington City Council since 2019, and I was initially hired to work on the Significant Natural Areas project, and then I was kept as a GIS analyst for the spatial plan and for the district plan review. So I've been involved for the last 4 years quite significantly. As part of my role, I provide data management and preparation work for the team. I also provide analysis to help them answer specific questions or to provide them information that's going to aid in decision making. I provide a lot of the map work, less so now that I'm a team lead. And I also do a lot of web application development. So specifically the spatial plan website, we would have developed that. And just for those of you who aren't familiar with what GIS is and what GIS analysts do, so depending on the context, GIS stands for Geographic Information Science or Geographic Information Systems. The science element is basically the study of spatial data, how it's managed, how it's used, how it's displayed to people. And then the system side of it is basically the software we use in order to perform our jobs. And then my involvement specifically in regard to this hearing is I was involved in the development of the walking network model for Wellington City Council, specifically an upgrade on the existing model that we had. I was involved in the literature review that provided our evidence base for the calculations that went into the model, and that was what created the walking catchments that a lot of the decisions have been based off. So in regards to the questions, I would say slope is quite an important consideration when you're looking at walkability of an area. They've done studies and generally people perceive the slope of a hill to be steeper than what it actually is, and that does inform their decision on whether or not they're going to traverse it. We've accommodated for this in the model. So most of the times when you're looking at a walking speed, they use a figure that's primarily based on a flat surface. So if you're not going up or down a hill, what would your maximum walking speed be? Our model not only looks at the speed that you would walk on a flat surface, but it incorporates your speed going up a hill and down a hill and how it's different. So most people, they'll walk slightly faster going downhill until you reach a certain gradient, and then your speed will drop off quite dramatically for safety and other reasons. Similarly, as you're walking uphill, you'll walk a little bit faster and then you'll slow down the steeper the incline gets. There was a second part to the question.
The crucial question is, in assessing walkability, should we consider people's preparedness to walk up steep hills,
Sure,
as opposed to how long it would take them to walk up the hill?
Yeah. In that regard, what surveys and studies have shown is people will walk depending on what their motivation is. So in general, people will walk a max of 5 to 10 minutes in order to get to a transport stop or in order to get to work. They'll walk a bit further if they're going somewhere more pleasant, like to a park or to a beach. They'll walk further again if they're going somewhere with additional amenities. So for example, if you're going to a town centre where you have access to shops and libraries and community services, people do tend to walk up to 20 minutes. But having the hill there does impact people's decisions insofar as it's a longer walk, it's a more arduous walk. So they do take that into consideration. And that's why we did build the timings into our model for when people were walking uphill. That was to accommodate a slightly more arduous journey as you're going uphill. And when we were developing our catchments, we didn't just focus on single directions. So our catchments are based off 4 different walking catchments averaged together. So we looked at walking toward a facility and away from a facility for both people who would be slower walkers and more moderate walkers in terms of speed. And then we averaged that together.
But I think you're missing the point. What's exercising me is the people who will get to the bottom of the hill, look up the hill and say, nah. It's not that they could get halfway up the hill or all the way up the hill in 10 minutes. It's they're going to stand at the bottom and say, no, it's not going to do that. Not every day.
Yeah.
It's the psychological element. It's not whether they can do it, but whether they will do it.
This won't completely answer your question, but I did include in my evidence how many people actually are walking. This is in relation to the city centre, but it's relevant in terms of slope from areas like Oriental Bay in Mount Victoria and Kilburn, which do involve quite a lot of slope, and the proportion is really high, especially compared to other parts of New Zealand. And also Mr. Cribben's evidence had some data which was even higher than my own, so I just commented it and left it at that. So I think it is a useful question to point out that, you know, we have assessed our walking catchments and did account for slope based on someone who has relatively average to low average mobility or speed, and that the typical person in Wellington often does walk a lot up hills, and the data from Stats NZ shows that, but it doesn't account for perhaps with people with disabilities, and that's probably because we didn't think that the national direction really focused on that when looking at where to enable high density, because that otherwise it would cut out a lot.
The other aspect of that is people may also want to walk down the hill rather than stand at the bottom and look up at it. So walking down the hill might be more of a enticing thing to do. So you're getting the benefit of walking of going down. Like the cable car example.
What goes down must go up.
Yeah.
Your house is up a hill.
It certainly also depends on what else you're doing on that route. I mean, if you're carrying shopping, that might affect the walkability. I used to live in Christchurch in the central city, flat. I used to walk to the supermarket, but I used to get the free shuttle bus back because I was carrying a lot of shopping, usually wine. But,
yeah, and there was a New Zealand-based study where they looked at centres, Wellington, Auckland, Levin and Palmerston North, and they did measure things like what was the person doing. So they made assumptions on whether or not they're just out for a walk or if they're commuting. But they also looked at if they're on their phones, if they're listening to music, if they had a bag, if they were walking with children. And that does impact your speed and your ability to go certain routes, for sure, yeah.
And is the topography therefore a factor for perhaps having variable walking distances? I mean, looking at Johnsonville, for example, you know, where the topography is steep in one direction, might the walkable distance that's been allowed reflect that, whereas where it's flatter, the walkable distance might therefore be greater?
So where you have situations like that, the walking network model actually accounts for the reduced speed based on the gradient that you're going up. So a really good example is if we look at the central city, so we draw our walking catchments from the central city boundary, and the difference between 5 minutes and 10 minutes is quite large because you're still on a relatively flat surface. But once you try to go from 10 minutes to 15 minutes, it's not that big a change. I mean, down in the southern, around Newtown area, it's still flat, so you get a big difference. But if you look at Tinnacorry or going up towards Kelburn, it's really minute, and that's because the topography is so steep. The extra 5 minutes doesn't get you much further.
Definitely understand the correlation between speed and distance. That's very easy. But what's the correlation between topography, particularly in steepness, and motivation to actually to walk? I mean, I attended a hearing many years ago in Johnsonville where people said that they weren't prepared to walk to the supermarket, even though they were close. They wanted to drive to the supermarket because they had shopping to carry back, and they weren't motivated to carry that back up a hill.
Sure.
So even though they might have lived within a 5-minute walkable distance, that wasn't motivating them to actually walk. It motivated them to take a vehicle.
Yeah, I mean, it's very difficult to measure motivation on a large scale like that without actually surveying people. I know anecdotally, I used to live on the terrace right beside Bolton Street, and that's where our tsunami zone is. And often I'd look up at it and say, oh, would I take the risk of the tsunami or would I try run up the hill? And then as part of our consultation process, I was approached by a man in his 70s, and his critique was that we didn't go further because he could walk further up Wellington Street in 10 minutes than what our catchments were showing on the map. But yeah, apart from that, it is really difficult to definitively say how motivation is going to affect it without doing large surveying quantities. Yeah.
Commissioner Lutz, you had a question.
Just going back to the inner city where you said, you know, people are coming from Oriental Bay or from Mount Vic, and they will walk much further and are prepared to walk. How does that actually, or how has that been taken into account that this is most likely their walk from home to work? That's not one of 3 steps going from home to the bus stop or to the train station, hopping on this train, sitting there, then hopping off and having another 10 minutes to go. There is, I think the motivation is very different, and I could imagine, for people who can just walk from home to work rather than doing all the steps in between.
So I understand, Commissioner Lutz, that you're asking how is that taken into account?
Yeah.
The different types of trips that people take. So it's related to the motivation question in part, I think.
Yeah.
So generally we look at, as directed by national direction, where can people walk? But I think it's worthwhile taking into account why this is happening, and the intent is to enable more housing and more development in areas near, well, particularly near rapid transit, but also near local centres, so that regardless of whether it's to take your kids to school, but then pick up something from the supermarket, or maybe go shopping, or maybe hop on a train and go somewhere else, that there's more trips that you can do with walking than if you lived out in the suburbs and had to drive everywhere. So I think that's the overall thing. It's not so that everyone can walk and that everyone obviously can't walk all the time, but it's about so that more of our journeys can be made through active transport, public transport, and so get the benefits from that.
I think we might have a stop and have a cup of tea. It's 3:15. We'll be back at past the hour. Before we go though, Mr. Osborne, when do you have to leave the building?
I've got a flexible flight tonight, so I'm here as long as you need me.
Thank you.
Should have said.
Thank you, Dan.
We'll be calling it 8.
A dangerous offer, but we will take it up on it. Thank you very much. As I adjourned until 3:30. Restarting the hearing. Thank you, people. Commissioner Black had some questions.
Just change the text slightly. I want to ask you a question about Charitable. I'm familiar with that area, and it has got fairly low amenity, as you've alluded to. In fact, it's sort of semi-industrial kind of area as well. And I know that Keir Landings is there, but I was surprised that you put it at 10 minutes, given that they're actually, as far as I'm aware, there's no plan to improve the amenities around there, albeit that Keir Landing is getting well developed. So what was? Can you expand on that a bit?
Sure. Some of the factors were that, as I mentioned earlier, all submissions were recommending 10 to 20 minutes walkable catchment there. I should note, the proposed plan also has it at 10 minutes. It's not something I'm recommending changing. I'm recommending retaining the existing 10-minute.
Oh, was it 10? Yeah.
Yeah.
Oh, yeah.
It is.
Yeah.
Another factor in the draft plan stage, when the staff were looking at it, is Ngāti Toa were very supportive of intensification in that area, and saw it's a good opportunity to increase housing for their iwi, and also to improve social services in that area. And yeah, I mean, there is, in terms of accessibility, more generally, well, it is in that light industrial area, but there are increasing services being provided, given that there's a large subdivision on the other side of the road going on, including a retirement village and lots of medium density housing. And it's not that far a walk to the shopping centre, and there's also a really good cycleway that goes along that river to the shops as well, and to the railway station if you want an express train. I don't know. Yeah. So yeah, it was a combination of support for 10 minutes, local iwi support for it, and more of an opportunity for social and affordable housing, and just general growth in the area.
Yeah, I'm familiar with that area because I'm doing some work on upgrading the access to the Porirua city centre from that, which is the other way rather than. But the other part of this question was in relation. Linden was the next one, but there's another couple, I think. Was that you've gone from 5 as notified to 10, and I know that you did talk about that earlier, but it was you said that there was, because there weren't any submissions, wanting it at 5. I'm not sure I got a reason why you changed it to 10. What in your thinking changed your analysis?
So standard practice for walkable catchments around rapid transit is to start at 10. In fact, there's, like I said in my introduction, there's some arguments from some submitters that 10 should be a minimum, an absolute minimum, and then you go up from there rather than going down. And because that is generally where people walk to get the distance you get to walk to a good train service to get where you want to go. So I did follow closely the Ministry for the Environment advice on that and guidance. Notwithstanding some of the comments on how we give weight to that advice, I think in this particular instance it is their overall document on implementing the intensification provisions around with walkable catchments. I felt to be quite good. They identify all the different factors that influence walking catchments and have references to some quite good research. So I use that.
And why was it notified at 5?
Yeah, because it was initially in the spatial plan, it was 10 minutes. And so that got put into the draft plan. And then with the proposed plan, it got kept at 10 minutes for Keneperu, Tawa, and Tawa. And for Linden and Redwood and Takapu Road got reduced to 5 minutes. Do you recall?
It was Takapu, Redwood, and Linden, yeah.
I don't recall a major reason why, except perhaps the council. It was more general view from the council that they wanted smaller walkable catchments around the less major, around the rapid transit stops that don't have larger centres like local centres or metro centres nearby.
But you decided to change to what was standard.
I think up to the maps. Actually, you're on the bed.
So I just had a little bit of trouble following the map for Kendala. So it's about 335, 83. It looks like that map's got a bit of a crossover between different stations, is that correct? In terms of walkability?
Yeah, that's correct. I wanted to show the overlap between the Box Hill station further down and the Kandala station. So I showed that in purple with a purple outline.
The reason for that area being 5 minutes walkable, that's Kendala Station. So, was topography quite a big factor in that? Because it seems to cover the more gentle area around Kendala and that sort of stops.
So as Ms. Hammond pointed out, the accessibility in terms of slope topography is generally already incorporated into the model, and the lines that are drawn from there. So yeah, that's why perhaps the Kandala station is 5 minutes. It looks a bit larger, although zoning is relevant here, than say your Crofton Downs, which looks quite small. And so yeah, you'll notice that where it's steep, they tend to be a lot smaller.
And the next page, a similar one. It's the same issue. You're showing the overlay again. Still present in terms of walkability.
That's correct. Yeah.
Questions from our commissioners?
Anything?
Yeah, well, just one thing from me. I've skipped 384 paragraphs.
We stop before then?
Yeah. Does anyone?
Stop at the central city walkable catchment. Point made by some of the submitters is that in terms of employment, the overwhelming weight of office accommodation doesn't go much further from the railway station, doesn't go much further than Stuart Dawson's corner. Okay, it goes a little bit further, but not much corner, not much further. So if you're talking about the distances are all to the edge of the town centre, but so if you talk about coming from Newtown, it's a long way from Newtown to, say, Bowen Street, and all the public service office blocks now, well, it's now full of lawyers, I think, shifting in there. And that Mr. Cribbins from Wakatahi had this interesting map that showed that the walking population was much higher in some segments around the central city than in others. Did you give any thought to having a hybrid 10 minutes in some directions and 15 minutes in others?
That wasn't an option that I actively considered, and I think there's some fairly good reasons for that. Definitely there's the highest concentration of offices is in that area, but the city centre zone has a lot more than offices. There's a lot of major draws for other people who aren't office workers, You've got the Massey University, which is down in the southern end of Te Aro. The hospital is a major employer, and a lot of hospital workers like to live, if they can, where there's housing available, around the new town or within a walkable distance of the hospital. Te Aro, Yes, Te Aro itself is evolving fairly rapidly into a real mixed-use area, away from its historic light industrial area into a lot of apartments, a lot of retail, a lot of small businesses, and so as a whole, the city centre has many destinations in it. It's one of those. It's a real draw card for people who want to walk into it. So I would still support having a walking catchment around the edge of this city centre zone that is consistent.
Well, another way to look at it is there are submissions seeking a walkable catchment around Victoria University. Is there a case for, as you say, what's walkable to the hospital? You've got a huge pull into the hospital. What's walkable to Vic? What's walkable to Massey? Like, you've got massive individual draws, and then a lot of space in between them where, yes, it's evolving into small businesses and a lot of apartments within the central city, but it's not much more than that. You sort of, where are you looking at a big area, or are you looking at individual draw cards and saying what's the pull in those various places?
So we haven't identified individual draw cards like Victoria University as one location why we should apply a walking catchment where a 6-storey building should be enabled within it. As we've outlined earlier, the approach to growth has been around those enablers of growth, and in and around our local centres and our larger centres where they have those amenities, those enablers of growth like schools, open spaces, access to public transport, places of employment. That's where we have allocated a large amount of growth in and around those areas. Otherwise, we have turned our minds to policy 3 of the MPSUD and what that asks us to do in terms of enabling growth from the edge of the city centre zone, the edge of the metropolitan centre zone, and where those 6-storey areas should apply. So no, Victoria University and other large facilities have not been singled out as reasons why there should be walking catchment methods applied to them, but they may well be one of those contributors to growth, of enabling growth.
Around Newtown, so there is no catchment around Newtown. A large part of it, as you said, at the north is captured by the city zone. But Newtown is quite a significant centre on its own. I have read what you said about spatial plan, and I didn't, but it is a centre. It's got supermarkets, got lots of shops.
So Anna may do slightly better, but I'll give it a go. So the policy 3C is focusing a walkable catchment approach on city centre zone, metropolitan centre zone, not local centre zones. So for that we go down to policy 3D, which is looking at the concentration of activities, and it almost gives us a little bit more freedom to look more broadly at the nature of the centre and the area around it, and the potential infrastructure upgrades and the amenity heat mapping that we got, and we're able to compile that into what the appropriate densities are around that centre, which is why actually there is some zoning for 6 stories around in the proposed plan beyond the 10-minute walking catchment, because it was seen as appropriate given how good Newtown is as a local centre.
Further to Mr. Wharton's point, so policy 3D asks us to ascribe a level of building height and density commensurate to that with the level of commercial activity and community services, not just based on the blunt mechanism of applying a walkable catchment. So what we would say is that the method which we've applied about using the enablers of growth, which help support create a well-functioning urban environment with various different types of housing and opportunities for employment and things that contribute to people's well-being, is a more refined and focused version and focused methodology for applying growth and building height and density than just a walking catchment model.
Well, that's thank goodness. But I did think with Newtown in particular, you know, you likely to have rapid transit going up there as well, and it is, you know, area was just, I thought it was sort of
Yeah, good point, Commissioner, and that sort of points to Mr. Wharton's points earlier in today's proceedings, where he said, don't know where the stops are going to be. So unfortunately, right now at this point in time, we can't turn our mind to looking at policy 3C and what that tells us about upzoning around rapid transit stops. So for now, this is what we can do, but when the time comes and we do have some certainty, we'll be able to turn our mind to addressing that upzoning.
Thank you.
Our next question was Charitable. Mr. Taylor at the Johnsonville Community Association gave us a copy of 2013 Environment Court decision that basically said that areas A and B on figure 43 were not practically walkable. That's my paraphrase of the court's conclusion. I suppose my question is, well, what's changed since then?
Yes, so we did some on-the-ground testing around Johnsonville. Part of that was driven by the 2013 Environmental Court decision. I'm just trying to find where. Yes, so the two main areas were the crossing point in Middleton Road. They felt that it wasn't safe to cross there. When we did our ground testing, there was actually pedestrian infrastructure that was at that point in the road. And when we reviewed imagery from 2013 up until when we did our ground testing, we found that at the time that pedestrian infrastructure wasn't there. So now at that particular crossing point, they have ramps at the curves to make it easier to get onto the road. And then they have, I think it's called a pedestrian refuge point in the middle, so like a raised platform. So if you can't cross the entire road in one moment, you can pause. The second area, I believe, were the steps leading to Sheridan Terrace, and it was felt that they weren't accessible. And I think the specific example in the Environmental Court decision was by women with prams. And I accessed those steps myself while I was heavily pregnant. So our determination as a team was they are walkable. They're not easily walkable, but you can actually walk up them. So they should be included as part of the walking network. And because they're included as part of our walking network, the catchment was able, or the model was able to include them in the catchment.
And panel, the other major difference, of course, is that after 2013, we now have the MPSUD, which directs us to use walkable catchments, which in 2013 we didn't have.
Could I?
Yes.
You were just saying you walked it heavily pregnant. They are walkable, but not easily walkable. How enticed would anybody be if it's not easily walkable to actually walk it? So while it's walkable, you know, if you've got a lot of people there, they don't walk it because it's actually a pain to walk it. Is it really a walkable catchment?
So, Andrew, you might want to interject with this one, but I suppose the purpose around the catchments isn't that people have to walk them or that they have to be, that people have to be willing to walk them, but that they are walkable within a walking network. So even though some people might look at those steps and look at that route and say, not for me, I don't want to walk that route, it is still a walkable route, therefore it's still included within the walking catchment.
I think
well, that comes back to the question I started with: how much of this is motivation, and how much of this is the ability to walk. Like people walk from Cape Reinga to the Bluff, but I don't think many people do it, and you wouldn't even contemplate using that test. So it's clearly something less than what is physically walkable by some people.
The test is quite well set out in Ms. Hammond's evidence, I think, in terms of the council's approach that I support, which is that it's a something that is walkable for a person who's walking at a medium to slow medium pace, and can do it. And I expect that people who, who it would be attractive to live in those areas are probably people who enjoy having a shortcut down to town. Not to say that they're all there. There will be people who will not want to use it, but that's the main test is walkability rather than accessibility and desirability for everyone. That's not the test in the national direction. The test is walkability, and so that's the approach that we've used.
Yep.
Just Kilburnie, just to clarify what you are recommending here. So this is 7 onwards, and that leaves on paragraph 376, the following one. But you are recommending what is shown in the map, but you recognise the issue of natural justice in terms of people not being able to submit on your recommendations. Nice.
Yes. So just to summarize, I think what my main phrases here is to give proper effect to the NPSUD, I recommend that the area mapped be rezoned. And then in 377, I recognise that there's a natural justice issue of making such a major change without those being affected being able to submit. So if the panel believes this is a determinative factor, I recommend that the residential land remains zoned as notified in the plan, subject to any other recommendations, and that it be referred back to the council to introduce in a separate variation. So I am kind of giving that back to you as to which is more determinative. I'm sorry about that.
If I can just ask, does the same apply to your proposed changes for Linden, Redwood, Takapū, PDP 5-minute walking distance? You're proposing 10. That will spatially have a difference between the two. Have people had the opportunity to comment about that as well?
So the difference in with the Tawa Valley stations is that these have been proposed as with 10-minute catchments in the past. So it was discussed as part of the spatial plan, and it was also notified as such through our draft district plan as with 10-minute walkable catchments. And so it's something that is familiar to everyone, well, not to everyone, but at least people who are aware of it were there and were able to make comments on it. They were able to discuss to the council on it as well. So I feel that natural justice component is far less significant from that perspective.
But if you viewed the plan as notified, thinking that wasn't, this is what I've got to look at the moment. And the plan or the recommendation is to make it a little bigger. Is that not a natural justice issue, even though it might have been discussed in non-statutory planning instruments before?
Well, others may want to contribute. I don't see that everything should either be notified or removed, because even removing something or reducing something, okay, no, sorry, let me rephrase. The process that we've been through has had a lot of opportunity for public feedback and public engagement. And even within this proposed plan, that's why we have further submissions, is that the submissions are notified. And we had a number of submissions asking for 10 minutes and no further submissions opposing. Well, perhaps no, could have been some opposing. So there is also the opportunity for people to oppose through that process and to oppose it in here. So maybe from a legal perspective, you may want to comment.
I mean, it seems to me the recommendation is that to recognise that there may well be a natural justice issue, but leave it in your hands. Okay. If because of the natural justice issue you're not prepared to, then there's a proposal how to make that happen.
So the same doesn't apply to Kilburnie then? Was it floated that you needed to have a 10-minute distance around Kilburnie before metropolitan centre? And now, yeah, what's the difference between the two?
So yeah, that's right, Commissioner. I think that is the fundamental difference, is for both the Johnsonville and the Kapiti lines and the rapid transit stops there. There's been a lot of consultation done both informally and quasi-formally through the draft plan about what size of walkable catchment should be, and that there is potential for this to be 6 stories, whereas around Kilburnie there wasn't any of that, and that's because we had seen that the natural hazard risk was likely to be significant around that area, and so we never breached with the community that that we were proposing to upzone them to 6 stories around that area. So it's only now that we have mapped the risk factors and they're officially now qualifying matters that we have to go back to the NPSUD, which says you must enable at least 6 stories around a walkable catchment of metropolitan centres unless there's a qualifying matter, which you can't. So that's why I think Kilburnie is quite unique in that this hasn't been raised with the community like it has with the other centres.
To be clear, I was discussing Kilburnie, not Johnsonville. I don't see that there's any natural justice issue with Johnsonville.
Yeah, I guess to paraphrase even further, at each stage of the planning for growth process, the spatial plan and the draft district plan, the Johnsonville line and Johnsonville itself and the Tawa line, including Linden and Keneparu, have always been at some stage either identified as being mass rapid transit and having walking catchments around them or not, and people have had the opportunity to submit on that, whereas with Kilburnie it hasn't been identified at any stage of that process as having policy 3 apply to it in terms of a metropolitan centre walking catchment, only insofar as policy 3D or the commensurate building heights one has. So this is not something that we have engaged with the community on over the planning for growth process in any of those 5,000 submissions, which is why Mr. Wharton recommends a bespoke approach for you to consider.
And just to also pick up, just slightly going back to the central city, in your supplementary, recommended tweaking, if I the walkable catchment DZZ, include a block roughly just above Victoria University there. It's the same issue that we were just talking about in terms of natural justice and people being aware that suddenly their property could be area. Is that the same sort of issue with that one, just to make sure we're clear about where it might battle?
Yeah, Commissioner, I think it's getting there because it is like a 15-minute catchment has been proposed before. But for those particular properties, they would have been part of the conversation about walkable catchments to the city centre zone, that not have seen their properties on a map in that sense. So if that's significant to the panel, that could be something to factor in. I had an interesting chat with a gentleman just outside it who demanded to know why his house wasn't included. And he said that his neighbours have been talking a lot about about what is possible and what is the council doing and what can we do, and so. But yes, of course, from a formal point of view, the question is the discussion about upzoning within the city centre zone or towards the city centre zone sufficient? The other difference, which is why it's not as bad as or not as significant as for Kilbirnie, is that the area is actually being upzoned already. So it's in the current plan, it's outer residential with a maximum height of about 8 metres, I think. In the proposed plan, it's 14 metres or 4 stories. So it's already a significant jump. And so it's from 4 to 6, it's a little bit more. But perhaps I'd argue, and well, people may disagree, but the effect is relatively minor compared to what Kilbirnie would be looking at.
Around the maps. Anything more on walkability, people? Mr. Ballinger, I've been waiting patiently. We'll wait. We'll give Mr. Ballinger his go, and then I'll talk to you.
Thank you.
Just to be clear on the ground rules, the nature of cross-examination means this is, you can sit there, but please don't feel the need to assist.
You don't have to move. It's okay. No, you're fine.
Moral support is fine. Gestures, notes,
nudges,
any other forms of communication are not fine. Mr. Ballinger.
Thank you, Mr. Chair. Mr. Wharton, I wanted to ask you a couple of questions about your Section 42 report. So I'm planning to take you through the objectives of the NPSUD, which you've analysed with respect to the proposal to classify the Johnsonville line as a rapid transit service. And I understand that the reason you've looked at those objectives is to test whether the proposal for Johnsonville line is aligned with those objectives. Do you agree with that? That's the basis for your assessment.
Yes, it's important that the policy is interpreted and applied in the broader context of the objectives under the NPSUD.
So I'll take you to what you say about Objective 1, and that's at paragraph 159 of your report. Now you see in the wording of Objective 1, which you've quoted there, that it's centred around enabling all people and communities to provide for their social, economic and cultural well-being and health and safety. So it's about all people.
Can you confirm what paragraph you're referring to?
159 on page 41.
Oh, yes.
Yeah.
Thank you.
So you'd agree, Mr. Wharton, that Objective 1 is looking at the enabling all people to provide for their well-being and health.
That's how it's written, yeah.
And I just want to invite you to compare that with the wording of Objective 3. If you flick over a couple of pages to paragraph 163, just below 163, you'll see that Objective 3 is about enabling more people to live in areas that have particular features. Yep, got that?
Oh, yes.
Yep,
sorry.
Thanks. And so just now flicking back, sorry, to para 159 and what you say about objective 1. So what you have focused on in your analysis is how the classification of the Johnsonville line enables more people to access certain services that are near those stations. Do you agree with that?
Yeah, that was the focus of that paragraph that mentions allows more people and communities to provide for that. Yeah.
Yeah, and you haven't assessed as part of your analysis of objective 1 whether those more people would have access to similar services if they were housed elsewhere.
Oh, so you're talking. So just to clarify, can I clarify? Yeah. So asking about have we assessed about where people are best placed to access those services and providing for health and well-being and all that?
Perhaps not where they're best placed, but whether
perhaps it's fair to say, like just going back to earlier comments, that we generally focused on enabling growth around centres and city centre and around key public transport routes. I think the NPSUD has kind of come over that, and in some ways it enhances that approach, and in some ways, and in some places it accentuates this. And I think this is the Johnsonville line is potentially an example, or it is an example, where the recommendation is for slightly high density because of the obligations in the NPSUD. But.
Okay, but you aren't certain on whether the Johnsonville line upzoning, if I can call it that, will allow more people to access certain services compared with if that upzoning was elsewhere and those people were housed elsewhere.
Still not 100% clear, but so this is about enabling people to live in locations with good services is generally what the objective is about. Yes.
Yeah. Okay. Thank you. I'll take you then to objective 2, which is just over the page at paragraph 160. Now, your conclusion on objective 2, as I understand it, is that the classification of the Johnsonville line as rapid transit or not will not affect housing affordability or competitive land and development markets. Is that a fair summary of your conclusion there?
With a slight difference, that the conclusion was generally in relation to the city overall. So yeah, will not affect housing affordability or competitive land and developed markets in the city, at least based on current construction costs and prices. There obviously will be effects locally.
But overall for the city, it doesn't increase the overall level of affordability.
Just given the ratio and the amount of realisable development compared to the amount of total realisable development in the city, I expect it wouldn't be significant, but also I recognise that I'm not the expert in this area, so if the expert comes up with a different conclusion, he's quite happy to defer to him.
And so just noting your conclusion on objective 2, which is that the Johnsonville line will not overall for the city affect affordability. I wanted to take you to your conclusion on objective 5, and that's over the page at paragraph 169. So, and objective 5 is about taking into account the principles of Te Tiriti o Waitangi. Now, you've said as part of your analysis there that the Johnsonville line may support putting whānau Māori into quality, safe, warm and affordable housing. I just want to put it to you that seems to be inconsistent with your view that overall housing affordability isn't impacted by the Johnsonville line.
The question is,
so why do you say that it increases? Do you say that it increases affordability of housing for Māori?
the text here was that the high density housing may in part support putting whānau Māori into affordable housing by allowing more housing units on land parcels owned by Māori. Perhaps the caveat to that is I haven't actually done the assessment of how much land in these catchments is actually owned by Māori. So it could be a small to negligible effect, or it could be a major effect. I think it's important that this is a focus on the potential benefits of housing for Māori as opposed to more general housing in the city and housing in these walkable catchments.
So you haven't done a specific analysis of the impact on Māori and housing Māori?
No, the main reason I mentioned it is because one of the few, in fact, I think it's only one or two planning documents with the council is actually the housing strategy by Ngāti Toa, who talk about that enabling housing throughout the city and having more housing options of different types for whānau Māori is really important to them. And to be fair, their focus is on the areas principally that they hold for the area. But given that the talk was about taking into account the principles of the treaty, and we have a relationship agreement with them, I thought it was worthwhile mentioning that.
Yeah, sorry to be jumping around a little bit. On objective 3, this is the objective about enabling more people to live in areas which have particular features, and there's 3 features, I suppose, that should enable more people to live in. The first of those is an area with many employment opportunities. I take it from what you've said in your report that you do not consider that's a relevant matter for the Johnsonville line decision.
For the employment opportunities, that's correct. I mean, there are obviously a few jobs there, but it's not as considerable as elsewhere. The centre zone, Kandala is zoned as a local centre, and that had a factor to play in the walkable catchment component of it. So a larger walkable catchment for Box Hill because it was within a block of the local centre zone.
Yes, I'll come back to the Box Hill recommendation in a moment. Thank you. Moving then to objective 6 of in your analysis of that objective. So objective 6 is generally about, well, objective 6A is about integration with infrastructure decisions. And you'd agree that roading in the city is a part of infrastructure.
Yeah.
Now, I know that you've read Dr. Helm's statement of evidence, and you'll see that he is of the view that the classification of the Johnsonville line as rapid transit and the growth that enables would lead to an increase in road congestion. You've seen that evidence?
Yeah, I have.
And you'd agree that if this classification of Johnsonville as rapid transit leads to congestion on the roads increasing, but that's a poor sort of planning outcome and example of infrastructure planning.
Yeah, I don't think I agreed with that assessment that because these suburbs have slightly higher rates of car use than other areas closer in, that therefore when there's more people moving in that we get more congestion. Because there are other suburbs such as out in Chuden Park, and which have much higher use of car use, and partly that's down to much better public transport options. Another reason is that in my capacity study, one thing that we found is that people who live closer to the train stations tended to use the train more than people who lived further away who didn't. So I don't think that's a necessary causational thing that because it is in these suburbs, a lot of people are using cars, that if you increase people in the suburbs, I think it's more about where those people are located, which is why the intensified land use is really close to the stations and close to the the neighbourhood and local centres, so that we get more mode shift from that.
Turning then to objective 7, which is on the next page. So objective 7 is broadly about having good quality information to support planning decisions or inform planning decisions. And you've referred to the development capacity assessment there. Now, just picking up the point that you just were talking about whether or not there might be an increase in road congestion. Am I correct in understanding that there hasn't been a traffic impact assessment of the consequences of upzoning the Johnsonville line area?
So there are broader assessments being done because largely actually let's get Wellington moving, because we're looking at improving your cycling and bus infrastructure over down Hutt Road, Thorndon Quay, and also around Johnsonville and down Noaranga Gorge. So there are traffic studies from that, but they do tend to be limited to the Johnsonville to Wellington crowd and not the western suburbs. There's less data available on that. In principle, though, the general aim for both regional and at a city level through our climate change objectives is for increased, less use of fossil fuels and more use of public transport and walking and cycling. So if it's the case that this zoning would result in large-scale car congestion, which I'm not seeing is the case necessarily, particularly given the amount of growth that's currently happening there, given that this is an enabling thing. I think the priority is, the focus should be more on how can we support people to be using public transport and active transport within the areas.
Yeah, so just to clarify, there isn't a traffic impact assessment of the consequences of enabling upzoning.
Not for those suburbs. For Johnsonville, there is.
There is an impact assessment for Johnsonville.
Well, looking at there's traffic data, I think it's fair to say, on potential population projections around Johnsonville and the effect that could have on traffic.
But that data hasn't, informed your assessment or recommendation.
No, because it's not as relevant to where most people are getting on, which is all the other stations down the line. So
right, so it's the data you're talking about is only about the Johnsonville metro area, not the stations on the line. So there is no traffic assessment of those stations.
No, not that I'm aware of, and I don't think there's been one.
Thank you.
Mr. Ballinger, you're up to 15 minutes. Can you pick your shots?
Time goes very quickly, thank you, sir. Yeah, I'll just ask one or two questions about the walkable catchment around Box Hill then. I think that the rest of what I was going to cover has come out fairly well. So turning then to your recommendations on Box Hill, and that's at paragraph 327. On page 79. So you've recommended a 10-minute walkable catchment around Box Hill. And you've recommended 5-minute walkable catchments around Kandala and Simla Crescent, which are the adjoining or neighbouring stations. Yeah. And the basis for the larger catchment around Box Hill, you say in para 326, is the existence of the local centre zone. That's right, isn't it?
Yeah, that is a key factor, and it's one that's also mentioned in Ministry for the Environment guidance about, are there local centres nearby which could affect the size of your walkable catchment.
And the premise of that, as I understand it, is the utility of someone getting off the train, using the shops, and then going home.
Yes, or even not using it at all, but taking advantage of the fact that you live near a local centre and can just walk to it and home without using the. So yes.
Yes, and so your recommendation is for the walkable catchment to be 10 minutes on both sides of the Johnsonville line around Box Hill, so to the north and the south.
Yeah, the walkable catchments are measured from entrances and exits to the stations. That's a general approach for all of our stations.
And so the local centre zone is only to the south, but your recommendation is 10 minutes to both the north and the south.
Correct.
Right. Thank you. That's no further questions.
Thank you, Mr. Bellinger. Sir, I don't know your name, but the process is, I'm happy for you to tell me what question you would like to ask, and if I'm happy with it, I'll pass it on. So what?
Well, thank you for the opportunity, and thank you, commissioners and ladies and gentlemen. My name is Grant Griffiths, and I live in Kandala. And there's been a lot of discussion on the Johnsonville line using the words mass rapid transport system.
Sorry, excuse me, would you like a microphone just so that I think people might be able to hear you online?
Well, thank you.
Into that.
A good suggestion. Yes, so let me go back to the mass rapid transport system. When I think of that, I can recall when I first heard it, and I can also remember being on mass rapid transit systems in various places such as Hong Kong, France, the UK, Singapore, Australia, Germany, Italy, Poland, Malaysia, China. I don't think the Johnsonville line matches up with mass rapid transport system in the general public's view, but I would invite the members of the council group to respond. But before I do, I've been remiss. I should have thanked you for all the material you've provided today, which has been useful to all of us.
I think distilling.
That's it. I finished.
Thank you, Mr. Griffiths. I think the question is a legitimate one. Have you considered offshore comparisons in this? Because as we've agreed, all of these descriptors of rapid transit and the NPSUD are relative to something. Have you considered offshore examples that are generally considered rapid transit?
I haven't included any in my evidence. The main comparisons I've made are to New Zealand examples, so to the other lines in Wellington, how that's dealt with, and also Auckland, which have, I think this is a national policy statement for New Zealand, and we inevitably will have to give a New Zealand flavour as to what it means. We won't be unlikely to get a Hong Kong style metro here, but we still have the direction to give effect to NPSUD, and we need to see how it works here. I have had a lot of experience actually comparing other rapid transit systems actually in other countries, but not in this context, in terms of let's get Wellington moving and what's best practice. But I haven't in my evidence applied the criteria in the NPSUD to those.
Really, Hanger Line was the one that was cited in some documents, also PT4. Did you do a
I believe so. If it's not on my evidence, I can pull it out.
Because people made that comparison.
Yes. Yeah. It might be.
Seemed to be some comparison.
I could potentially put that down in a paper for you, because I do have some thoughts. I think there are some significant differences between the two lines and how they're treated, both Onehunga and Johnsonville. But I could put that in a page for you.
I think that if we could ask you to canvass that and reply rather than give us an off the cuff answer, because as the Commissioner identifies, I think one of the points pointed out by I think it's Dr. Helm, is that drawing attention to the update of the ONF classified two lines as PT4. One was Onehunga, the other was Jayville. And so if you consider that comparison is not apt, then I think you need to tell us why in reply. I think that's all for Mr. Wharton, but I think we'd better interpolate Mr. Osborne if he's going to get home tonight. Thank you, Mr. Ballinger.
Good afternoon, Commissioners. My name is Philip Osborne. I'm an economic consultant for property economics. Just in light of time and some of the nature of some of the refined questions today, I think I can give a fairly quick summary to my evidence and to the process that was undertaken. Property economics was engaged by Wellington Council to assess the residential development capacity enabled by the proposed district plan. Property economics has also undertaken this process for Pororua City and is currently in the process of undertaking it for the majority of the region's TAs. In the 2021, just to give some context to the way that the numbers have progressed through time, in the 2021 HBA that was undertaken by Wellington City, there was a shortfall in realisable capacity of around about 10,000 households. The changes from that time to this include two major changes. One is obviously the inclusion of the MPS and the Amendment Act into the proposed plan, as well as some rather significant updated valuation data that went into the modelling. The model itself includes a number of different processes. The first one, which was undertaken by Urban Edge, assessed the enabled capacity under the plan, which is simply theoretically what could be done that would produce the most houses across Wellington City. The result of that was around about 240,000 additional houses or additional dwellings that would be possible under the plan within the city. The second step is to assess the commercial feasibility of those houses. As I'm sure you can understand, that had a significant impact on that capacity potential. This looks simply at some market variables such as profit and construction costs, civil engineering, those sorts of things, development levies. This 240,000 fell to 77,000 feasible. The next step is one that is directed in different ways in terms of the guidelines of the MPS, but it looks at the realisable rate of that feasible development. That is, it looks at the different types of risk that are associated with typology. For example, a standard feasibility assessment will look at a 20% profit level. However, if you're building 200 apartments as opposed to building one dwelling and standalone dwelling, try to sell it, the risk is significant. And that reduces the chances of that happening at a grand scale across a city. That realisation, also looked at the motivation of individuals to subdivide properties for infill. And obviously, as time goes through, that realisation rate goes up because there's more likely to be a turnover of property, but many individuals would rather keep their backyard than obviously subdivide that. That impacts upon the potential capacity within a given time frame. Again, that has a larger impact over the short term than it does over the long term as those properties are actually traded. The final step of that is to look at the demand reconciliation. So essentially what we're saying here is that there may within the plan be enough to provide one bedroom apartments for all households that are needed. But that's not obviously what those households want. Not all households are created equal. The things that we look at in terms of that is we look at the average size of those households within household structures. That is that couples without children, singles, families are more likely to go into a higher density product or a townhouse than families with children and things like that. Also, we have to look at the likely size of that demand moving forward, because a larger house or a larger apartment is going to take more capacity. If you build a 120 square metre apartment rather than 260s, you've obviously halved your capacity in that particular regard. So we have to look at what's being demanded and whether what can be produced at a profitable level is likely to match that. In terms of the movement of numbers, we moved from 240,000 theoretical to 77,000 feasible, down to 63,000 that was realisable, and actually 62,500 that are demand reconciled, essentially. Now, those aren't necessarily all the highest profit level, which is why there's not a lot of difference between the realisation. They still make money, they make over the 20%, but they're not necessarily the highest value outcome for that particular site. Now, the reason that's appropriate is because you can produce as many one-bedroom apartments as you like, but if there's not the market to actually buy them, eventually that market's going to change to a different type of product. The final aspect of this assessment is to look at the qualifying matters and what sort of capacity those actually reduce. There are a variety of ways of looking at QFM. One is that it could have a direct impact on the nature of capacity, that is that you're restricting how many dwellings can go on a particular site within an area. The second one is it can have implications for cost, that is that you're having to undertake some sort of additional mitigation work on a site or in a particular area that is going to add to that feasibility cost. And the final one is the increase in risk. So if you move from a permitted activity status to a restricted discretionary, that obviously has not only additional costs, but additional risks in actually getting that through in the first place. So all three of those are actually modelled in terms of the extent of impact that they have on that capacity. The modelling itself found that would have and again, there's some of the QFM overlays or matters actually overlap each other. So there's not necessarily a matter of adding up all those and finding what the impact is. Sometimes that impact's already been created by a previous QFM. So the net result was a reduction in capacity of around about 12,500. That ended us with a demand reconciled feasible capacity of around 50,000 dwellings under the proposed plan. Now, Mr. Lees will obviously appear tomorrow and we'll talk to you about how he's done the demand assessments, but essentially that looked at about 31,000 at the time that we undertook this assessment, with a 15% buffer that's required by the NPS over the long term. That results at just under 36,000 that the council would need to consider in terms of that demand. So obviously with 50,000 that are possible, feasible and likely to be developed, we've got an excess of capacity as opposed to the 2021 HBA where we had a shortfall. There are a number of submissions that related to capacity and intensification in terms of the economics. The two key ones were talking about a type of staged up zoning, where you're not necessarily going with the extent of what is proposed in the plan, but over time increasing that. That in itself comes with a risk. That could be that you may not be zoning a particular area for as high a density as you would want, which means that you run the risk that developers will provide, let's say, standalone houses or terraced housing in an area where you might ultimately want apartments. That increase in improvement value, that is the cost of the buildings that you're putting on and the value of those buildings, dramatically reduces the long-term viability or feasibility of actually turning them into a higher dense product. The second significant one was talking about intensification and its impact on affordability. I think it was the evidence of Mike Cullen as well for Kaiangaora that talked about intensification actually supplying more and therefore having a benefit to the price of property. Essentially what we're talking about is we're talking about a more efficient land use. That is that instead of using 800 square metres, we're using 400. Now the value per square metre has gone up, but the actual cost of land per site or per dwelling has significantly reduced. In higher density products, there's typically a higher build cost per square metre, just because of the nature of having similar walls and soundproofing and all that sort of things. But generally, that cost is outweighed by the benefit and the lower cost of the site. One of the reasons that people accept less land or more dense product is because generally for what you get, it's less and it costs less. Yeah, I'll probably stop there and take some questions that might sort of direct it a little bit better.
Osborne, I took one question and one request for clarification. The first question is, have you assessed or taken account, first of all, have you assessed whether it exists, and if it exists, have you taken an account of an existing housing deficit?
We have not looked at the latent demand beyond what that which Sense Partners have assessed. So we haven't looked to see if in the market at the moment, in terms of, I'm not sure whether Sense Partners have taken that into consideration with the 31,000 that they've projected forward. But in terms of a base latent demand that exists in the market, we haven't considered that at this point, no.
Second question, second clarification, is at the end of your paragraph 2.11, I struggled to understand the logic in the sentence beginning of note. Can you walk me through what you've done and why it results in a smaller figure?
So this is dealing with the change from realisable capacity down to demand reconciled. So the reason that we end up with a slightly smaller figure there is that what's happened is, although, as I say, although there may be a capacity and a realisable capacity for a lot of small apartments, the actual demand composition may not fit that, and therefore there may be a component of families and larger households that require either larger apartments or require more likely to go for a standalone product, and that's why that actually drops down, because part of that has taken up the capacity that would be realisable. So if I have 2 terraced houses instead of 5 apartments because that's what the market wants, then obviously I've reduced my overall capacity that is likely to actually occur in the market. So we're trying to take what is feasible for developers to create in the market. We're trying to assess some of the risks that are associated with that. And then we're trying to say, well, what do people actually want? How is that going to reconcile in terms of that? And that actually drops the capacity slightly, simply because in terms of what is the highest profit margin, it's not necessarily what people are actually after. And we're trying to see if the proposed plan can actually give people what they would prefer at this particular point in time.
The specific examples, and I think this is what puzzled me, where you say less attached dwellings, I think it's not development, less attached dwellings, that's code for attached townhouses, is it?
Attached dwellings is a term given in the demand figures, which is for apartments and so terraced housing, yes.
And in favour of, because more people want the old-fashioned standalone house, even if it's on a smaller section.
Yes.
Throw it open. Any other questions? Start with Commissioner Dosh. Since he seems to be continuing being left out on the end.
Oh no. Thank you, Mr. Osborne. I've seen your evidence a few times before in various things, but I guess my question is the step change in terms of the numbers that you come up. You start with very broad. This is based upon this height limit. Bang, here's a number about theoretical capacity. And then you drop it down to those which are, I think you call them, well, realisable was the last one, isn't it?
Feasible, realisable, and demand reconciled.
Yeah. So, you know, having been a planner in Wellington for a long time now, there's a couple of key issues that I see from the development community, which I just want to make sure that they have been factored in. Obviously, there's topography and the ability to be able to develop a site. Steep sites, particularly if you're going higher, will require larger cuts. They'll require larger retaining walls. Seeing that yesterday in Johnsonville, for example, there's a development off the back of Johnsonville Road, which has got very high retaining walls on that. So that was taken into account in terms of topography and the ability to be able to actually build a product, because building apartments will require a different building methodology than building townhouses, for example. That be true?
Absolutely, yes.
Okay.
Yes.
And the second thing is in terms of land assembly itself. If you're looking at a 6-story zoning from an economic perspective, you're going to want to actually have a reasonable chunk of land to put 6 stories on it. And there seems to be a little bit of uncertainty where, which is why things like the Karori Teachers College was looked at for a retirement village, because it was in one ownership and you could actually go in there and do that. But has there been an assessment about how easy it is to actually amalgamate enough land together to produce a product? Because you've got a 500 square metre site, you're not going to build 6 stories on a 500 metre site. Recession planes kick in. Even at MDRS or higher density, the recession planes are going to kick in. But has this whole land assembly issue been actually factored in to the numbers that have come here?
The short answer to that is no. I've obviously seen quite a few of these across the country, and I don't think there's too many at this stage. I think that's what's being considered as the conservatism of this particular approach, where it hasn't included the aggregation or agglomeration of sites, and that there is potentially additional capacity that sits there. Agglomeration of sites in the New Zealand market is extremely difficult. It's extremely difficult, especially when you get closer to centres, to try and, when you've got split ownerships, when you've got small sites, when you've got different timings for people to sell their properties. It's extremely difficult to model for that sort of time aspect of it alone, never mind the risk that's associated. The risk that's associated with it would probably in any model cancel out that for the most part. It does happen, absolutely.
Is that where the checkbook comes in?
That's exactly what it is. You'd have to work out what premium a developer would be willing to pay, and the individual motivation or collective motivation of several owners that all coincide at the same time, that they're willing to sell for that premium, and whether it's going to actually occur. The sort of capacity model we have here is trying to look at simply those individual sites and see whether they're viable. But you're right, a lot of the large scale apartment developments are going to be aggregating sites, and they're going to do that over a matter of time and try and keep income in some capacity going while they do that on those land sites. But it's difficult to model because it's a very individual sort of thing.
A follow up from me, Commissioner Voker, you said that you've taken the conservative approach and not considered agglomeration. I wondered if it might be considered the opposite, that by not considering agglomeration, you haven't considered an aspect of feasibility, that if you can't agglomerate, it's not feasible, because you won't build 6 stories, you'll build something less. So is it the other way around?
So we've looked at whether it is feasible, obviously, to build these on these individual and some large sites. We've also looked at the model itself doesn't necessarily look at the maximum that can be built on a site. It looks at the maximum profitable. So that maximum profitable might be going to 4 levels instead of 6 on some sites. So it's not necessarily assessing just that maximum theoretical capacity on each site, but an iterative process in terms of decreasing that capacity and that typology.
Yes, but Mr. Osborne, that even the 4 levels might assume some level of agglomeration.
No, the actual way that the theoretical is done is just on those individual sites with the appropriate setbacks and so forth. So where the data that we got from Urban Edge was simply at an existing site by site basis. So it didn't assume any degree of agglomeration was required to actually develop that. Essentially an envelope of space was developed, and then that was divided into different typologies.
I interrupted you, Commissioner Dash. That was Commissioner Birch.
Yeah, I just had a couple of questions. Paragraph 2.4, you sort of, you illustrate the impact of 10% fall in sale prices and 10% rise in construction costs. And that was based on a late 2021 scenario, was it? Do you see that being quite different today, just knowing how much the market's changed for both construction costs and sales?
I mean, yes, I think the market is in a dynamic state at the moment. I think that
could be said to be something of a euphemism.
Yes, I mean, we at that time at the end of 2021, properties were at their peak. It was relatively clear, I think, to most people that they couldn't be sustained. It was also clear that construction costs were rising rapidly, and that's why that scenario was developed. It's one of the questions, I guess, that arises when you've got the guidelines that the MPS say that you sort of use current prices to look at capacity. The difficulty of that is when you look backwards on that and say, well, does the current plan provide for affordable housing? Well, no, because you use current prices. So for me, the modelling is about saying, does the proposed plan and the quantum that's actually provided, the feasible quantum, still meet demand when prices are affordable? That's really the question that needs to be asked. A lot of the affordability comes from external factors such as construction, interest rates. These are the things that are changing now that are changing affordability. I mean, affordability has less to do with the price of a property than the funding of a property at the moment and that cash flow issue. So it's about trying to find where that line is, that the plan continues to provide enough capacity with that price at a given level. We were comfortable at that point that we had actually taken something that turned out the market went in that direction quite rapidly. It continues to do that. There is more capacity still within the market. Changes in those prices also alter not only the feasibility but the realisation rate. If there aren't other options for people to make money in the market, they're more likely to go to other ones that have higher risk because there's very little money to be made in the market. So it actually is likely to drop the feasibility rate while increasing to a degree that realisation rate, where there's still capital in the market and it's still got to find somewhere to invest. It just is a riskier proposition in terms of development.
And just following on from Commissioner Dash before, you commented that your methodology is sort of based on, maximum profitability. And I just struggle with the correlation with, whether the land is suitable to be developed. Wellington's a probably good example. And that wasn't factored in at all.
No, so it was factored into 2 stages. The first one was through the theoretical capacity. It looked at slopes that just weren't possible to develop, for example, slopes. The second aspect of that was we had slope information by site, and that increased the cost proportionately. There's more sort of watershed moments of slope that change costs. There's increased need for greater for greater level of civil works and all sorts of things that are inherent in that. Now, these are averages because we're not entirely sure on a site by 40,000 sites across Wellington exactly what the practical implications are by site. So we took thresholds in terms of slope, and we took thresholds in terms of other things that allowed us to look at what was actually going to happen on these particular sites. Now, they fall within averages, so to pick a particular site and run a model right the way across it may well work out slightly different, but we assume that there are pluses and minuses within that.
So you did factor it in to a certain extent. Yeah.
Yes, but both the extent of slope and the impact on the costs, yes.
And just one other clarification at paragraph 3.2. I just think it's an incomplete sentence, so I just wondered what you were going to say.
Actually, what's happened, I saw this, sorry, I should have made this clear when it actually follows on. So 3.3 should be a non-capitalized T.
That's what
and
I
actually
wondered.
somebody's, what's happened there is we've dropped another paragraph number in there accidentally.
worries. Thank you.
Thank you.
Thank you.
Mr. McMahon?
Yes. I just want to follow up on that slope issue also, Mr. Osborne. So slope or topography, whatever you want to call it, it features in that 4 or 5 step process twice in your view, is that correct? At the beginning in terms of the enabled capacity? Is it?
There are impacts of slope on in terms of the urban edge model that discounted the theoretical potential on sites, and then there's for the feasibility there's an impact on cost. Now some of these are already seen in the average cost of construction in Wellington, which was obviously factored in. Some of these are unique to specific sites, where we tried to, in terms of geospatial extent of the capacity, we tried to include those rather than just general costs of construction.
And I appreciate your comment that these are averages. Understand that. Did slope feature as a cost on the QFM, that last step? Where qualify.
I don't think it was an identified QFM that was run. No, so slope was already considered in general at the high at those first numbers rather than as a QFM.
Okay. My final question is just on the numbers in terms of what you gave in your summary. The 31,000 demand assessment from Sense Partners, what date was that?
I believe it's subsequently been updated to 27, if I'm correct. There's been a further update. I think there's an update every 6 months. So it's sort of a bit hard to keep up at the moment, but I believe that was mid 2022.
Yes,
that was incorporated into the final reports.
Yes. I was frantically taking some notes. Did you also mention a 36,000?
That's the so the 31,000 is identified by Sense Partners. The just under 36,000 is with the NPS buffer that's required. A long-term buffer of 15%.
Yes. And bearing in mind that I just scraped through on school cert maths, is that surplus around 19,000? Is that what we're looking at?
You're looking at a surplus of around, with that buffer, you're looking at a surplus of about 15,000.
Based on the 36.
Based on the 36.
Yes. Yes. But humour me, that 19 with the 31.
That 19 is demand and supply. Yep. Yes. That's probably one of the key ones. Yes.
Okay. Thanks.
Nice question. A couple of questions. Clarification. Paragraph 2.6 of yours. The tail end of that paragraph, you say, as such, it's important that the district plan is still able to meet these demand levels under hardship development. What do you mean? How would it meet those demand levels?
It sort of relates really to what we talked about in terms of increased construction costs, decreasing a lot of the value that's been in New Zealand development over the last decade has been in the value of subdivision as opposed to the value of building houses. We see that probably explicitly in places like Queenstown, where there's a huge number of empty sections that are traded, and that's because the value is in just splitting up the land as opposed to building the houses. So in terms of that harsher conditions, that's really what I'm talking about. I'm talking about the fact that there's a movement away now from making excessive amounts of money in terms of land, and there's going to be more of a movement towards trying to make that money out of construction, even though construction costs are going up.
So how does the proposed district plan meet those demand levels? Just enabling greater development opportunities.
It enables, it's about, I mean, it sort of leads, I guess, to a bit of a conflict between the NPS and the amendment through the MDRS, where you're trying to get competitive product in and around centres and public transport networks and so forth, and at the same time the MDRS has sort of spread this capacity everywhere. So what the Wellington proposed district plan does is it bolsters the amount that you can get in and around those centres, so it's more competitive. And being more competitive, you can move away from your standard subdivision and actually get more value out of that uplift, out of that land value. And in doing that, it actually provides in those harsher conditions. What we've seen again over the last 10, 20 years is a lot more greenfield development, because that's where the value is. It's in subdividing up those properties as opposed to getting more of an uplift in and around more dense locations.
Thank you. Just one other question. You've answered some of my questions around slope and earthworks and things. And this may be a dangerous question, but that hasn't been mapped at all, is it? Where you can commercially realise development versus areas where it would be difficult to commercially realise.
It would be a dangerous thing to map in so far as we've talked about, we use averages. Where we can, we're using valuations for individual sites, impediments and constraints for individual sites, but we're dealing with average construction values, and we try and make those as relevant to the suburbs as possible. There's no point in saying, well, you can build a house in Oriental Bay for $2,000 a square metre and you're still going to get $3 million for it. Those sales values to construction still have to balance. Mapping based on that sort of has historically led to problems of people picking out specific areas and going, well, that's not feasible because of X, Y, and Z, even though it's based on an average for that particular suburb, based on as much individual site information as we have. So the answer is no, it hasn't been mapped.
Mr. Black, we pass.
Mr. Osborne, in your table 1, you have actually shown us the numbers in terms of the theory and the feasibility and the realisable, and the numbers that you have there for the proposed district plan. Do they take into consideration the qualifying matters in the areas where buildings cannot be built?
No, that first table is just dealing with feasible and realisable. It's actually not till later in my evidence that we take away the qualifying matters from 2.13 onwards. The actual qualifying matters are identified and their level of individual impact identified in table 3, and then the net or cumulative impact is identified in table 4, which then comes off those numbers still more. It's about just over 12,500, I believe, that comes off those numbers.
In that respect, in your paragraph 215, where we are talking about qualifying matters, these limiting factors, as you call them, have they been, the identified limiting factors, have they actually been taken out of the current operating district plan or out of the proposed district plan? Because as we know, there's, for example, natural hazard areas have changed in size, and special character areas have changed. That would all have an impact on your numbers. So where do those numbers?
So my understanding is, in terms of the information that we've been given both from Urban Edge and from Council, is those are the most up-to-date extent of those QFM as they're identified now. So they're taken off at the most current proposed. Yes.
Thank you.
Yep.
Mr. Faulkner. Just 2 quick questions. So My experience with models, and correct me if I'm wrong, is it's basically data in, something out. And there's a lot of models. Climate change is a great one where we continuously are behind the 8 ball with regards to what we're modeling. How do we make sure that the information that's in here is maintains its relevance during the life of the PDP? Is that a loaded question? So 40,000 today, what if it's 10,000 in 5 years' time? I mean, what's the not the usefulness, that's not the word I'm looking for. What's the applicability of it in a PDP environment?
So firstly, you're right. A model is only good as the inputs that you put into it. There is a requirement, obviously, for council to review information over a 3-year period, and we've provided council. We'll be providing council with this dynamic model where they can change simple things like interest rates. They can change whether there's been plan change put in place. So all those driving factors, and a lot of those factors are external to council's role. And they're market-driven factors, but they're really important factors. As we've noted, a 10% increase in construction and a 10% decrease in value has had quite a shift in what is feasible within the market, and it will continue to do so as the market finds its equilibrium again over the next couple of years.
Yeah, cool. Thank you. And my last question, Mr. Osborne, I know it's getting close to, well, it's past 5 o'clock now, and before you go, how much can you bench press?
No, that's just good question. Thanks.
Thank you, Mr. Chair.
Yes. That's it, Mr. Osborne. Thank you for your assistance. We appreciate that. Better get on your bike. Team, I wonder if we should go a little longer and hear from Ms. Hammond, and then come back fit and keen in the morning.
Unless there's any additional questions for me.
Like there may be. I want to cover that off now. Message from alongside that we need a 5-minute break. So we'll be back at 10 past. Yeah. Flights are full, isn't it?
Oh, he left in the half-day break. I think he was quite happy working. That's good.
There is still some. Did I say something?
Couldn't be.
Say something about.
Yeah, straight off.
Yeah, no, I thought I had a question. Oh, okay. Have you got a question? No. Oh, that's right. We didn't have that. I remember we. Let me just ask you.
Thanks very much.
Yeah. So it's just we got up till 10.
Sort of a question around.
Just I really want to.
But that's not. That's not.
No, you go.
Yeah, that's psychological, but someone doesn't.
All right.
Decided to go for a walk. Have you been sitting there for a while? How long have you been sitting there for? Well, it's really fine.
Okay, I just want to get a bit more. So that's kind of, if she's got to run, she's got to run.
Thank you for answering this question.
We could have at least, is he here? Oh, well, yeah, okay, we'll carry on and do a bit more for Adam. Yeah, okay, let's talk.
We should also. I'm not worried about that. I can do it.
Yeah.
Yes, exactly.
So we just carry on through the chapter.
Like, I think we'll roll for another half an hour. Half an hour.
There it comes.
Yeah. It wasn't a criticism.
Back on the go, change of plan. Ms. Hammond has to has other responsibilities. I think the plan, Mr. McCutcheon, is I think we'll spend half an hour trying to get as far into your section of the Section 42 area report, and we'll draw stumps at 20 to 6. 4.5. The I had a couple of questions about this. I know the submitters read the submissions focused on underutilisation in Adelaide Road, and you 397 you talk about car yards, obviously using large amounts of space to park cars. The NPS UD, of course, requires that business needs are accommodated as well as residential needs. So if all those car yards were shifted out of Kent Terrace, where in the business zones are they going to go?
Well, I don't even think it's a matter of if they move out, but how can they use the land more efficiently? And there are a number of examples of where car yards form part of multi-storey buildings. A car dealership, occupies 1 and 2 stories of a building. Johnson Ebbett on Taranaki Street is an example of that. There's been another one just move in, what is it? The new MG one on the corner of Vivian and Kent and Cambridge. I can never remember which one it is. But there is an opportunity to use land and still sell cars as a retail activity within a building that is different from what is there now, and achieve some housing on top of it.
That makes sense. Thank you.
I just had a follow-up to that one.
Commissioner?
That's in relation to car yards. What about other panel beaters, the car repairers, those things which people need, and need relatively close. Where's the anticipated areas for those, which require a bit of flat land, and not everybody wants to live next door to them either?
So we'll get into the utilisation of the mixed use and general industrial zones later in hearing streams, but primarily they are places where it would be a permitted activity to do such light industrial type activities and maintenance and repair. They're not out of the question that they could also occur within a centre zone, for example, by way of a resource consent process. So there's a variety of different business and commercial zones in the plan that do foresee this type of activity occurring.
Yes, but are they well located to where the high density potentially will be?
So these zones are located right across the urban area. There's some in, off the top of my head, in Lyell Bay, Tawa, bottom of Noronga Gorge, in Newtown as well. There is an area of mixed use zone just off near Constable Street, by Ridderford Street. But it has been there has been over the 20 years prior to where we are now, and even before that, a trend of Wellington losing its mixed use and industrial land out primarily to the Hutt, where it is flatter and there's less competition, closer to sort of bigger transport routes, the train line, main trunk line, both train and road. But the plan does recognise the benefits that these places provide for employment and their contribution to a well-functioning urban environment, and accordingly zones for them.
My other question was the 402, you cannot compel development, you can incentivise. The plan could impose minimum height limits. Have you considered that? I have to confess I haven't read the Section 32 analysis. I presume that was an option considered.
So of relevance is within the city centre zone. If new building is to take place, there's a standard which requires a minimum of 6 stories to be built. If a person owns a property, the council cannot compel them to go and demolish their house or their building that is there at the moment. But when
the existing use rights will prevail, so the answer is that there is a minimum, but you can't do anything with at a planning level with existing uses.
With respect to the city centre zone, yes, there is a minimum.
Any other questions on 4.5, people? Go to 4.6. Your analysis at 4.408 is the answer to that concern on the part of residents that your population studies are all overly inflated and that the whole thing's on an unsound premise? Mr. Osborne's answer that it'd be one thing if the mandatory rezonings required by the NPSUD were producing a deficit relative to demand, but ultimately, given his conclusion, they're producing a surplus. Are the population studies actually an academic issue?
I'll leave it to Mr. Lees tomorrow to talk to how he came to the population.
I'm not saying he's wrong, but in terms of the logic, is it on the critical path that we be satisfied on that the population estimates are sound?
What we do need to do is to meet the capacity that we are going to have, and plus a buffer, as Mr. Osborne has outlined. That's a requirement of the NPSUD. What we also need to do, and have no choice but to do, is to do policy 3, which we are doing, which is around walking catchments around the edge of the metro centres, city centre, rapid transit stops, and around local centres, all the other centre zones, and the MDRS. We have no option to do that, and we are doing that. that produces an amount of housing, which Mr. Osborne has shown is enough to cope for that population growth that we're expecting to have. So I would put that forward.
Was that a yes?
Yes.
That it is academic?
Yes.
Thank you. Sorry, it's late in the afternoon. Anything else on 4.6, people?
It's Zeppelin was later.
Like a black night. 4.7. 4.7.
Yeah.
4.8. Climate change and nature-based.
I just had a question, that one about regional council seeking objectives, policies and rules to address, sort of go wider than US to address the implementation of nature-based solutions. And your view is that it, or on the other ones, have methods specific to activities. Yeah, you consider the chapter addresses that? Any emissions that you would add?
So in my assessment, I identified that there are a number of provisions in the plan that in the first instance seek a nature-based response to an issue. So for natural hazard mitigation, is there a nature-based solution like planting or moving sand around rather than going straight to a seawall as the preferred option? It does do that. No other examples to my recollection were proffered by the regional council as to what they meant. Accordingly, I was unable to form any more of a view.
I just wondered if you had discussions with them or anything.
I have not.
No.
Affordable housing,
just one more. So in your para 430, under your assessment in the second to bottom line, you make the comment there that you consider the plan makes a significant contribution within the limitations of a document under the RMA. So you meaning there that you don't have the ability under the RMA to be more bold, or what do you mean by the under the RMA? But are there restrictions that stop you from doing any more with regards to what's been sought by submitters?
Well, certainly the RMA is not a do-it-all piece of legislation. Many submitters have offered options that the council could take up through this district plan, such as requiring the use of sustainable building materials or carbon zero building materials. And as an example, we cannot require that under a district plan. Section 18 of the Building Act doesn't allow us to do that. So that is an example of how we cannot do everything under the district plan under the RMA. What I've identified in my assessment is that one of the biggest contributions this plan can make in supporting a reduction in emissions is, like we've discussed today, having people live close to areas where they can walk and use public transport and other climate-friendly modes of getting around the city rather than a car.
Let me rephrase the question a little bit then. I understand that there is no ability to require things like building materials. Where things have been sought that are within the scope of being able to enable through the RMA, they have been considered and responded to. So I'm not talking about the things that there is no scope to do. The question I'm asking is, if someone has sought that we be bolder and it is within the scope of what we're allowed to do, that the RMA legislation is not an inhibitor to do that. Is that what am I safe to assume that?
So to rephrase the question, are you saying has the plan done all that it can to support a reduction in emissions? I think that based on what submitters have asked for, yes, the plan does prioritise emissions reduction in response to Amos Mann and Anna Jackson. We have a strategic direction around sustainability, resilience and climate change. Grant Buchan identifies that one of the greatest drivers of carbon emissions is in relation to private car use. Well, as we've had a discussion at length today about how the plan seeks to resolve that. climate change, including response to natural hazards, was something that the Regional Council, supported by Forest and Bird, seeks, and that's certainly a big focus of this district plan. Ben Barrett seeks that the plan will support a low embodied emission and high building performance. Well, I've outlined just before about how unfortunately that's not possible for us to do. So on balance, yes, I do think this plan is pushing out the climate friendly boat as far as we can and delivering on Te Atakura, the Council's climate strategy.
Good point, thank you.
Follow up on that. Of course, we have some large institutional submissions in the form of Kaingora and Wakatahi, who are suggesting that the council could do more by adopting a larger walkable catchment. Now, this isn't trespassing into Mr. Wharton's sphere. He's explained very clearly why they've done what they've done. Is there a climate change response to that, which is that if you spread the net too far beyond the area that people will actually walk, you just encourage more car use?
I think this picks up on some of the cross-examination which Mr. Wharton was having before around if you zone for greater development, does that mean people are inherently going to own cars anyway and not use public transport? I cannot speak for the motivations of individual people, but the assignment of walking catchments and the recommendations that have been made have been centred on our direction from the NPS to achieve a well-functioning urban environment and intensify near places where people do have access to public transport and services. And consistent with that, that's why we have recommended, or Mr. Wharton has recommended, a variety of different walking catchments commensurate to those amenities rather than just 6 stories everywhere, which I know some submitters have asked for.
And there's a lot of, I don't want to decry the reasoning, but it's very much the more the better. Is there a contrary argument that more high density is not necessarily consistent, for instance, with climate change?
I think there is an argument that if you are enabling a great deal of density in places where people don't have access to public transport and climate-friendly ways of getting around, then they will be left with no other option than to use a car to get around, which is why a big focus of assigning increased density in this plan has been zoning to enable people to use public transport.
Right, I think we're on to affordable housing 4.9, Commissioner Black.
Yes. A lot of the issues that were raised in this were actually things that you're looking at that are outside the district plan, so the mechanisms to achieve it, not necessarily regulatory through the district plan. But you did say that there was a chapter on affordable housing in there, and there is a definition of assisted housing. So a couple of things. I was wondering, is just having a definition sufficient with provisions that relate to that sufficient, or does it need a chapter? And what was in the chapter that went out? And what would you put in? And because the question is sort of to us is, well, if you think that you should put it in, you can. But what will go in it? So.
Well, thankfully we have the author of that chapter as it was in the draft district plan, just to quickly respond to what is the utility of having a definition and how does the plan address it at present. So yes, council did make a decision to remove the assisted housing chapter from the plan, and Mr. Wharton can speak to its detail. But what they did retain within the notified PDP was the definition, references to that type of housing within the strategic direction, and most importantly within the mechanism you will discuss in stream 4, the city outcomes contribution, where there are essentially density bonuses offered to developers when they are demonstrating they are contributing back to the city, be that through public open space as one mechanism, or assisted housing, which there is an identified need for. I'll hand over to Mr. Wharton to speak to the sub.
Maybe I'll put ratio bones that we listed here.
Not public art.
Public art. All residential used to be a bonus too on the top floor.
Till they pulled it in.
Yes, it's it turned into the boardroom.
Very briefly, panel. The council strongly supports affordable housing and methods to achieve it, and have a variety of actions to try and increase affordable housing. They did request staff look at mandatory forms of requiring affordable housing or assisted housing, which is a component of that. For the plan, the council decided to forego the mandatory component, so inclusionary zoning, some people call it inclusionary housing, but to keep the voluntary part through bonuses or incentives, and instead to retain the idea of creating a fund to support assisted housing, but instead to do it through some other means through the rating review. So be it some sort of targeted rate or a overall rate or something else. So that was the method they decided to use.
But that was the chapter that was taken out. Was that it? Was it sort of brought it all together?
It was yes, it was a generally self-contained chapter focused on the inclusionary housing mandatory components, because I knew that being quite contentious and would be quite groundbreaking, it was siloed to an extent. So the chapter could be removed, but still retain the voluntary methods within the relevant sections of the rest of the plan.
When you say mandatory, what was mandatory?
So areas that have had significant upzoning would have to would have to either give enable a certain, I think it was about 10% of their housing as assisted housing, meaning that it would need to be managed by an agency as long-term affordable, or alternatively give a financial contribution to be used in a contestable fund for agencies to develop into affordable housing.
Can I just follow up too? Was there a report that went to council to make a recommendation on this?
Yes.
23rd of June meeting. So the recommendation was to remove it.
Yes.
It
was it was council's decision, because it was council's request to present these options initially, and they wanted to investigate it, and they did, and decided not to go with the mandatory option in the district plan.
What I'm thinking of is you put it back to us. Should we be able to view that, etc. And I'm just thinking, well, what have we got to information have we got to make that evaluation and judgment?
I mean, to make that call, it would be advice from Mr. Wharton, largely around whether he thought that the district plan was a mechanism which was appropriate to do so. I mean, we have established that it is possible to do this. Council has doubts, or the council last training had doubts as to whether this was the most appropriate and effective way to do it, and have accordingly asked us to come back with options about other mechanisms, not ruling out that they don't decide to come back and introduce, by way of a plan change off their own accord, a chapter on assisted housing.
I wonder if the way forward is to provide the panel with a copy of the report that went.
So there is a very detailed Section 32 analysis that Mr. Wharton.
Yes, that's the next thing I suspected.
Yeah.
That there were chapter and verse. So can you give us some references that we can go look at that, please, Mr. Wharton?
So all of the Section 32 analysis, including this one here, are under the what's in the proposed district plan page, and then they have their own page, Section 32 reports. And to clarify, there was not a specific recommendation that went to council on the 23rd of June to remove that chapter, and that wasn't addressed any specific way differently to other chapters of the plan. They made that call during, well, there was a motion that was raised by a councillor and seconded by another, and it was removed through that process, not from officers' advice.
Is it, just on the term assisted housing, it's often used in another way, that it is actually housing that comes with support services. I don't know if you took that, because that's how I thought there's a difference here between affordable and assisted, because that's how I understand assisted housing. But you've obviously done some work on that and decided that that was a term because it's ambiguous.
Yes, there's a lot of different opinions on which term to use. We didn't just want to use affordable housing as a general term because that's generally like just housing that is affordable but may not be once market conditions change. Just because housing is in poor condition or is small or is in a certain location, the council wanted it to be clear that this was something that was below market rate, that was retained affordable long term. I think Queenstown is using the term retained affordable, which was another option.
What was it?
Retained affordable, I think they're saying. Yeah, rather than just affordable. The term assisted is because there would be an organisation actually managing that housing, whether that's be leasehold or rent to buy or like some sort of buyback mechanism or just subsidised rentals. There's lots of different ways it could become affordable, but the key principle underneath them all is that it's an assistance from some other entity, whether that be public or private.
I understand
to keep it affordable.
It's a bit loaded term too, isn't it? Because it's open to so much.
It was too broad for what the council wanted to do.
Yeah, it's just that assisted does have usually associated with
Yes.
support services.
There are lots of houses that are in Queenstown that are affordable to American billionaires. It's all who you are and how big your wallet, Commissioner.
Yeah, I'm not sure who this question is, maybe Mr. Cutten, but aren't we really punching at shadows here? And I mean, whilst some submitters have talked about affordable housing or assisted housing, no one has suggested specific provisions of what that chapter might look like, based on my understanding of your paragraphs in 4.9. So whilst even if we were of a view that that was a good idea, just based on public fairness, I mean, no one's had an opportunity to further submit on what those provisions might or might not be. Is that your view?
Yeah, certainly my recommendation is that we don't
Yes.
amend this plan right now to reintroduce a chapter of the plan that was in the draft.
Yeah, so at the moment we've got a strategic objective that mentions affordable housing. That objective can be given effect through outside the district plan through council's own initiatives. And in a more of a carrot sense, there's some bonuses that can be achieved through the provision of affordable housing through the rule provisions.
Correct.
But that's as far as it is. If there was something to be more specific, it would need a first scheduled process, whether a plan change or a variation.
Correct. And for that reason, I subsequently recommend retaining the definition as notified.
Yes. Yeah. Thank you.
Commissioner Dash, you had a question?
Probably 2 years ago, I dealt with a resource consent, limited notified resource consent for Kāinga development in Newtown. And the officers at the time had recommended a restrictive condition that it had to remain in public ownership, but on the pretense that it had a shortfall of car parking, and the car parking standards have been removed. With the current provisions that you have in the district plan, is that a likely scenario that if a resource consent is required, then such a restriction could be sought?
I would not imagine so.
We had to get some legal advice on it, and I think it was found that, and KO were just really opposed to it. But my understanding was that under the plan at that time, under the operative plan, it was, there was some virus issues with it.
The only time I can imagine that might arise would be if a city outcomes contribution offered was the provision of assisted housing, and to ensure that that it was implemented as such, and there was assisted housing that was actually built and it wasn't just flicked off to the market a year after it was built. In that case, I could imagine, but more generally, where that was not triggered, I would be surprised.
I think the next area is Papakāinga, but speaking personally, I think I've had enough for the day. So we'll say draw stumps. Thank you for your contribution, particularly Mr. Warden, who's had a long day, or certainly a long afternoon. We'll adjourn proceedings for the day, back at 9 AM tomorrow, starting at paragraph 4.10. What's this? Yeah, well, and yeah, those boys are down that seat.